Good morning, everyone. Yes, good morning. Welcome to the sixth hearing of the Portfolio Committee Number 1, Premier and Finance, for the additional round of the inquiry into budget estimates 2023-2024. Firstly, I would like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Jeremy Buckingham and I am the chair of this committee. I welcome again Minister Houssos and accompanying officials to this hearing. Today the committee will examine the proposed expenditure for the portfolios of finance, domestic manufacturing and government procurement and natural resources. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome again and thank you for making the time to give evidence. Minister, I remind you that you do not need to be sworn as you have already sworn an oath to your office as a Member of Parliament. We only have one witness to swear today, Mr Johnson. Could you please state your name and position title and swear either an oath or affirmation?
Scott Johnston, Chief Commissioner of State Revenue and Commissioner of Fines Administration. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you, Mr Johnston. I remind all other witnesses here today that you do not need to be sworn as you've been sworn at an earlier budget estimates hearing before this committee. Today's hearing will be conducted from 9:15am till 5:30pm. We are joined by the Minister for the morning session from 9:15am to 1pm with a 15-minute break at 11am. In the afternoon, we'll hear from departmental witnesses from 2pm to 5:30pm with a 15-minute break at 3:30pm. During these sessions, there will be questions from the opposition and crossbench members only, and then 15 minutes allocated for government questions at 10:45am, 12:45pm and 5:15pm. We will begin with questions from the opposition.
Thank you, Chair. Good morning, Minister.
Good morning, Mr Tudor.
Minister, on the 12th of September 2023, you made a reference to the Social Issues Committee for an inquiry into procurement in New South Wales. Do you recall doing that?
Yes, I do.
And it included terms of reference for the inquiry, which you asked the committee to inquire into. Is that correct?
Yes.
And that referral, in fact, said, if I can just get the precise terms, it's paragraph G. The New South Wales Government procurement practices, in particular its ability to prioritise local content, local manufacturing and local jobs, improve opportunities for quality training and workforce participation, provide opportunities for diversity, inclusion and the participation of disadvantaged groups, including women and minorities, and then the last one was support local suppliers and small and medium enterprises. You recall that those were a component of the terms of reference to the Social Issues Committee.
I broadly recall those.
In relation to that terms of reference, how do you understand the definition of local?
Well, thank you, Mr Tudor, for the question. This was something that we went to the election with, and we said that we would introduce local content requirements. Now, I understand that you asked Minister Chanthavong about this during the previous budget estimates hearing.
I didn't. Someone else may have, but I didn't.
Okay, then someone from the opposition asked him questions in relation to that.
So, how do you define local? It's your terms of reference.
Yeah.
For the purposes of the referral to the committee, what's your definition of local?
Yeah, so in terms of what local means, broadly that's considered to be within Australia, but this is a complex area of policy that needs to be developed, and that's why I asked Dr Kane to conduct this particular inquiry. I'm really looking forward to the recommendations from that inquiry and responding to them appropriately.
So you don't have a specific definition, because I think when the Jobs New South Wales legislation was introduced by the Labor Party in the term of the previous government. Local jobs was defined as Australia and New Zealand. Is that right?
Yeah, that's correct.
Would that accord with your view then?
Look, like I said, we haven't landed exactly what that definition will be. That would, of course, be, I would expect to be part of the recommendations and some of the considerations that Dr. Kane will consider as part of that inquiry. This is something that requires close and diligent work, and I think that it's the perfect place for an upper house inquiry.
So, in terms of the policy then that you took to the election, you did have a commitment that you did take to the election. What commitments do you say that you took to the election as requiring local content?
Yeah, so we committed that we would increase tender weightings for projects to 30% to capture local content, job creation, small business and ethical supply chains. We made a number of election commitments in relation to procurement around local content, around tender weightings, around establishing a Jobs First Commission, and that is what we are absolutely committed to delivering for the people of New South Wales.
But there was only one specific local commitment that you did make in relation to local manufacturing, was there not?
I'm sorry, what are you referring to, Mr.
Was
Chair?
there only one specific policy you took to the election in relation to local manufacturing? Was there not, that you took to the Parliamentary Budget Office?
Well, it sounds as though you have a new question for me, Mr. Chair.
Well, I do. Did you take a specific local manufacturing policy to the election?
The election commitments that we took were that we were committed to increasing tender weightings for projects to 30%.
Well, didn't you take a specific provision in relation to the replacement of rolling stock?
Yes, we said that we would have 50% minimum local content for future rolling stock.
Okay, so that was one of the requests you made, that it will be for the purposes of that rolling stock. Do you understand that that local component was New South Wales, Australia or New Zealand?
Well, I mean...
When you took it to the election as a commitment, where did you take the view that that commitment would be fulfilled from?
Yeah, so Mr. Tudor-Hope, the Labor Party took that to that commitment to the election. Now, you would be aware that I was not in this particular portfolio at that time. So as the Minister, am working through how we implement those election commitments, I have asked the Upper House inquiry to consider that. Now, it may be, as Minister Chanthavong said at last year's budget estimates, that the industry expectation is that it would be Australia and New Zealand. But let's be really clear about why we took that election commitment.
No, I'm not asking you that,
No,
Minister.
well, you've asked me a question and now I'm providing you with an answer.
Well, no, I'll redirect you then.
You might not like the answer, Mr. Tudor-Hope,
I didn't ask you why you took the policy to the election. I asked you where you were going to get the local content from. Now, where do you say that local content in relation to the commitment for 50% rolling stock will come from?
Well, Mr. Tudor-Hope, I think it's useful to understand. You've asked me what was the policy that we took to the election. The reason why we took that policy
I didn't ask you the reason why, Minister. I asked you where it would come from.
Well, Mr. Tudor-Hope, you get to ask the questions and I get to provide the
Well, I will
answers.
redirect you then, Minister, in relation to it. Where did you get it?
Point of order's been taken, Mr. Namber.
Chair, it's not courteous to the witness to prevent her from answering a question in a legitimate way and in a way that the opposition may not want to hear. The Minister's answer was relevant, and I just asked that courtesy be extended to her under paragraph 19 of the Procedural Fairness Resolution.
Yeah, sure. It's helpful to the inquiry to have less interjections. The Minister should be relevant in her answer and can answer as she sees fit. But Mr. Tudor is free to continue asking the questions he wants to.
Thank you, Chair. Minister, I take it you're aware of the functions of the Independent Commission Against Corruption, are you not?
Yes.
And one of those functions, as set out in the Act, is this: to instruct, advise and assist public authorities on ways in which corrupt conduct may be eliminated, the likelihood of corrupt conduct reduced, and the integrity and good repute of public administration promoted. You'd be aware that that is one of the statutory functions of the ICAC.
Yes.
Minister, you'd take seriously in those circumstances, would you not, a warning from the ICAC in relation to proposed policies which, if implemented, would be likely to increase rather than reduce corruption?
Yes,
You'd take that seriously?
absolutely.
So, Minister, have you read any of the 32 submissions that have been received by the Social Issues Committee for its procurement policy inquiry?
No, I haven't read any of the specific submissions yet. My understanding is that the submissions to that inquiry closed last week. Now, I would certainly expect that I will be following the work of that committee closely, but I have not read every single submission in the last 6 days. I think you said there was 32 that were made. I do trust that the committee, particularly under the leadership of Dr. Kane, will come up with a very considered and thoughtful report, and I look forward to responding to it. That's exactly why I wrote to Dr. Kane in the first place. This is an important policy issue, and I look forward to responding to those recommendations in time.
Well, let me help you. One of these submissions, in fact, is a submission, and it's number 18, from the Independent Commission Against Corruption, and it was lodged on the 18th of January 2024, and you have accepted that you haven't read it. One of the submissions made by the ICAC in its submission was that local content scheme would create unnecessary lobbying risks whereby parliamentarians or councillors are approached to support their local businesses. What do you say in answer to that submission by the ICAC?
A point of order has been taken. Mr. Lawrence on a point of order.
I just wonder whether, as a matter of procedural fairness, the witness could be provided with a copy of the submission, so that if she needs to refer to it in order to answer the questions, she can do so.
Tabled on the Parliament's
I
website.
assume Mr. Tudor has brought copies of it.
publicly
given that
already
it's
been
got
provided.
questions that he's clearly reading
submissions,
out, so it must be ready.
just for clarity, the submissions have been published?
Yes,
Okay.
It's on
it's
the
on the
website.
website.
It's on the
You
website.
can Google it.
Yeah, but it doesn't mean it's here today.
Doesn't mean it's here
I reckon
today,
there's a
but
device up there that you can find it.
if Mr. Tudor Hope wants to table the document so that the minister can
I've
refer
asked
to
a
it.
specific question in relation to it.
Sorry, can you ask the question again?
Well, how do you respond to the ICA submission that a local content scheme would create unnecessary lobbying risks whereby parliamentarians or councillors are approached to support their local businesses?
So, of course, I would take any submission from the Independent Commission Against Corruption seriously, and I would expect that the parliamentary inquiry would take that submission seriously. And I look forward to making a government's response to the recommendation from the inquiry when it fits. It's absolutely fitting. I've been a member of a large number of parliamentary inquiries where the ICAC has made submissions and provided thoughtful and considered advice as part of that, and I think it's only appropriate that they would do that again.
Well, given this was your reference to the Social Issues Committee, wouldn't you have thought it important to be following the submissions which have been made because you're the minister responsible for domestic manufacturing and procurement?
Yeah, of course I will follow.
So 18th of January till today, the 7th of March, you or no one in your office has read the submission from the ICAC lodged on the 18th of January in relation to the
Point of order has been
reference to the
taken.
procurement
Lawrence, on a
committee.
point of order.
Suggest that that is not a question. It's extremely thinly veiled criticism and
no,
not in the nature of our task.
Well, I'm not going to uphold the point of order. I think it was both, which is very clever of Mr. Tudor Hope, but there was a question there, so I'm not holding.
So no one has in fact read it.
Well, Mr. Tudhope, no, that you're verbally me now. You're
Well,
saying that.
you've told me you haven't read it.
No, that's true.
Point of order, Chair.
A point of order has been taken. Dr. Kane, on
A
a
bit of
point of order.
defence.
According to the guidelines on budget estimates hearings, I understand that we shouldn't be considering the proceedings in other committees, and while you're allowed to cover the general area, this is getting very specifically to submissions that haven't yet been considered by the committee, and I don't think it's appropriate that they be canvassed here before we've even had a chance to deal with them appropriately in committee.
Well, to the point of order, Chair, this is talking about one of the government's signature policies in the lead up to the election, and indeed now under the control of this minister. It's about local content and procurement. It's entirely within order to ask about that at budget
Further
estimates.
to the point of order.
Dr. Cannon, point of order.
Yes. As I did say in my first point of order, the general topic, of course, is well within the scope of the hearing. The actual particulars of submissions to an inquiry that we are yet to consider are not within that scope.
Chair, it may assess
If it, yes.
that there is a Clerk's Memorandum of the 20th of June 2001, advice regarding questions in budget estimates with respect to committees, other terms of reference and the content of questions.
Well, it's
Well,
pretty
no, no.
You've got a
clear.
copy of that with you there, Bob?
It's very.
We've all got
I was
standing orders
unaware,
about
and if that is the
Well,
advice
no.
from
Well, to that point of order, though, these are questions going in relation to not to the findings of the committee or the evidence being canvassed by the committee. This is a submission made to the committee by the ICAC. This minister is now saying she doesn't know about, and it is relevant
It is
to the.
evidence.
It is relevant to the manner in which she conducts her portfolio.
Absolutely.
Yes, it may be relevant, but if there's been a determination that's in the guidelines, if you could move on to some other
Yeah, well,
questions,
yeah,
Mr.
thank you.
Tudor, I'll get some advice from the Secretariat. If those could be brought
So-
to my attention,
so,
and I'll
Minister-
make a ruling.
How do you respond?
Minister, the ICAC goes on to say that the local content scheme, which you are an advocate of, could be used to mask a conflict of interest between a local supplier and an agency decision
Point
maker.
of order, Chair.
Yeah, Dr. Kane on a point of order.
You've just asked that that line of questioning is ceased until such time as you've sought advice from the Secretariat, and Mr Tudor Hope has
But
clearly
this
flouted
is-
that ruling and
to the
asked the
point of
same
order, this
question.
is
Oh,
to
order,
the way in
order.
which she administers her portfolio.
Yeah.
Yes, I understand that, Mr. Tudor Hope,
fucking
but there has been a point of order raised, which I am getting some advice on, as to whether or not that line of questioning fits within the resolution of in terms of procedural fairness, and whether or not the activities of another committee can be subject to inquiry by this committee. So I'm not ruling it out at the moment. I'm just getting.
Well,
some
let me
advice.
ask it in a different way then, Minister. If in fact the ICAC had concerns in relation to local content schemes, would you be concerned about that? And I think your answer earlier was yes. And if they had concerns...
A point of order has been taken. Mr.
But now you
Lawrence
can't
on a
ask
point
anything.
of order.
I would suggest that Mr Tudor Hope is not able to get around what you have said, Chair, in terms of deferring that question by a rhetorical device of putting something in the hypothetical. He's clearly flouting your ruling, and he should move on to a different topic,
No.
and then he can
No,
return to
no,
this
no,
topic
I-
after
We
the
get to
ruling.
decide.
It's a transparent flouting of,
Can I,
of what's
to
occurred.
the point of order, Chair, there have been other hearings held in this budget estimates period where questions have been asked about topics that are currently being considered by committees. One example would be the treatment of students with disability in education. We have a current inquiry happening in our portfolio committee for that. There were questions put to the Education Minister about that. If what the government are trying to do is say that any particular committee subject is off limits for a budget estimates hearing, that is a farce of the highest order. We are allowed to ask questions about government policy. This is a key government policy under the responsibility of this minister.
To the
Further
point
to
of
the
order.
point of order.
Well,
Hold on. Yes, just Mr. Lawrence, yes.
That's fine, and that might be right. But as I understood your ruling, you had asked Mr Tudor Hope to defer this questioning until you rule. And it might be that Ms Mitchell is correct, but I think Mr Tudor Hope should comply with what was in effect a ruling.
Yes.
And just defer
Well,
his
well,
questioning. I'm sure he's got lots of other things, and then we can return to
We're
it after.
Well,
Interested in this one.
I've read to provide some clarity. I've read the rules governing questions, and it does say that questions asked during the budget estimates hearing should not attempt to debate the unreported proceedings of other current committee inquiries.
and I'm not doing that.
Well, I think you are.
And, well, with respect,
The-
Chair,
the- I think
I'm
you are,
asking,
Mr.
I'm
Chair.
asking
Read that
the
again.
Could you read
minister.
Order. You are asking about a specific submission about whether or not the minister has read it, whether or not her agencies have read it, her
Well, I'll
officials.
withdraw those questions.
And so, just to be clear, the rule, the governing area, the 4.5 says they should not attempt to debate the unreported proceedings of other current committee inquiries, and I would put that those submissions are the proceedings of those unreported inquiries. So the questions that may have been the practice previously, but
I think you're getting some advice, Chair.
I am getting some advice.
Well, this has taken up a fair bit of time. You'd be happy about that.
I'm happy to answer your questions, Mr.
I'm sure it
Tudor-Hope.
will.
Well, now you know that ICAC have got concerns.
Now that
What
you
do
know
think
that
about
ICAC
it?
have concerns.
There you go. There's a
Why is it
solution.
not caught by this?
And submissions, by the way, aren't proceedings.
You've just set up inquiries into things you don't want to talk about.
Okay.
That's not what
Well, look, yes,
this
I've
is
just
a
had some
reported
advice.
proceeding.
Thank you. Proceedings. I've had some advice from the Secretariat. Proceedings are do not capture submissions.
Thank you.
Chair.
So the
Thank you,
questions.
Chair.
You just have to wait for the ruling.
Thank you, Chair.
So the questions are in order.
Minister, if in fact the ICAC in its submission says this, that local content schemes could be used to mask a conflict of interest between a local supplier and an agency decision maker, would you have concern in relation to that particular observation?
So, Mr. Tudor-Hope, this is a submission that is made to a parliamentary inquiry that is important
I'm asking
on a
you
large
to
and
answer that
well,
question.
you can ask me a
Order, Mr.
question,
Chair.
and
I'm
I
asking
can
you to
provide
answer that
you with an
question.
answer. You can be courteous enough to listen to my response.
Just answer the question, Minister, that'll be helpful.
Well, you get to ask the questions, and I
Would you
get
be
to provide
concerned,
the
Minister,
answers. Well,
would you be concerned, Minister, to respond to
you
ICAC's
can continue to
advice?
speak over me. for
To
the next
ICAC's
3
advice that
hours.
local content schemes potentially sacrifice value for money by limiting competition and may prevent access to new products and innovative solutions. Would you be concerned about that observation made by the ICAC in its submission?
Well, as I was saying before you interrupted me, that this is an important and complex public policy area. And that is why I asked Dr. Kane's committee to take a deep look into this. These are important concerns that are raised by ICAC, but I'm not going to preempt the committee's work. I expect that they will come back with a considered and careful response to how to mitigate these risks and provide a way forward.
Well,
But let's be clear,
but let
Mr.
me just say in
Tudor-Hope, we
relation
are
to that,
not
Minister-
first
Order,
movers here.
order, Mr.
If you
Tudor-Hope.
look to Victoria, if you look to Queensland, if you look
if
to
you look-
Western
thank you,
Australia,
Minister.
they all have local content policies in place.
Well,
This
Minister,
is
why
not
don't you have said this?
something. This is not
we lost a lot of
something.
time previously.
This is
so I
not
need to
something
to ask you this.
that is
Got limited
new.
On the 18th
But
of
what I
January,
have done
I've
is
got limited
ask
time,
the
Chair.
parliamentary
Well,
inquiry.
order. You've got a
On-
lot of time,
on-
Mr.
on
Tudor-Hope,
the
because there's a lot
On
of
the
other
18th of
sessions.
January, the ICAC made its submission discouraging the use of local content scheme. On the 22nd of February 2024, you reaffirmed that a Minns government had an intention to establish a local content requirement. You weren't waiting for the committee to report about the complex issues. You were saying on the 22nd of February you were committed to doing it. No qualifications. Your press release said committed to doing it. No
Don't,
Chair,
don't
I don't-
verbal me,
qualifications.
Mr.
Point of
Tudor-Hope.
order.
Don't
I'm
verbal
reading-
me.
I'm
What
reading
I
your
have
press
said,
release.
what I have
Order,
said,
order.
Your press
let me be
release.
clear.
Order. Sorry, a point of order has been
Your
taken.
press
Mr.
release,
Nanba.
Minister.
I'll hear the point of order.
Thank you, Chair. I don't believe that there was a question attached to that. It did seem to me
He was
that it
getting
was a
to it.
statement
Tirade, he was
and
getting to
an
it.
I got to the
inference
question.
and an imputation. And while
How's it an imputation
while the
when
House
they
procedure is while House procedures are a guide, I would suggest that Mr. Tudor-Hope has well and truly exceeded the latitude that's afforded to the questioning that
To
can
the point
take
of
place
order,
in budget
unlike-
estimates.
To the point of order, unlike question time, the opposition is free to ask questions that may include some degree of argument or imputations as a statement, so long as it is followed by a question. And I think that point of order was taken before Mr. Tudor-Hope had indeed finished his line of
Imputations.
questioning.
So, Minister,
Well,
why are you
that may be
ignoring
the case,
ICAC's
Mr.
advice?
Tudor-Hope, but by the time your time had expired, had not been a question. So I uphold the point of order, and we'll ask some questions myself. Minister, I'm going to ask some questions on behalf of the Redfern Legal Centre, and there's a little bit of a preamble at the beginning here. In a case brought by the Redfern Legal Centre in the New South Wales Supreme Court, Justice Fagan confirmed the, and I quote, bare minimum, end quote, validity test for COVID fines outlined in the previous COVID fines judgment of Justice Yaya, Beam, Ells versus Commissioner of Police, New South Wales SC 347. The bare minimum test demands that for a penalty notice to be valid, it must clearly state the relevant act and provision relating to the offence, enabling individuals to understand the offence they are accused of committing. Following the judgment, Revenue New South Wales refunded 33,000 COVID penalty notices. There was then a second court case brought by Redfern Legal Centre in the Supreme Court, which dealt with the remaining 29,000 COVID fines. This was similarly upheld. We now have two judgments that confirm that penalty notices must act to meet the bare minimum validity test. That is to say that each penalty notice must have the act or regulation that was allegedly breached. The question concerns the remaining 29,000 penalty notices covered by the second case that have not yet been repaid. Minister, will you, as the Minister responsible for Revenue New South Wales, ensure that the Commissioner of Fines honours these two New South Wales Supreme Court judgments and withdraws and refunds all monies paid for the remaining 29,000 COVID fines that have not been withdrawn?
So thank you, Mr. Buckingham. That's a really important question, and I note that it's on behalf of the Redfern Legal Centre. This is a very complex area of law. I'm seeing nodding from the Honourable Stephen Lawrence over here.
I've done a few cases.
I'll acknowledge that. This is a really important issue. It obviously predates my time as Minister in terms of the actual issuing of fines, so I'd just make that point at the outset. The other important point to just note is that I actually have no ministerial authority or discretion to withdraw those fines. That rests with the Chief Commissioner. So I think perhaps it might be helpful for him and perhaps Mr. Smythe to just talk through this. Like I say, this is a very highly nuanced legal scenario that they have certainly been briefing me on since my very first days as Minister, because this is something that did occur under the previous government. But I think they're best placed to actually give you a considered response.
Sure. Mr. Johnson.
Mr. Buckingham, I might ask Mr. Smythe just to, because I think there's a few points in the question around the facts that I think it'd be worth giving our perspective to that, and then I can talk a bit more about where we're at.
Sure.
Yes. Thanks, Mr. Chair. Principally around the second decision, which was, I believe, the one being referred to is Koshulek versus the two commissioners, the Commissioner of Police and Commissioner of Fines Administration. It was in relation to a slightly different issue to the matter that was dealt with in Beam and Ells, or at least the decision of the Supreme Court was. While it did deal with a COVID fine, the question there was whether or not the court should make a particular declaration, and because the matter had been dealt with on other grounds by the Commissioner of Fines Administration and had in fact been withdrawn, the Supreme Court declined to make the declaration requested by Redfern Legal Centre. That's all the time.
Yeah, no, thank you. So, at the end of those two matters, it is correct. After the first hearing, I withdrew vicinity of 33,000 fines that were of a similar nature to those that were before the Supreme Court. From that period till today, we've continued to review and treat every matter on a case-by-case basis, and are comfortable with that position and continue to. My view from that second hearing, as Mr. Smythe explained, was that hasn't materially changed the position because it was of a different nature, and it wasn't the outcome of that hearing didn't give a reflection on 29,000 fines. It spoke to one matter that we dealt with in different context, because around the facts of that case.
And so, because of that, because there's a different context and different cases, your position is that you will not be refunding those fines. There's no necessity to.
That's correct.
Okay. All right. Thank you very much. Oh, one other one. Sorry. Could you take this question on notice and provide the following statistic? Out of the 61 categories of COVID penalty notices generated by Revenue New South Wales, how many contain on the penalty notice in writing the Section 10 Public Health Act? If you take that on notice.
Okay. But a point of clarification, Revenue New South Wales doesn't issue the fines. They're done by other authorities, but primarily in COVID fines police.
Okay. Well, maybe I'll ask that on notice to them. Thank you. Minister, could you update the committee on where the government's future jobs and investment authorities are up to in terms of populating the authorities and potentially engaging with some of those 4 mining regions and getting some of that money out the door, as the Treasurer likes to say, in the light of the recent closure of some of the coal mines, Russell Vale and Werris Creek. Could you update the committee in that regard?
Yeah, certainly, Mr. Buckingham, and that's an excellent question, and I know that it's one that you and I have discussed at length. The work of the Future Jobs and Investment Authorities is certainly well underway. I think I reported at the last budget estimates that I had gone up to the Hunter and held a round table up there. Since then, I've been to Lithgow and held a round table. I know that you're a great supporter of their LEAP program there. And later this month, I will be heading to the Illawarra to hold a similar round table with the community. And again, I'll be headed up to the northwest to consult directly with the community. What I can tell you since the last budget estimates is I've instructed the Department of Regional New South Wales to establish a dedicated unit that will support the delivery of the authorities, while we work through the process with the local community about what the structure should look like and the format of those particular authorities and how they can best use the convening power of government to plan for a post-coal mining future for these regions. We're stepping up that public service capability to make sure that they are ready to get going once we've worked with the communities to come to that decision.
Okay, so to be clear, you've established a dedicated unit to help populate those authorities. What's are there any timelines for when communities can expect to see those authorities up and populated and consulting with their communities?
Yeah, so I mean, in terms of a timeline that I can give you, like I say, I'll be travelling to the Illawarra later this month and up to the northwest in coming months to meet with the communities directly. We made an election commitment that we would have 4 local authorities, and the actual structure of those we're working through. The other key timing factor for us is the establishment of the federal net zero authority. Now that legislation I understand it hasn't passed the federal parliament. They've set that authority up within the Department of Prime Minister and Cabinet, and we're certainly having discussions at a departmental level with the federal government about how we can work together, because we want to make sure that there's no needless duplication. The federal government will have particular expertise, and need I flag some funding that might be available for these particular regions that we'll be able to partner with them on. But perhaps Ms Beattie might be able to provide a little bit more information about how we're working in partnership with the federal government about the creation of these local authorities.
Thank you, Minister. As the Minister said, the Australian Government has committed to legislate the National Net Zero Economy Authority, but in the meantime they've set up a unit within the Department of Premier and Cabinet, the Net Zero Economy Agency, Prime Minister and Cabinet, to establish that statutory authority. So we are in regular discussions with the Commonwealth Government about what that will look like as they develop their legislation. And as the Minister said, we are working very closely with them to make sure that the New South Wales coal-reliant regions, and the 4 of those in New South Wales, are adequately understood by the Commonwealth Government to make sure that we can support coal workers in those regions and support those economies into the future.
Mr. Buckingham, let me just say this in closing. We have one chance to get this right. We want to partner with communities to make sure that we have authorities that are fit for purpose for the future.
Okay, thank you. Minister, you'd be aware that there has been a case, a successful case an appeal brought by the Gomeroi Nation regarding the Native Title Tribunal decision to approve licences attached to the Narrabri gas project. What's the government's response? I know it's it's only happened in the last day or two. What's the government's response to that decision, and what are the implications for the Narrabri gas project from that?
Yeah, so I'm certainly aware of the decision. It was handed down late yesterday, I think at about 5 p.m, so which upheld the appeal. The state is a party to the proceedings, which are ongoing, but this is a very complex decision made by 3 judges, and I don't think that it's necessarily helpful for that process going forward for me to provide an ongoing commentary, but we are certainly aware of the judgment. We're working through those implications, and we will certainly be making public commentary when that's appropriate.
Okay, thank you. That's enough from me at the moment. Back to the opposition.
Thank you. I'll just return to the question. You might have had time to think about this again, Minister. On the 18th of January 2024, the ICAC made a submission to your inquiry, or the inquiry for which you set the terms of reference, and they specifically advised discouraging the use of local content schemes. On the 22nd of February, you reaffirmed the Minns government's intention to establish local content requirements. Surely you're not going to tell this committee that you will ignore the advice of ICAC?
Well, Mr. Tudor-Hope, you're verballing me again. I'm absolutely
I'm asking you a question.
Order.
That's not what they say.
Order. The Minister is 2 words into her answer. Let's not treat our witnesses with discourtesy and interrupt them. Minister, you have the call.
Thank you, Chair. So I am absolutely not disregarding the advice of ICAC. I will take that, and I would expect that the committee would take that and consider that seriously, but I'm not going to preempt the work of the committee. Let me be clear about what our election commitment was. It was in relation to local content, but as we work through that process, I look forward to the considered recommendations that Dr. Kane's committee will be on, and I understand you're a member of that committee too. But let's be clear about why we have made these significant local commitments, and that's because you were part of a government that consistently sent large projects offshore, those important local procurement projects.
I've asked a specific question. The Minister shouldn't be given the latitude of just making a speech in relation to... The question was specific. It was directed to the ICAC submission, and this is now completely outside that question.
It's not complete. I won't uphold that point of order. It wasn't completely outside of the remit of the question.
Minister,
the Minister was being relevant to the question and can answer in the form that she sees fit. And so, Minister, you have the call.
Well, thank you, Mr.
Well, no, I'll move on, Minister. Minister, when did you first become aware of the Treasury Laws Amendment Foreign Investment Bill 2024?
This is the federal legislation. Yeah, so I think it was introduced in the federal parliament, and I think I became aware of that either later that day or the next day after it had been.
And it's passed the House of Representatives, has it not?
Yes, my understanding is that it is to be debated in the federal Senate shortly, but perhaps.
Correct. And on the 1st of December 2023 in the MyEFO, the Commonwealth made this observation: the Commonwealth will clarify the uncertainty associated with the interaction between foreign investment fees and similar state and territory property taxes and double tax agreements implemented domestically by the International Tax Agreements Act of 1953 to ensure that the foreign investment fees and similar imposts prevail. This measure will have retrospective effect. Were you aware of that when you read the MYEFO, no doubt?
Yeah, I am aware of the announcement that the federal government made.
Well,
I am aware that their announcement is retrospective.
And you're aware that the legislation, the input of that legislation will have retrospective effect?
Yes, I am aware of that.
So, in respect of New South Wales foreign surcharge duty and foreign surcharge land tax, which has been imposed in respect of citizens of New Zealand, Finland, Germany, India, Japan, Norway, South Africa and Switzerland, it will apply, will it not, to that surcharge duty?
Yes.
Yes. Did you consult with the Labor government, Albanese Labor government, about the interaction between international tax treaties and state property taxes on foreigners before deciding to refund $52.6 million?
Well, this is a rather audacious question from you, Mr. Tudor-Hope, but one that I will answer nonetheless. There is no doubt that New South Wales has refunded more than $50 million after your government bungled the drafting of the foreign property tax surcharge. Now let's just go through a little bit of history here, which is that New South Wales was not entitled to collect the money, as you said, because we had existing tax treaties with a number of countries. Now that was a decision taken to refund that money by Revenue New South Wales, but that was a decision that was made because they weren't legally allowed to collect the money in the first place.
Similar provisions exist in South Africa, Victoria, Queensland, the ACT. None of those jurisdictions have refunded money, have they?
Well, I'm not responsible for the revenue.
Similar provisions were...
Well, you can ask me a question and I can provide you an answer.
Are you aware that similar provisions exist?
You can continue to speak over me.
Are you aware that...
Point of order.
Are you
No,
aware?
don't need to hear. Mr. Tudor-Hope, we must treat our witnesses with courtesy. You've asked a question that I'm very interested in. The Minister is attempting to answer it. If you could afford her the courtesy of listening to the answer of the question you've asked. Mr. Minister.
Are you aware that those other jurisdictions have similar provisions, Minister?
Yes.
Then, when was the last date on which a refund was made to a taxpayer in New South Wales in relation to surcharge duty to a taxpayer from one of those foreign jurisdictions?
I'm sure if Mr. Johnson
are you aware,
can provide
Minister,
you with an answer.
I can ask the Commissioner later on this afternoon,
Well,
but are you aware last date?
As a former finance minister, you would understand that I'm not the one signing the checks as they go out. That is the responsibility of Mr. Johnson. I can hand to the Chief Commissioner to provide you with an accurate answer.
Well, I'll ask him later on today.
Okay,
I've satisfied myself that you're not aware.
No, Mr. Tudor-Hope, you don't get to verbal me in here.
Well, if
You don't get to verbal me.
Sorry.
You will answer if you are aware, Minister.
Mr. Tudor-Hope, what I am telling you is that we have refunded more than $50 million because, as the current law stands, the law that was drafted by your government, we were legally required to give back that money. It was not our money to hold on to. Now,
Minister,
this is yet another legacy issue that we have inherited from your government, and what we have done, what Revenue New South Wales has done, when they made the assessment that it was not legal for them to hold on to that money, they have refunded that money. Now, I welcome the federal government and their decision to fix up this mess that you've created. I mean, I'm delighted that our federal counterparts are coming in to help as well. But as it stands, that legislation has not passed through the federal parliament, and as it stands today, that money is not legally ours to collect.
So are you still
and
refunding
you could have
money?
taken
Are you
those
still
steps.
refunding? Are you
You
still
could have
refunding?
taken those steps when you were the finance minister to correct this error, but you didn't. Now, I welcome the fact that Revenue New South Wales has done that.
Are you aware that the Victorian government has not made any refunds in respect of their identical legislation?
Yes.
And the New South Wales government is the only government to have made refunds?
Yes, and
Now,
the reason why
well,
they did that, Mr. Tudor Hope, it's probably helpful for Mr. Johnson to give you the
Well,
exact
I will-
course of events.
Point of order.
He
as to-
can
Point of
prepare for
order.
my questions this afternoon.
Narrabri on a point of order.
Chair, it is perfectly in order for a minister to refer to an officer to elucidate on an answer in accordance with very long-standing convention in budget estimates hearings.
Yes.
I-
Yes, I uphold the point of order. The minister is seeking some elucidation, as the honourable member
I've-
has
and I've
suggested,
indicated-
from the official, which will inform the
Yep.
hearing. Mr. Johnson.
Chair, I've indicated that I will be asking those officials for an elucidation this afternoon. I have limited time with the Minister this morning and my questions are directed to the Minister. Minister, I just want to put this to you. In relation to the payments that have been made, were any payments made to your knowledge, since December last year to foreign investors?
Let's be clear about why that money was refunded, Mr. Tudor.
Did you hear my
Hope.
question?
That wasn't the question.
Did you hear my question?
Point of order.
A point of order has been taken.
I note the time, but also it's entirely the minister's prerogative how she responds, and she's had about 3 seconds of response, and then she's interrupted.
Yes, I
She's
uphold
also
the
got to
point
be
of
relevant
order.
to the question.
The minister is perfectly within her rights to provide some context to the answer she's providing, and it's discourteous and against the resolution of procedural fairness adopted by the House to not afford the minister the courtesy of listening to the answer to the question you've asked. So, Minister.
Thank you, Mr. Chair. It might be helpful to say that the Revenue was actually asked to make this ruling in February 2023. I'm not sure if that was when you were still the Minister, Mr. Tudor Hope, but that is how far back this issue dates.
Yes. So, if the repayments were made, were they not after the date that you became the minister?
Yes, the repayments
So the
were
repayments
made
were- did you-
because, well, you can continue to ask me questions and I can provide you with answers, or you can continue to talk over me.
Well,
yeah.
Minister, I will ask the questions. If you don't want to answer them, don't answer them.
Well, no,
But
don't,
don't get-
no,
don't
no,
make-
no, no,
don't
no,
make
no, no, no,
patronising
no.
comments.
You're not going to verbal me.
Don't make
I am
patronising
answering the
comments.
questions and you're cutting me off from answering the questions. So let me tell you this. Until the 30th of November, that was the cut-off date for refunds for those, but individuals can still submit a refund application.
Well, thank you,
As
Minister.
it stands, the law has not changed from when you were the Finance Minister, when your government drafted these faulty provisions.
In the same way as
And
Victoria, Minister?
Order.
That's a matter for Victoria. What I'm concerned about
Have Victoria made
is,
repayments?
I mean, you're asking me the same questions over
Well,
and over again here, and I'm telling you,
So,
Victoria
Minister,
haven't.
Minister,
Point of order, Chair.
A point of order has been taken.
I think you probably know what it is, that Mr Tudor keeps speaking over the Minister when she is trying to answer the questions,
Well,
or
the
indeed
Minister
just
won't
keeps
answer my
repeating the questions because he's not happy with the answer, which is not a reason.
Yes,
to
I uphold the point of order, and Mr. Tudor Hope, you were interjecting by asking a question you had previously asked, and the minister had responded positively to, said yes to. So that was not a helpful interjection. The minister should be afforded the time to provide a comprehensive answer if she wants to. So please desist from interjecting while the minister is providing an answer.
Thank you. So the Victorian government hasn't made any repayments.
You asked me that already,
And
and I
you-
said
and you
yes.
agree
the
with it.
Victorian
So are you
government
aware,
hasn't. But the
Minister?
Victorian government, I'm not here to answer questions on behalf of what the Victorian government chooses to do. I'm here to answer questions on the basis of what the New South Wales government has decided to do. And the reason why the New South Wales government has taken this course of action, that Revenue New South Wales has begun to refund that money, is because Revenue, whilst your government was in power, was asked to make a ruling on the issue by an affected individual. And they came to the conclusion that the money that they were holding was illegal. Do you dispute that they should not be refunding? Is that your position, Mr. Tudor-Hope, that you're putting to this committee, that when Revenue New South Wales comes to a position that they are holding money that they should not, that they should not refund
I'm asking
that
the
money?
questions, Minister.
Well,
Minister, are you aware that the Commonwealth Government, under both Labor and Liberals and Nationals, has always maintained the view that international tax agreements were not intended to prevent the Commonwealth or the states from imposing specific taxes on foreigners, including state property taxes, such as foreign surcharge land tax and foreign surcharge purchase duty? Did you make any submission to your Commonwealth counterparts to fix what you say was a problem in the interpretation of the Treasury Law's Treasury Law's foreign investment bill?
sorry, there was a very long lead into that
suggesting to you
question.
that
Were you
there is
reading from
that
something
there-
then, Mr. Tudor-Hope?
There is a convention by both the Labor government and the Liberal governments that under international tax treaties, that there were never any suggestion that states would be prevented from implementing state tax laws, and that the tax treaties were not intended to cover state taxes.
Well, you're asserting a convention
Do you agree with that as a
no
proposition?
documentation.
Do you agree with that as a proposition?
Well, you can ask me a question, Mr. Tudor-Hope,
you
and I
agree
can
with that
provide
as
you
a
with an
pro-
answer.
Just answer the question.
Do you agree with that as a proposition?
Mr. Tudor-Hope, you have asserted that that is a convention between Labor and Liberal governments. I'm asking you where that convention.
Well,
are you quoting from
do
something?
you-
Is this
you don't-
your learned opinion that I'm providing a response to?
Do you agree with that as a proposition or not? That's all I'm asking you.
Well, no, you just made an assertion and then you're asking me to agree to it, and I'm asking you to provide me with some documentation as to where you're making that assertion from.
Did you make any submission to the Commonwealth in relation to the amendment of the law to ensure that state taxes were not impacted by foreign treaties?
Sorry, you're asking whether I made.
Yes,
You're
yes.
now. So sorry. Let me just be clear. You've had a long run in for this line of questioning, and I'm just trying to get a clear understanding of what you're asking me here.
Well, did you make any representations to the Commonwealth Government in respect of amending the law to ensure that state taxes were exempted from foreign tax treaties?
Look, I don't recall making any formal representations, but I have to say I have really fruitful conversations with my federal colleagues, the Federal Treasurer, the Federal Finance Minister on regular occasions, and indeed I have been in contact with my federal counterparts
So
on
once
this
this
issue.
law passes, do you have any processes for the purposes of recovering the $52.6 million which has been refunded?
No.
So this money which has been paid by your government, which could have been spent on nurses and teachers, Minister, is in fact not able to be recovered.
Well, I'll tell you what, there's been a few Road to Damascus conversions from this particular member as he's departed from government to opposition, and this has got to be one of them. You are attacking the fact that we have refunded money and we should be clawing that back.
No other
the
jurisdiction
scale
did.
of waste and mismanagement that we have uncovered, that you oversaw during your time in government, we are not going to be clawing
Well, I
back
won't be
this
lectured
money
by you,
from
Minister, in
individuals.
respect of this particular
will.
provision,
Point of
because
order.
you're the one who was suggesting
Order.
it was your office.
Order. Mr. Tudor-Hope, we have a point of order from Mr. Narrabri.
Chair, it would assist with the conduct of these proceedings if they were a question and answer session
Correct.
rather than a talking over each other session. I just asked that the courtesy be extended
correct.
to
Still waiting on the
the
answers.
witness in accordance with paragraph 19 of the procedural fairness
It assists
resolution.
me in hearing the answers and Hansard in recording the answers and questions if we desisted from interjecting and we make sure we treat all the witnesses and each other generally with courtesy.
So, Minister, would you agree that if you were able to recover that money or had not been paid that money, you may have been able to, in fact, engage 506 graduate police officers?
He's asking that we illegally.
Is that right?
I mean, Mr. Tudor-Hope, the audacity of that question is
Can't debate the
unbelievable.
Well, it's your
We
submission,
have
isn't it?
refunded.
It's amazing.
We have refunded We have refunded money that was collected during your time in government because it was illegally collected. And now you want to come in here and question us about the priorities that we've made.
suggesting you should
I
have
can
got
tell you what we
clarification,
have
Minister.
done. I can tell you what we have done. And we are absolutely cleaning up the enormous mess that your government has left.
doing
And
that
this
well
is
for you in
yet
the polls.
one of the many issues that we are working on.
Minister.
We have refunded the money because of your blunder.
And
I
Minister-
welcome the decision by the federal government to legislate to fix your problem. And,
Minister,
and we will no longer, once that legislation
Now,
passes,
Minister, would
we
you
will no
agree with me
longer
that it may have
need to refund that money.
Would you agree with me, Minister, that it may have been much more prudent to have followed the lead of Victoria in relation to this
Oh, you want us
and
to
got
follow Victoria's
clarification
lead?
and
I'll
got
take that.
clarification from the Commonwealth before you refunded that money?
Well, that was
Because
a
that
decision.
would have allowed you to employ those 500 additional police officers, wouldn't it, Minister?
Well, the decision to begin refunding the money occurred when you were, or maybe you were no longer the finance minister at that point. All I know, it was February 2023
might have
when
to
that
resign.
decision was taken by Revenue New South Wales. I believe, as the minister now responsible, that is the correct course of action. I welcome the decision by the federal government to correct your mistake, but I'm not going to be clawing back that money from individuals. It was your mistake.
It was your mistake,
government's.
Minister, not to be more prudent in relation to getting clarification from the Commonwealth, was
I
it
mean,
not?
if we want to talk about prudent economic management, we
Minister.
can sit here all afternoon. I can talk
Let's do
about
it.
the $1 billion that the Auditor General found that your government spent on consultants with little plan for oversight in a
Yeah.
wasteful way. We can talk about the programs that we're headed for blowouts. We can talk about the
And we can talk about lack of
1,112
vision and lack of
nurses
delivery,
that
Minister.
you
That's
provided
fine.
ongoing funding for. If you want to talk about prudent economic management, why don't you ask me a question about the budget?
So did you in fact, would you agree with this, you've prematurely refunded that tax money, haven't you?
No.
You haven't, because in fact that same amount of money, if you were in Victoria, would now be available, would it not, to employ police officers and teachers? If you were in Victoria, that money would be available. Now you're telling us that it has been repaid to foreign investors who you will not seek to recover it from.
Well, no.
In another jurisdiction, they will.
All break the law, by the way.
Not in the habit of law breaking.
I'm not sure what your question is there, Mr. Trudeau.
Well, do you agree that it would have been prudent to seek clarification
law.
from the Commonwealth?
No.
No.
And in fact, you could have done that
Because-
if you were the minister responsible, because that was when this decision was first made. We are living with the consequences
you-
of the poor decisions you took, Mr. Tudor Hope.
Well, what I'm suggesting to you, Minister, is
The failure in drafting occurred under your government, Mr. Tudor Hope. It
And-
didn't occur under our government.
and
It's our federal Labor colleagues who are fixing
Tell me
up
how
this
you would have
mess
drafted it differently,
through the Labor, through passing this legislation through the federal parliament. I mean, Mr. Tudor Hope, is it actually your submission to this inquiry, to this committee, that when Revenue New South Wales formed the view that they were illegally holding the money as a result of a representation from an individual in February 2023, and I don't know the date, I don't know if you were the minister or not at that stage, but is it your submission that they should have held on to that money that was illegally collected?
So ICAC about that one.
I put it to you, Minister, that when you became the Minister, you may have taken the view that it would be prudent to get advice in relation to that issue.
I
About
take
clarification.
the view that it would have been prudent for you
Clar-
when you were
well, you
drafting the
may- you may
legislation
take that view.
to
I'm
do it,
asking you, Minister.
or
Debate
for you
everything.
to seek that
Don't have to debate it with me,
clarification
Minister.
when the complaint was
answer.
originally made. What I
Minister-
can say is I'm confident that Revenue New South Wales refunded money that they were not entitled to hold on to as a result of a complaint.
Minister, what are the implications of the Court of Appeal decision in the integrated trolley management case?
Yes, so this was a case that was handed down, I think, earlier this week.
Calm down.
Oh, sorry, there was a newspaper report earlier this week. but perhaps Mr Johnson can
But
provide you with
I'll ask him this afternoon about this, Minister. Have you been briefed in relation to what the implications of that case are?
So I think that's still subject of ongoing legal proceedings, but I'd take advice on that.
No, I think the decision's been made, Minister.
Yeah,
No, I'm aware the decision has been made, but I don't think it's concluded. Mr Johnson might have.
so the
Some
outcome was it
details.
confirmed the Chief Commissioner's position.
Was upheld.
Yes.
Yep.
We'll have that
Thank you,
one.
Mr.
Yep.
John. In relation to ITM, of course, you're aware, of course, that they are now in administration.
Yes, I am.
Are you concerned about the implications for the appointment of administrators to that company?
I mean, that's a decision of a private company.
Well,
I
they're
don't
a
think
publicly
it's-
listed company, Minister.
Well, I don't think it's particularly helpful for me to provide commentary on the consequences of a legal ruling that upheld Mr Johnson's position.
Minister, how much payroll tax will be foregone in the event of the administration of this company, or the liquidation of this company?
We're not allowed to respond to individual. We're not allowed to disclose the individual taxation arrangements of individuals. You would know that, Mr Tudor-Hope, as a former finance minister, that there are quite strict rules. Indeed, we strengthened the rules last year in relation to the privacy provisions.
When
for
proceedings were
individuals.
commenced by the Commissioner to recover payroll tax from this particular company, how much payroll tax was sought to be recovered in those proceedings?
Yeah, look, I mean, that's a very specific question about a particular court case that I'm sure Mr Johnson can take
the same
on.
question.
Provide you with... Well, you can ask me questions and I can provide you with answers, or you can continue to talk over me, Mr Tudor-Hope.
It is the same question, Minister. How much payroll tax will be foregone in terms of the administration or liquidation of this company if in fact they are placed in liquidation?
Yeah, I mean, I'm happy to take that on notice or refer to Mr Johnson to get you an answer in relation to the specifics on that.
I'll ask you later on this afternoon, Mr Johnson. You can prepare potentially for that question. Sure. You'd agree with this, that it is important that New South Wales Revenue, or Revenue New South Wales collects and retains for the use of taxpayers monies which are properly due to the people of New South Wales,
Yes.
in the same way as money which is sought to be assessed in relation to foreign investor surcharge duty, Minister. Would you agree with that?
Sorry, that was a very long
In the
and
same
winding
way-
question. Can you just restate the question?
In the same way as foreign investor surcharge duty is also important to be recovered from those taxpayers in New South Wales.
Well, no, you're drawing two different distinctions here. What we have spoken about at length this morning is money that was collected by Revenue New South Wales that was not legal for them to retain under our international tax treaties. Now you're drawing a comparison with payroll tax, which is legally required to be collected and to be paid. And my understanding is that the decision that Mr Johnson... I shouldn't say that. I should say the decision that Revenue New South Wales made in order to collect that payroll tax has been upheld by a court. So I don't think you're comparing apples with apples here, Mr Tudor-Hope.
Minister, of the 44 publicly listed or publicly identified sites where asbestos contaminated mulch has been found, how many of these sites was contaminated mulch procured by the New South Wales government?
Yeah, so... Mr Tudor-Hope, this is a really important issue, and I'd just say at the outset that New South Wales takes a zero tolerance approach to asbestos, but there have been a range of measures that have been put in place in order to provide a timely response on such an important issue.
Well, how much in total has the New South Wales government spent on purchasing and laying mulch now found to contain asbestos?
Yeah, so Mr Tudor-Hope, sorry, how much has the New South Wales government
spent?
Look, I'd have to come back to you on notice with the specifics of that particular question. I mean, our focus very much of the government at this time, and the asbestos task force that's been set up and is meeting regularly, is the immediate response, and to make sure that that the mulch is removed as quickly and as possible. And I say this, I mean, questions in relation to the investigation are really best directed to the Minister for the Environment, who's over in the Macquarie room right now. This is something that is being spearheaded by the EPA, and it's the largest investigation that they've undertaken in a decade, I'm told.
But it is a procurement issue, you would, because this is a New South Wales government procurement issue. So the two questions that I'm raising with you.
Sorry, I'll just clarify there, Mr. Tudor-Hope. There is a procurement element to that, but as we canvassed extensively at the last budget estimates, and as you would know, as a former finance minister, we operate under a devolved procurement framework. So the procurement board that reports to me is responsible for setting the policies and the framework, but the actual procuring occurs within the different agencies and the departments
Thank you,
themselves.
Minister. Thank you. So there are two questions then. How much is spent on the purchasing and laying of mulch, which has now been found to contain asbestos? And then the second question, which I anticipate you'll also take on notice, is the amount being spent on by New South Wales government on removing contaminated mulch.
Yeah, look, I'd have to come back to you. And I just make this point, Mr. Tudor-Hope. This is a really important issue.
No, I agree.
The focus of the government has absolutely been on the response. And that's why we set up the asbestos task force so quickly. You asked about my responsibilities in relation to procurement. I'd just say this. The New South Wales Procurement has requested the Procurement Board and the Procurement Leadership Group agencies across the government to assist the EPA with their supply chain investigations. Now, as part of the framework of policies that the Procurement Board sets, it includes the supplier code of conduct. Now, let's be really clear. This is illegal. This asbestos. It is illegal to supply mulch that contains asbestos. That is in contravention of that. My understanding is that would be in contravention of the supplier code of conduct.
I agree.
But we will work through those issues carefully, and the consequences of those. The focus of the government is making sure that the EPA has the resources to conduct its investigation and that the mulch is removed.
Well then, let me ask you this, Minister. Why is Green Life Resource Recovery Facility still listed as a supplier to the New South Wales government by New South Wales?
Well, you would understand that the investigation is still underway, and if you have specific questions in relation to that investigation, you should go and ask those to the Minister for the Environment.
Wouldn't you at least take steps to suspend them from being a supplier on the Buy New South Wales website?
I'm going to be really careful about the way that I respond to this question, because it's a very important issue, and I know there's a great deal of community concern in relation to it. I would say this: we want the EPA to conduct that investigation with all the abilities that it needs to. If you have specific questions in relation to that investigation, you should ask them of my ministerial colleague.
I'm interested in Buy New South Wales.
I can tell you that we expect that in tenders and contracts, suppliers and their supply chain comply with all of those relevant codes of conduct, the supplier code of conduct and all the relevant laws. And there's serious consequences. If you break those codes of conduct, you can risk losing your contracts or being removed from pre-qualified tender panels. Pre-qualification schemes or panel arrangements, I should say.
Thank you, Minister. Ms. Fairman.
Thank you, Chair. Morning, Minister.
Good morning, Ms. Fairman.
Minister, I think it was the last budget estimates, you said in relation to a question about the strategic statement of coal that you would expect that over the course of the Parliament we would revisit those strategies to make sure they were fit for purpose. But in the meantime, it remains a document that has been published by the New South Wales Government. So have you and are you revisiting that document in terms of being fit for purpose? Since then, we've seen the passage, as you know, of the Net Zero Futures Bill, which is now an act, which is now in force. Is your government revisiting John Barilaro's strategic statement on coal?
So as I have said previously, and I maintain our same position, which is we will work through these carefully and methodically in consultation this time with the community and also with the industry. But what we are working through at the moment is the critical minerals and high-tech metals strategy. Now, once that work is concluded, then I expect that we will move on to, as I've said previously, in questions to the House, indeed from the Chair, I think it was, in relation to the future of gas and the future of coal.
Remind me the timeline. You just said the critical minerals strategy. What's the timeline for that?
Yeah, so submissions closed. Let me just, submissions closed late last year. I'm just going to double check on that one because I want to say November, but I just don't want to.
Okay, so this year, you're basically saying this year you're focusing on this one policy review, critical minerals. You're in government potentially for 4 years. Who knows what's happening after that? I mean, Minister, portfolio committees in the upper house manage to undertake 3 or 4 inquiries at a time. Surely your government can review the strategic statement on coal and gas. You do realise how urgent this is, don't you? You do believe in climate change, Minister, don't you?
Okay, so Ms. Fairman.
Firstly, do you?
Yes.
And do you recognise the contribution that fossil fuels are making to climate change?
Yes.
Yes.
But
so
Ms.
you're
Fairman, you just asked
waiting
me about
one more
7
year.
questions.
No,
you just
you're
asked me about
waiting.
7
It's one
questions
question.
in a row.
It's one question.
Well,
which is the question in relation to the strategic statement on coal. Are you revisiting it? Basically, you've come back and said this year you're going to focus on the critical mineral strategy, which it's not until maybe the end of November. You said you're doing that first. So I'm coming back to you challenging that, saying, is that seriously your response given the absolute urgency of climate change? You're going to wait another year before you do anything in terms of even having a look at that policy of, let's be clear, John Barilaro's.
Okay, Ms. Fairman, you've just had 2 very long questions there. So let me just provide you with an answer. Yes, I believe in climate change. Yes, I support our net zero targets. I voted as and am a supporter of those as a member of the New South Wales Labor government. This is an important step forward. I just want to correct something in your question there. Submissions closed in November last year for the critical minerals and high-tech metals strategy. Now, as we have discussed previously in a private briefing with the CEO of MEG, that previous government strategy was done without any community consultation. So we've taken a deliberately different response. We are consulting with the community. I've held a roundtable. We received 36 submissions from a range of industry, from industry, from unions, from community members, from individuals, from peak organisations. We've had really good engagement in that. I accept that we can walk and chew gum at the same time. At the same time, we are trying to implement our election commitments around the future jobs and investment authorities that I answered a series of questions on earlier during budget estimates. There are a range of things that we are working on. We are certainly over our 4-year term going to get to the future of coal statement. I take your point. It was done by John Barilaro under the previous government. But this is also something that we're going to work through carefully and methodically. We're not going to rush it. It's an important statement and we will review it in time. I've been really clear about that.
Thank you for that response. Are you aware of just how much the Independent Planning Commission relies on this document when they go to look at whether or not to approve coal mine approvals that are currently in the planning system? So your government, Labor government, under your government, we've already seen one being approved, which is the Boggabri Modification 8, reasonably significant. The Independent Planning Commission relies on that strategic statement of coal because it is the direction of government. It's the policy of government. So if you're saying you're waiting however long that is, right now there's about 14 or so modifications in the system that, if approved in terms of the coal that they are going to burn, is way beyond New South Wales's annual emissions, for example, huge amount of greenhouse gases. So preparing to wait might be okay if it's a policy about, I don't even want to say, well, actually, in terms of what is okay to wait, but it's not okay to wait. When your government came in, elected on action on climate change, you did say you'd act on climate change. This policy is the most critical policy your government has when it comes to approving coal mines. Are you aware of that?
Okay, so you've asked me again a really long...
No,
there's been a
no,
long
I didn't ask you a lot of
pleading.
things. I gave you
asked
some
me, well, no, Ms.
information
Chairman,
and
you
I've
have
asked
me
one question.
No, you have asked me a series of questions. You asked if I'm aware of how important the statement is in relation to the IPC. You've asked me about whether I believe in climate change. You've asked...
Well, that was a previous question which you answered.
I lost track of a few of the questions there. Let me just be really clear. I understand it's an important document. I understand it's an important document for the community and for industry and for organisations like the IPC.
Planet.
Of course, Ms. Fairman. But if you want to ask specific questions about the actions that we're taking on climate change, I'm sure you've been asking those of the Minister for Environment and Climate Change in the other room. This government is absolutely committed to an energy transition, to a clean energy future, to taking real action on climate change. But we are committed to doing that in a careful and a methodical way. We're not just going to make these snap decisions overnight. So what we are doing at the moment is working through the critical minerals and high-tech metals strategy document, updating that, working on delivering our future jobs and investment authorities in partnership with local communities, doing the range of other important work that the Department of Mining and Exploration and Geoscience does every day in relation to mine regulation and keeping our workers safe. It's not the right bow to draw to say that this government, because we're not immediately reviewing the statement on coal, that we're not serious about acting on climate
is there
change.
any direction that you care to? I mean, this is what the Independent Planning Commission is looking at right now. This is what they quote. This is what they say in their approvals right now. Is the only direction they have from your government in relation to coal and relation to approving every single coal modification expansion. Let's be clear, modification is expansion, more coal being mined, more coal being burned, more greenhouse gas emissions as a direct result of what is being approved in the state of New South Wales. Are you going to send any direction to the IPC this year from your government when it comes to the approval of coal mines other than what John Barilaro said 4 years ago, 5 years ago under the National Party?
So, Ms. Fairman, of course, we are working on a very multifaceted and nuanced approach. Questions in relation to the specific considerations for the IPC are best directed to the Planning Minister. I am certainly speaking to him about the best ways that we can do that, but we are going to work through this in a careful and in a methodical way. I'm not going to make an announcement here today that we are going to be updating the coal statement. I have been consistent in my language about this since my very first days of being elected. We will work through these issues carefully. Now, we have legislated for our net zero targets. We have legislated to put our net zero commission in place. They have started that important work. I speak to my ministerial colleagues about these issues frequently, but we need to do this in a managed and in a careful way.
Thank you.
Coal will continue to be a key part of our electricity network and a key part of our state's exports for a long period to come, and we want to make sure that we're working through that in a careful way.
Just one more question about that then. You said to ask the Planning Minister question. Sure, I understand the way this works. That's why I'm here sitting here asking you about the strategic statement of coal. I'm not asking you about the planning system. I'm not asking you about any of that. I'm asking what you have responsibility for. That's what I'm asking you about. It's the strategic statement of coal policy. One question in relation to that. Are you aware of how much the Independent Planning Commission relies on that statement when they make their determination as to whether to approve or reject coal mines in New South Wales?
I'm aware that that is an important statement for not just for the IPC, but for industry, for community, for government more broadly. So we are going to review that document, but we're not going to do that in a knee-jerk way. We're going to work through that in a careful and a considered way. We want to be able to provide certainty and a stable operating environment, and I don't think that's going to be assisted by me making a knee-jerk response today.
Can we see anything this year? Do you think 2024? Will we see any movement on this this year?
I've said. You've asked me the same question
Minister,
several times. I've said the
have
same.
you seen the recent ABC report about 2 miners being diagnosed with silicosis at Orange's Cadia gold mine?
I am aware of those reports.
Are you concerned that this disease is still striking miners down, including here in New South Wales?
I am concerned. Let me just say, sorry. Of course, the first and foremost responsibility as mining minister is to make sure that mining workers have a safe and have a safe environment to work in, and that they get home safely to their families. That is the absolute underpinning primary responsibility that I believe that I have as the mining minister. Now, I am aware of the silicosis diagnosis. That is specifically in the remit of the resources regulator, so it's probably best that he provides you with that direct information. We do have a really stringent regulatory system that underpins our mining industry, and I think he's probably best placed to be able to provide you with those answers.
Which we have a lot of time for this afternoon, Mr. Day.
Thank you. Minister, just following on from Ms Fairman's questions, why is the government reviewing the strategic statement on coal?
So we will work through that document once we've concluded the work that we're doing on the critical minerals and high-tech metal strategy.
But why?
Well, we want to make sure it's fit for purpose, that it's updated, that it's in line with our government's aims and objectives.
So there's a possibility that it's not fit for purpose?
Yeah, there is a possibility that it's not fit for purpose.
Do you think it's a document written by John Barilaro that the community can have confidence in, that they can rely on the integrity of that document?
I mean, Mr Buckingham, you have asked me questions about this since my very first days as minister. I think it's really important that we provide a stable operating environment for the mining industry in New South Wales, but also for the community to rely on. We will certainly make sure, and I have flagged this frequently, that we will make sure that that's fit for purpose and whether it needs to be updated. But I think it's important that existing policies stay in place to give that certainty, that ongoing certainty to the industry, but also to the community.
Mm-hmm. And just to be clear, in terms of what Ms Fairman was saying, that the work in terms of updating it will not be occurring concurrently with the there's no activity being done until the policy around critical minerals has concluded.
Look, I've just made it really clear. I think we need to prioritise what we're doing and sequence it properly. And I think that the resources of the department at the moment are fully consumed with the work that they have on a day-to-day level, but also then in doing this survey. So we will begin the process of formally reviewing that document once we've concluded the work that we've done on the critical minerals and high-tech metals strategy.
Thank you. Minister, I'll just bring you to a question around the Russell Vale.
Yeah.
Just excuse me 1 second. The Russell Vale colliery and Wongwilly mine sites. Are you confident that the securities held for those mines, which have closed, will cover the cost of rehabilitating those sites? I understand that the Russell Vale site has $12,340,000 held in security, and for Wongwilly it's $40,150,000 as of 2020. But the actual miner, Wollongong Resources, estimated the cost of rehabilitating the Russell Vale site at $215 million. Are you confident that we have enough money held in security to rehabilitate those mine sites?
Yeah, so let me say this. I know this is an issue that's causing concern across in the Illawarra, and it's a good question for you to ask.
And those mines you're aware those mines are under the Sydney drinking water catchment.
Absolutely.
So the rehabilitation of them impacts on anyone who's drinking water from our water catchments.
I certainly understand the importance of mining rehabilitation on any mine site. Let me say that. I'm absolutely committed to enforcing those standards and making sure that they are stringently enforced. There is some history in relation to, or there's some sort of broader considerations in relation to Russell Vale and the commercial decision that was made by the company not to reopen that particular mine. But and perhaps you might like to ask the resources regulator some more questions in relation to that this afternoon. That was it was a pretty significant step for them to take, but that was, and we certainly understand, and I certainly understand the impact that that's had on those workers in the Illawarra. In relation to the rehabilitation requirements on the company, Wollongong Resources can take a decision that they no longer want to operate the mine. That doesn't negate their responsibilities in relation to mining, the rehabilitation work that needs to occur on that site. We will absolutely ensure that all of their obligations are required. Your figures were correct. There's the current rehabilitation security deposit is roughly $12.3 million, and the title holder is responsible for lodging that security deposit. But I want to be really clear with the community in the Illawarra. I'm working closely with my colleague, the Minister for the Illawarra, and with the local members down in that part of the world. We will ensure that all of those obligations are honoured, and we will make sure that that mine is rehabilitated in the way that it is required to be.
Thank you, Minister. Minister, point of consumption taxes. It's one of my favourite topics these days. Point of consumption taxes are a novel, a new way for states to generate revenue. How much is, over the forward estimates, the government predicting it will raise from the point of consumption tax on online gaming wagering in New South Wales?
That's an excellent question, Mr. Buckingham, in relation to our future projections. Before I pass to my Treasury colleagues to give you an accurate answer about exactly what we're projecting over the forward estimates, what I can tell you is this year in taxation we'll be taking in about almost $45 billion. But in relation to the point of consumption, we might need to
take that one on notice, Mr. Buckingham, unless my colleague Joanne Wilkie can magic up an
I'll move
accurate
on,
answer.
and if I could get an answer.
No,
Yeah, of
we might be able to respond during the course of the day.
Fantastic.
Yeah.
Appreciate that.
Yeah.
In a previous hearing of this inquiry, the Treasurer said that interestingly said that he had an assurance from the federal government that if the point of consumption tax was not constitutional, because there's been some challenge to point of in Vanderstock versus Victorian government, there's been a challenge to point of consumption taxes in Victoria under refund. He had an assurance that from the federal government that were they to not be upheld by a potential High Court challenge, that the federal government would essentially underwrite those taxes by way of a windfall tax. How has that process occurred? Have you been privy to those conversations? And how has the federal government, formally responded or informally responded to the New South Wales government about that issue?
Yeah, look, I mean, the Treasurer and I work closely on a range of issues, and I did watch large parts of his estimates last week, and I think that's probably really a question for him in relation to providing you with an update with his conversations. He's certainly briefed me on a range of issues that is currently underway. There's a clear intersection between the work that we do at a state level and the federal counterparts, but he takes the lead through the Board of Treasurers, through KIFA, in that kind of external consultation role. So I think that's probably best for him to answer, unless the Secretary's got anything to add.
Oh, thanks, Minister. Look, it was a matter of discussion, Mr. Buckingham, at the last Council of Federal Financial Relations, which is the meeting of the Commonwealth and State and Territory Treasurers. And the Vanderstock decision is a decision in relation to one tax and one tax in Victoria. There are a range of views about its implications, if any, for other tax bases. And I think the view in New South Wales is essentially we won't know until a tax base is challenged before the High Court whether there's further implications. What all Treasurers were seeking from their Commonwealth counterpart was a commitment that, as the Commonwealth did in the late 1990s, it would essentially take, by way of a windfall tax legislation, any compensation that someone sought for taxes that had previously been paid to a state government but was now ruled unconstitutional. In other words, remove the incentive for a legal challenge to recoup taxes that may have been paid over decades. Yes, you might win in the court constitutionally, but the Commonwealth will take back any compensation you get, and you will be left with your legal costs. So that's what states and territories were seeking from the Commonwealth, to discourage legal adventurism in coming after our tax bases. And there was a commitment in that meeting that the Commonwealth would consider that.
Thank you. Has Revenue New South Wales, or the Treasury, done any modelling on increasing point of consumption taxes over the coming years?
Look, I'm not immediately aware of that, but we can take that on notice.
I'm happy to take that on notice.
Yeah.
Okay.
Yeah.
Some other states have introduced let's call it an addition to their payroll tax in terms of instituting a mental health levy. I think it's 0.5% on companies with payroll above 10 million and 1% on companies with a payroll over 100 million. I think that's the case in Victoria. And it's generating nearly $1 billion worth of revenue there. Is Revenue New South Wales, or the government, considering a similar model? I think New South Wales is one of the only states that isn't bringing that in and hypothecating that to funding suicide prevention, mental health services. Is that something that the state government is considering? Or?
No. So the Treasurer was very emphatic before the election. We are committed to introducing no new taxes. It's a worthy, it's a very important issue, mental health, and it's a growing challenge for our health system. And we certainly want to be providing the support that people need, but that's not something that we are considering at this time.
Do you consider increasing the payroll tax a new tax?
That's an interesting question that I hadn't really thought about. I mean, I think the Treasurer was pretty emphatic that there's no new taxes, but I make this point. We have been really clear that if there are loopholes that emerge, or there are things that emerge as a result of the almost constant legal interactions between and legal cases that occur as a result of our system, will certainly take action to ensure that our tax system, to ensure the integrity of our tax system and to make sure that it's fit for purpose.
Thank you, Minister. Dr. Kane.
Thank you. Minister, could you talk about the last government's record on domestic manufacturing?
I welcome the excellent question from Dr. Sarah Kane, and I'm looking forward to your report. And I certainly, just at the outset, let me say, I think I'm really encouraged by the fact that ICAC has made a submission to your important inquiry. I expect that you would take a considered view on such a submission. I deeply respect the ICAC views. I'm not going to preempt the recommendations that you make, but it is important to provide some context as to why we took some significant election commitments around local content and to rebuild our domestic manufacturing industry in New South Wales, because what we have seen from the previous government is consistently sending major projects offshore over a series of years, and it didn't just result in a poorer economic outcome, it also resulted in a poorer social outcome. And that's certainly, I know, the focus of what you're looking at doing in relation to the procurement inquiry. How can we be using those precious procurement dollars in a more effective way? But let's be clear about what the people of New South Wales did get from those billions of dollars sent offshore. They got ferries that were riddled with asbestos. They got ferries that you were risking decapitation if you travelled up the Parramatta River. They got there was issues with the engines that they couldn't start, they couldn't reverse. I mean, I lost track of all of the different faulty problems that occurred with those ferries. Those important projects that were sent offshore. Not to mention, we can start talking about trains. We did commit. We will build trains here in New South Wales again, as we have for over 100 years. But the previous government took deliberate deliberate decisions to send those important procurement dollars offshore. Now, we think we can leverage them in a better way, and I look forward to hearing how we can be doing that as a result of your inquiry, Dr. Kane.
Pretty
Thank you.
underwhelming answer.
Thank you, Minister. And
Order.
as a follow-up, what have you achieved since you've become Minister for Domestic Manufacturing and Government Procurement?
Yeah, so in November last year, I issued my first ministerial direction to the Procurement Board. We increased the amount that small and medium-sized businesses can be directly purchasing goods and services from the New South Wales Government from $150,000 to $250,000. Last year, the New South Wales Government procured $42 billion worth of goods and services and construction. We want to be making sure that small and medium-sized businesses get a larger slice of that pie. We want to be making sure that they have that opportunity to do that without the paperwork being so overwhelming that it's a disincentive. So we took a number of steps to that. We're committed to setting up an Independent Jobs First Commission. We've started doing that work in New South Wales Treasury. We think that this is an important way to build the capability that is no longer here, that was decimated over 12 years by the previous government, and we want to rebuild that capacity and that capability by setting up our Jobs First Commission. And I really want to thank the excellent public servants who are helping that process. As we've talked about extensively this morning, we're going to be setting up a 30% tender weighting to support local content, and really taking a fresh look at the way that devolved procurement model works. These are important taxpayer funds. We want to be able to spend them and to be getting the best possible outcomes. We want to be rebuilding our domestic manufacturing industry as we do that, but there's a range of opportunities about how we can be better using those precious procurement dollars. And I look forward to your inquiries report, Dr. Kane.
Thank you, Minister.
Thanks, Chair. Minister, you gave an example earlier under some questioning from Mr. Tudorhope of having to clean up a mess left by the previous government, and I want to know: are there any other such instances where you've had to clean up a mess left by the previous government?
Well, thank you for the excellent question, Mr. Lawrence. I did speak extensively about the foreign surcharge tax issue. That's obviously taking a considerable amount of cleaning up to do. You and I have worked on the issue of opal mining, where the previous government was issuing mining licences incorrectly for an extended period of time, but it was discovered that they were 3,343 mineral claims were impacted by those decisions. That was a really difficult time for those miners and for the mining community out there, and I really want to thank you for the work that yourself and certainly Roy Butler did with working through those issues. The legislation passed the Parliament last year. That was great. We could sort of and I'll look forward to hearing from the review and making any further changes that we need to be doing. But I mean, there's just a range of issues, whether it's, I've talked about the fiscal cliffs that we uncovered, $7 billion worth of programs that were unfunded, this budget black hole that was just gifted to us when we were sworn in. We've funded 1,112 nurses in our public hospitals that didn't have ongoing funding, and I really want to thank the Minister for Health for the important work he's doing there. Cybersecurity in New South Wales, out-of-home care, there are a range of issues that we've confronted. Not to mention, we've started doing some work on fairer fines. That's going to be a lot more of our focus, and as we make sure that our fine system is fit for purpose, and particularly during this cost of living crisis. I mean, the previous system that was in place around fairer fines, where 0.01% of fines were given any kind of hardship that were refunded under this system at a time when there are so many families and households and businesses doing it tough. We need to make sure that that is actually going to be fit for purpose and in place.
Thanks, Minister.
Thank you, Chair.
Thanks, Chair.
Done. Okay, thank you, everyone. We will now, in the absence of any more questions from the government, we'll have a break and reconvene at 11:15 a.m. sharp. Thank you very much. Commence with questions from the opposition. Mr. Ruff.
Thanks, Chair. Minister, before the election, did Labor commit to increasing tender weightings to 30%, capturing local content, job creation, small business and ethical supply chains?
Yes.
And do you stand by that commitment to including local content in weightings?
Yes.
So how do you respond then to ICAC's warning that, quote, the Commission does not support selection
Point
criteria...
of order, Chair.
A point of order has been taken. Dr. Kane.
I understand that we are allowed to, the opposition is allowed to pursue this line of questioning. However, the committee has not yet looked at those documents, and without the Minister having them with her, they're now being subjected to a particular interpretation by Mr. Rath and Mr. Tudorhope, which I actually don't share, having read them. And I think it would be at least courteous to allow the Minister to have a copy of...
Go on.
I mean, I'm quoting directly from it.
Well,
yes, it's what you quote,
Mr.
the
Ruff
selectiveness of it that I'm worried about, Mr.
table-
Rath.
And it's publicly available on the Parliament's
to the point
website.
of order, it would be unreasonable to expect the Minister to now take the full period of time to read the whole report to comply with what the Minister... This is a direct quote from the report, and the Minister is being asked to respond to that quote.
Was it a direct quote? I think it was Mr.
So,
Rath.
So
I will quote.
Interpreting.
I will quote the report
well,
directly.
just on the point of order, the advice from the clerks is that submissions are not caught by the meaning of proceedings. So therefore, the report, the submission can be referred to. And if Mr. Ruff would like to table a copy so the Minister can have one, that may assist, or may not. But anyway, if you want to rely on a quote, then please do so.
Thanks, Chair. So quoting from page 12 of the submission, how do you respond to ICAC's view that, quote, the Commission does not support selection criteria or weightings that give preference to local content or local suppliers because of the increased potential for corruption?
Yeah, I
But
mean,
it goes on to explain.
Dr. Kane, order.
You can it qualifies it later, so...
Order, Dr. Kane.
So, Mr. Rath, I'm not sure if you were here for the questioning earlier from Mr. Tudorhope, but I was really clear that I deeply respect I deeply respect ICAC. I am delighted that they've made a submission to the parliamentary inquiry that I initiated by writing to Dr. Kane. I think these are important and considered things that should be thought about as we consider how to implement this election commitment. But yeah, I stand by
who's
my
right,
earlier
Minister?
testimony.
Are you right, or is the ICAC right?
No, it's not a binary question there, Mr. Rath.
So the ICAC's concerns about value for money for taxpayers, about integrity measures.
The only submitter.
Order, Dr. Kane.
Are you happy just to jettison those for the headline about local procurement that you brought to the election?
Well, Mr. Rath, there was a series of assertions in your question then that I don't agree with. I find it interesting that you're coming in here attacking this from a different viewpoint now. I deeply respect the views of ICAC. Of course the committee will consider those carefully. I note that Dr. Kane is so diligent, she's gone away in the break, gotten a copy of the submission and is already quoting it back to you. I will look forward to the committee's recommendations in relation to this. We were really clear about this before the election. You asked me questions in relation to this during the last budget estimates, but let's be clear about why we took that decision. We said that the approach of your previous government of sending billions of dollars of taxpayer funds offshore was not right. We want to build things here. We want to be able to build trains or ferries or spend our government procurement dollars here. What I can tell you, we are not going to be spending billions of dollars in Korea for trains that do not fit our tracks. We're not going to be spending money on ferries coming from Indonesia that are riddled with asbestos, that are can't reverse, that are risking decapitation by getting on them. I mean,
But-
this is just
Minister-
absolutely
Minister,
ridiculous.
but at
Do
the
you
last-
not support Australian-made products?
Well-
We are not
well,
first movers
Minister,
here.
at the last estimates, you're quite right. I asked you about the RTBU's pledge on local manufacturing and procurement. And 25 Labor MPs, including yourself at the estimates, committed to that pledge. But the ICAC's recommendations basically throw that entirely up in the air, doesn't it? In particular, they say potentially sacrificing value for money by limiting competition and may prevent access to new products and innovative solutions.
And also,
Well, let me say this.
objectively
I'm looking forward to the
criteria.
recommendations.
They are going
that-
to do it.
Order.
Cherry picking the submission.
Let me work through those series of assertions that you made then. I do support the RTBU's pledge. I was delighted that you brought it to my attention during the last estimates hearing. I do support the ability to build and find opportunities to spend our government procurement dollars in Australia. In domestic manufacturing, we know that for every job in the supply chain that you directly create, there are 3.5 in the supply chain that are created. So when your government sent billions of dollars offshore, not only did you send those jobs offshore, you sent those supply chain jobs offshore as well. We are absolutely committed to using that money here, and we will do that within the guidance provided by ICAC. I welcome that feedback, and we will respond to the report appropriately. But like, Mr. Rath, are you actually coming in here and saying that you don't support domestic manufacturing?
Well, we're here to ask the questions, Minister,
All right,
and
that's a no.
hopefully
That'll
we're
be a
here
no.
to answer them. So, Minister, are you intending to wait until after the committee reports, as in the Social Issues Committee reports in July, before heeding ICAC's warnings about local content schemes and their potential for corruption?
It's not a warning, it's a submission.
Order. Dr. Kane.
Mr. Rath, they have made a submission to a parliamentary inquiry on an election commitment that is complex and requires careful and diligent work, and that's exactly why I've asked the Upper House Social Issues Committee to make recommendations in relation to that. I think it's a welcome contribution from the ICAC. Of course, we'll consider that carefully.
So you're just going to ignore the ICAC until July?
No.
Well, Minister, do you also accept that we do have obligations under free trade agreements?
Yes.
But they can be dealt with.
And do you accept that those free trade agreements do in fact
Have you read
open?
the other submissions we talked about?
Order. Dr. Kane.
Do you accept that under free trade agreements we do have obligations in relation to procurement policies in respect of making sure that we do get value for money and have an open competition market in relation to the supply of contracts?
Read all the submissions.
Yeah, I mean, I'm certainly aware of our free trade obligations. I'm also aware that Victoria, Queensland and Western Australia have found a way through this. These are important projects that we can be building locally, and we will work through that. But the idea that our free trade obligations are in some way going to inhibit us when Victoria, Queensland and Western Australia have all found a way to spend their dollars locally, to build local jobs, to create local opportunities, to build their local supply chains. I mean,
Thanks, Minister. Minister, and you'd agree Victoria found a way in relation to dealing
the other
with
submissions.
surcharge duty, is that right? Victoria
I
found a
mean,
way?
again, Mr.
Thank you,
Tudor-Hope, you're
Minister.
drawing
The
comparisons
Minister,
between two issues that have no relationship
Minister-
to each other. The foreign tax surcharge, I mean, we've dealt with that at length. Anyway,
So,
do you have another
Minister,
question?
well, you're prepared to, in fact, compare New South Wales with Victoria in relation to procurement policy. Are you prepared to compare New South Wales to Victoria in relation to revenue policy?
Mr. Tudor-Hope,
Or is it just you pick and choose?
Mr. Tudor-Hope, I dealt with your questions in relation to Victoria and the steps that they took and the steps that we took as a result of your bungling of the foreign
No,
surcharge
Minister, it wasn't
tax.
bungling. It wasn't bungling.
They're-
It was
they're-
a good
they-
policy. $2.6 billion we raised in relation to
Point of order,
surcharge
Chair.
duty.
A point of order has been taken.
Good
Dr.
policy, Minister.
Dr. Kane.
I'm not sure that Mr Tudor defending his dubious record is appropriate material.
Well, it's
to be
like you
covered.
making interventions in relation to...
Well,
Order,
read the submissions.
order,
There are
order,
separating
order,
Don't do it.
order,
Don't do it.
order. There's no point of order.
Thank you.
Mr. Tudor, please ask some questions, and could we all desist from interjecting or conducting a debate across the room,
Minister,
please?
can I take you to palliative care? Are you going to give the same response as Minister Park, the Premier and the Treasurer in relation to the reduction in palliative care funding, or will you admit today that in fact in relation to the future contributions for future budget estimates for palliative care contributions, you have in fact cut palliative care funding by $250 million? Will you make that a concession today? Be the only minister who's prepared to do it.
Well, Mr Tudor-Hope, you asked me these questions in November. You've asked the Premier and the Treasurer and the Health Minister the same questions. They've given you the same answers. I will give you the same answers. Under our government, we will see palliative care funding increase this year by 6.8%. It will increase by 8% next year and a further 11.7% in the following year, 2025-26. You can ask the same questions, Mr Tudor-Hope. The answers don't change.
So, well, let me just put this in very simple language. If you promise your children a pocket money of $10, and you only give them $7.50, is that a cut? Is that a cut?
I don't think Anna would go
Mr Tudor-Hope,
Is that a cut, Minister?
I'm not going to enter into debates about
Well, you
pocket
promised them
money,
$10 but
mainly
only
because-
given them
mainly because
$7.50. Is
I
that a
don't give
cut?
my children pocket money, so that's I don't necessarily buy into the analogy. What I can tell you in relation to this important issue on palliative care is that this year the funding will increase by 6.8%. It will increase by a further 8% next year. The year after it will increase by 11.7%. What we have done is provide increased funding over the subsequent
But you have
budgets
cut it,
that
have
we
you
are
not,
doing.
Minister? Just make the admission, because today's your chance to say we have cut it, haven't you? You promised $10, given them $7.50.
Mr Tudor-Hope, you are asking hypotheticals and drawing the wrong conclusions. What I can tell you is the facts. The facts are in the budget papers for
They are.
everybody to see, which is that
We've
under
seen
our
the
government,
documents, Minister.
Under our government, we will be increasing funding by 6.8% this year, by a further 8% next year, and by a further 11.7%
Minister, I
the
thought
year after that.
in relation
And
to
so
that you
what
would at
I
least
can-
have a bit more perspective. But in any event, how many full-time FTE positions will be cut as a result of, or not be filled because of the $250 million funding which has been removed?
I mean, that's quite a specific question in relation to the health system. I think that's probably better directed to the Minister for Health.
You were in fact on the Expenditure Review Committee. You must know an answer to that.
Well, no, I'm telling you that a specific question around the full-time equivalent of the health workforce is best directed. You missed your
But you
opportunity.
admit that there will be a reduction in FTEs
Well,
for
let me
palliative care.
answer your question. Don't speak over me. Extend me the
I'm not
courtesy.
speaking. I
If you
just
want to
want you to
ask me
answer.
questions, give me the courtesy to give an answer. That palliative care is actually being expanded under our government. There are new and expanded palliative care units throughout the state, and that palliative care will increase the funding. Now, if you have a specific question in relation to the full-time equivalents, you are welcome to direct that to the Minister for Health.
Would it have been
What I
increased
can
more
tell
under
you-
the previous government?
What I can tell you is the funding that is available in our budget will increase year
Would
on
it
year.
have been more
And this
under
is
the previous
same
government? Would it have been more?
Mr Tudor-Hope, this is the same answer
Would it have
that
been
I
more?
said here last year, that the Premier has said in his estimates now twice, that the Treasurer
Would it
said
have
in
been
his
more
estimates,
under the previous
and that the
government,
Health
Minister?
Minister has said in their
Would it have been
estimates.
more
I mean,
under the
we
previous
have-
government?
We have continued to answer your questions about what is in our budget, what we are committed to doing, which is increasing funding year on year for new and expanded palliative care units across the state.
Would it have been more under the previous government?
Well, you lost the election, Mr.
But
Tudor-Hope.
would it have-
You
that's
lost
it.
the election.
We did.
We
But would it
won
have
the
been more under
election.
the
We are
previous
dealing
government?
with the legacy of
There wasn't
the
any
issues
money
that
there.
you created in the health system, including the 1,112 nurses that
So
you didn't
would
provide funding
would palliative
for.
care have been
So,
funded
well,
more
Mr.
under the previous
Tudor-Hope-
government? Answer the question.
Well, that's a
Minister.
hypothetical question
Point of
because
order.
you didn't
No,
win
it's
the
not. It's
election,
not
Mr.
hypothetical.
Tudor-Hope.
Point of order, Chair.
What I can
The
tell
point
you.
of order has been taken, Mr. Nanva.
Chair, I again refer to Legislative Council practice, which states that House procedures are not binding or strictly applied, but they do provide a guide to budget estimates hearings. Mr. Tudor-Hope is asking a hypothetical question, and I ask that you rule it out of order.
Yes, it is a hypothetical question. We have no idea what would happen in a parallel reality where the
allocated
coalition
more money
was
in the budget.
returned.
We allocated more
We
money.
cannot, see into the
They cut the
multiverse.
money.
So, because of that, it is a hypothetical, and
it's a real
therefore
question. It's not hypothetical.
Well, it is a hypothetical. Well, you're saying, what if?
No, I said, would it have been more?
Well, we don't know. You may
do,
have made,
because it was-
you may have made a
budget
different
vote.
decision.
We
You
do.
may have
Crystal ball out.
We do know.
You
It was
could
in the
have done
budget
it.
papers,
No,
wasn't it,
because you had no
Minister?
money.
But we will never
But you
know
can
what
cut
we
it,
don't
Minister.
know.
The money
So,
for
You can cut it.
Didn't have the money for it.
Mr. Tudor-Hope, you have 4 minutes in.
No.
20
Actually, my turn, Chair,
Oh,
if that's okay.
Ms.
Thank
Mitchell.
you. Minister, I just wanted to ask you some questions about the Royalties for Rejuvenation Fund. That fund's legislated with $25 million annually to be set aside for mining royalties, for investment. That's correct?
Yes.
Can you tell me when each year that $25 million goes into the fund?
So that is my understanding is that the requirement for the fund is that the money goes in, but your government made an interesting decision, which was to lock the money up.
No, Minister, I'm
So
asking you about,
what
I want to know, you've said that is set aside annually, that's in the legislation. I just want to know when that $25 million goes in. And further to that, can you tell me how much is currently in that fund?
In relation to that fund, Royalties for Rejuvenation. So this is a fund, yes, that's correct. The current balance is $74.5 million.
Thank you.
In this year's budget, we have promised $5.2 million over 4 years towards establishing our future jobs and investment authorities. But I think when we discuss this fund, it's really important to note that it was your government that made the decision that that money is tied up until 28, 29,
Thank you,
or until it
Minister.
matures
No, I'm
to a
asking.
particular
Well,
position.
Minister, I'm asking.
So that puts some
Chair,
requirements.
this wasn't my question. I asked how much money was in the
around-
fund. The Minister's answered that. I'd like to just move on to my next question. Can
Well,
you tell-
sorry, just to that, Ms. Mitchell, if you do have a concern with what's the answer, you should take a point of
Well,
order.
to point of order, it was a very specific question, which is how much money is in the fund. The Minister's just told me it's $74.1 million. I would like to ask the second question.
74.5.
74.5.
Further to the point of order, I think there was actually
Oh, for
two
goodness
questions.
sake.
I think there was two
Yeah, there
questions,
was two questions.
and there's a practice emerging of cutting short witnesses
redirect
in
you,
giving answers.
to the-
And if you ask a question and the minister is providing detailed and relevant information, then
But to the
well,
point of
that
order,
she-
Chair.
any minister is at liberty to provide
I-
that information.
But
So-
I haven't asked the Minister about what that money's being used for. I asked about when the money went in and how much is in there, which she's answered. I'd now like to ask other questions. I've got very limited time, as the Minister well knows, having sat in this chair for a long period of time. So I want to ask you now, Minister, how many local government areas comprise the coal mining regions covered in the regulation for that fund?
That's an excellent question. That there's a large number of local government areas. I could get you the specifics. I mean,
That would be
our
great.
fund, our approach to the fund is very much about the 4 regions that
That's
we've
fine.
identified.
Thank you.
So there's the Hunter.
Yeah, I know that. Thanks,
Lithgow.
Minister. I've been on the website. I wanted to know how many local government areas.
you
If
already
you
knew
provide
that.
that
Well,
on
if you're on the
notice,
website,
thank you.
maybe you could have just.
No, I'm asking whether you know how many local government areas and you don't. So come back on notice. That's fine. Have you met with any of the panels, the 4 expert panels who've been set up to provide advice on the applications?
I've met with the chairs of the expert panels on several occasions. There were a number of the members of the expert panel who attended our roundtable in the Hunter. But in terms of the roundtable, Nico, I might just have to
No,
ask the
I'll come back.
CEO
I'll come back this
whether
afternoon. That's fine.
they
Can you
attended.
tell me? Did you write to the expert panels and instruct them not to put forward any submissions or advice on projects that could be funded through this program?
So what I have done is I have asked, can I just say at the outset, I deeply respect the experience of the people who have been appointed to the expert panels by the previous government. I know that there's lots of really dedicated people who were finally appointed in November or December 2022 by your government to these panels, and I admire the enthusiasm that they have and that they have.
But did you
it
write
is
to them and
appropriate-
instruct them not to put forward submissions? That was my question.
I'm answering your question, Mrs. Mitchell.
Did you write to them?
I'm answering your question, which is we need to go through a process to ascertain whether the expert panels are fit for purpose for our government's objectives, whether they reflect the approach that we want to take with our future jobs and investment authorities. It's no reflection on the individuals on those expert panels. I think the opportunities that I've had to meet with them, they've been enthusiastic advocates and they've got some great ideas. But what we need to do is make sure that it's fit for purpose for what we promise the people of New South Wales. And so there does seem to be a slightly different purpose in the way that the previous government has set that up, but we're going to work through that and make an announcement in due course.
Thank you, Minister. Ms Boyd.
Thank you, Chair. Good morning, Minister.
Good morning.
And good morning to all of the officials who are here today. Just coming back to those jobs and investment authorities and the Royalties for Rejuvenation Fund, that's really interesting. I didn't realise that was locked up until 28-29. So does that mean can you tell me what it's invested in and what through? Is that a T-Corp investment?
I'd have to get refer you over to the Secretary of Treasury to give you the very specifics.
Okay. And
it's a great question.
You were about to say at the end of the answer to the question you were asked before that it's either 28-29 or, did you say if it reaches a certain level?
Yeah, so from memory, it's when it reaches the fund reaches a certain amount, but I don't want to mislead you, so I might... what I can tell you is that it sets aside $25 million each year from mining royalties. The fund is held in a Treasury special deposit account. Sorry,
Okay.
I did have some information here that would be helpful for you. This year we expect to spend $1.2 million in recurrent expenses, and the budget promised $5.2 million over 4 years towards establishing our local future jobs.
So is that
investment
5.2 then out of the 74.5?
So the current balance is 74.5. So that will increase with the $25 million each year. We've promised $5.2 million over the 4 years. So I don't want to mislead you.
As a separate amount?
No, as part of that.
But it's locked up.
amount.
So how does that work?
Doesn't make sense.
Yeah, I know. It's so there is my understanding or my advice is that there is a small amount that we are able to access for recurrent expenses,
Right.
but that the fund is tied up until 28-29 or until the fund matures. But perhaps Ms Beattie might be able to.
Yeah.
She's looking at me eagerly.
It's a little bit complicated. So it's actually $22.5 million that is put aside each year in the statutory fund.
Okay.
And then there's $2.5 million in recurrent expenditure that is available for operational costs.
Okay. And that operational cost, presumably that's operational for that fund rather than for these authorities. So how did we do that?
So we are directing that fund to be spent, and as I said earlier to Mr. Buckingham, who was asking me some questions in relation to the future jobs and investment authorities, I've asked the Department of Regional New South Wales to set up a specific unit that's going to be responsible for administering the authorities or for working with the authorities. So as they do that, we're using some of that funding towards that.
I was listening to the answers that you gave the chair earlier in relation to those authorities. It strikes me that there is a disconnect between what the authorities are that are being sort of, are in progress versus what is commonly called a just transition or transition authority is that the communities have been calling out for some time. During the election, Labor made a commitment, for example, that in the Hunter they would have a transition authority on the back of at least a decade of work by communities
unions and universities and a whole bunch of other people there to create what that sort of would look like. Are you concerned, firstly, that it seems a bit slow, that we're getting this thing, but also that it doesn't look like we're on track to get that kind of transitional authority for the hunter?
Yeah, I mean, as I said earlier to Mr. Buckingham, we have one chance to get this right. And I accept that there's been lots of work done by local communities, and we want to be able to tap into that expertise. That's certainly why I've been travelling to hear directly from communities. And the thing that really struck me from the Hunter Roundtable was the enthusiasm and the number of ideas. This is a region that is genuinely thinking about the future. There's lots of opportunities, and I mean, my reflections afterwards would be that the authority kind of needs to harness that and find ways that the government can bring those ideas together and enable them. That might be a slightly different approach that is taken in other parts of the state, but as I've said consistently, we want to work with communities to solve these problems. The enthusiasm in the Hunter, those opportunities, that work that's been done, we want to be able to work with them to do it. Whether the expert panels are the appropriate mechanism for that, that's really what we're working through at the moment.
So I think the frustration from the Hunter, and again, you know, as you say, they're enthusiastic, but they're also incredibly well up the curve when it comes to what a transition in the Hunter would look like. And community groups have come together, again, for, 10 years to develop that and to work towards that transition. What they're looking for now is the funding to be able to implement that strategy. I'm hearing that the royalties for rejuvenation funds have been locked up still. What can we do to, I guess, harness that in real time rather than waiting another 2-3 years for these things to be structured? It's happening now on the ground and they need it now and they're ready to go. Is there any way that we can deliver them some funds?
We are working through those exact questions. We're asking those exact same questions ourselves, which is if there's a pool of funding there and it's tied up until 28, 29 or until the fund matures, is that the best use of money? Like, I think as we work through this process of what our local authorities will look like and whether accessing those funds earlier might be more appropriate, these are the kinds of things that we are considering. We're talking to local communities. In addition to holding the roundtable, I've held several meetings since with different organisations from the Hunter Jobs Alliance. I know they've done a lot of work on that. And we really want to be able to partner with communities. We don't want to recreate the wheel. The other part of it is, as I said earlier, the federal net zero authority and how we can work in with them. There is no doubt that we want to be able to make sure that government is working together in partnership with the community, and we don't want needless duplication. That's not going to help.
But I guess the lesson that we have learnt from overseas and from where transition has worked well is that if we listen to community and we build these transition structures from the community up rather than from that sort of top-down approach, that's where we get the best results. So I understand that there is work being done at a federal level. I understand that we have now this state structure, but what we have at a community level is communities ready to go. You could be funding and establishing those local transitional authorities in those regions much quicker, and we will all benefit from the economic results and from the community results down the track. I guess what I'm putting to you is it looks like the government is actually being a bit of a handbrake on this now. The community is ready to go. Will you look at more urgently, I guess, setting up the transitional authority that the Hunter are asking for?
Can I just say we are working on this every week. There is conversations that are occurring. I know that within my office every day that they're working on this. We absolutely understand that sense of urgency, and I know that since we've been here last and you were asking me these questions in relation to that sense of urgency, I know Meg has been working on this as well. Part of what we have done in setting up the dedicated unit is, as we do that consultation with communities, is actually making sure we've got the public service capability there. A key part of how I see the authorities working is using and making sure that government, as you say, is an enabler and not a handbrake. So there are significant questions in relation to what are the opportunities on these mining sites as they close, are the current planning arrangements fit for purpose? Are we providing for more jobs? I mean, the classic case, and I've spoken to you and in the House about the Mount Arthur site, such a huge site with almost, I think it's 2,000 jobs located so closely to a significant regional town.
That's why we need it now.
We want to find, I mean, but I would say this, the existing planning approval for Mount Arthur goes until 2027. I know they've lodged an extension to 2030.
Yeah, but it's not
That's
just...
the first of those. Sorry, that's going to be the largest mine. I think we can do some pilot work around there.
And I appreciate the focus on jobs, but the transition authorities that have worked really well in other places have focused at a much broader level as well on community services and other things. I'm also frustrated because when we talk about, this structure of jobs and investment authorities being almost like a handbrake at the moment, is that when I go and talk to, for example, Minister responsible for skills and TAFE, or I talk to any ministers across the government about what they're doing to assist with transition and making sure we have a nimble workforce and that communities are supported during the transition, what they say is, oh yes, we're doing this thing at this, this jobs and investments authority level. So again, everyone's waiting. It's like everybody's waiting in the government for this to happen. Is there work being done to coordinate in the interim?
Yeah, absolutely. Absolutely. I mean, one of the key
doing that,
challenges.
and how does that happen?
I am, and my department is doing that. We're working with our colleagues. I mean, in relation to skills, absolutely, I'm working really closely. I'm delighted. We've now got Minister Wan in the cabinet dealing with TAFE. But as I think I said to you when we last met, the challenges within TAFE just to get that onto an even keel are huge. So I wouldn't say that we're waiting. I would say that we are working with community. We are absolutely committed to doing this. The skills part is going to be a really big part of the component, and we want to find opportunities. But when we find ourselves in a situation where the previous government sold off TAFE sites in that Hunter Valley region, in Scone,
I agree. You've got catch up to do. Yeah.
We've got a lot of work to do. So, but we are absolutely working collaboratively and across government to make sure that we can all work together to solve this problem.
I'll just ask a few questions and then you'll have more time, Ms Boyd. Just following up from Ms Boyd's questions on that. So the royalties for rejuvenation, the majority of it has been set aside in a statutory fund until 28-29. What is the statute under which that is set aside?
Let me see if I've got that written down here. I'm not sure if I do. Perhaps the CEO.
Yeah, it's established in the Mining Act.
Okay.
So why wouldn't you, Minister, just amend the Mining Act to enable us to access those funds sooner rather than later?
We might be considering something along those lines at this time, Mr Buckingham. Look, I have to say, this is it's set up under the Mining Act. There are certain requirements that are in the legislation. There are other steps that we can be taking in the meantime, and we are just pursuing those options. As I said to you, we are working on this. It is a high priority for the government because we understand that if we want to actually plan for the future, we have to get those supports in place early, and we want to be able to work with communities to do it. So yes, that's a very good suggestion from you, Mr Chair.
Well, that's good to hear. I met with the Minerals Council recently, and they were making representations regarding these transitions. And one of the issues they raised was a legacy issue of consents around mining rehabilitation, and the fact that many of the consents they have require a particular mode of rehabilitation or remediation, which they put, and I have some sympathy with, is outdated in that it requires a return of the site to a particular use, and also the removal of a lot of infrastructure that has enormous value, hard stands, water pipes, electricity infrastructure, fencing, which may have some other use. How do you respond to that? Is that a key consideration, especially around the issue of Mount Arthur, 2,000 jobs, a lot of valuable infrastructure there? is that something that you as a minister are considering and will respond to in due course?
Absolutely. This is one of the key challenges that we face as we plan for the post-mine land use of some of these key and large mine sites across the Hunter Valley. I'm really excited about some opportunities that we can that we might be able to trial on Mount Arthur. Now, I know BHP is consulting or may have just concluded its consultation process with the community. For example, there they've got such a huge void, there might be an opportunity to do pumped hydro in the void. But the point that the Minerals Council raised with you, and I have to say, tribute to the Muswellbrook Mayor who raised it first with me and the then opposition leader, the idea that you have existing infrastructure on a site. I mean, Mount Arthur is a great example because it's located so closely to Muswellbrook, and the current, you're right, planning and consent requirements require it to be returned essentially to virgin grassland. We want to be able to find, it is logical, and I believe that we want to be able to find job opportunities on that land. And when you have existing infrastructure, the idea that the existing requirements require you to actually remove all of it, it just doesn't seem logical to me. Now, there are some benefits that would be for BHP in not having to remove that infrastructure. We need to work through that. But there would also be some benefits for the community potentially in retaining that. So these are really complex issues. The other thing is that it's likely, given the size of some of these sites, that it's not one uniform solution. So as I said, for Mount Arthur, it's good to, I find it easy to speak in specifics. So for example, at Mount Arthur, they're talking about farming perhaps on one part of the land. They're talking about the potential of pumped hydro in the void. Then there's some other existing infrastructure. For example, the Mayor said that this could be used for domestic manufacturing opportunities. These are all great things, but it's a reopening that consent process is one that would potentially be difficult for the company, but I do believe it would be in the best interest of the community. So I'm really excited about these opportunities. I think that the Future Jobs and Investment Authorities, these are going to be some of the challenges that they're working with. But the point that the Minerals Council made to you, and like I say, the Muswellbrook Mayor has made to me previously, is a great one.
Yes, thanks for that. And I'll just note that the industrial hemp, the nascent industrial hemp industries, and also the medicinal cannabis industries that I've been talking to have put their hand up and saying that these sites, for a number of reasons, are something in terms of advanced manufacturing that they are looking at. But that's just a point I'm making.
And certainly one that you've raised with me previously, and yes. I know you're working with Minister Moriarty on. Yeah. Fantastic.
Minister, the future of gas statement. Look, I just want to get clear in my head how this these reworkings on the strategic statement on coal and future of gas statement, are they going to operate concurrently at all? Is there any opportunity for the future of gas statement, which affects a much smaller industry, in actual fact, an industry that barely exists at the moment in New South Wales, for that work to happen sooner rather than later? Or is there a staged approach, critical minerals, coal and gas? Is there a possibility that the future of gas statement could be, again, a document produced by John Barilaro, that could be considered before or concurrently with the critical minerals or the strategic statement on coal?
Yeah, look, I mean, I think I've been really clear that we're going to work through the critical minerals and high-tech metals strategy first in relation to whether the future of gas or the statement on coal, whether they can happen concurrently or whether that would happen consequently. We haven't taken a decision on that yet, and that's certainly something that I just, in consultation with the department, just sort of work through. I take your point. I mean, gas exploration is only permitted in 1.5% of New South Wales under the existing statement, and it is somewhat smaller. But we just haven't made those decisions yet.
Okay. Just following up on a further area, I was asking questions about The point of consumption tax on online gaming, how much of it is hypothecated for a specific purpose, and what is the quantum of that hypothecation? So I know that some goes to responsible gambling. Maybe you could take that on notice.
Yeah,
but,
I'd be happy to pass to the Secretary if he can provide you with a specific answer on that.
I have a figure on the line, but we'll check and provide a response on notice. Thank you.
Okay, thank you. That's me done.
Oh, good.
Ms. Boyd.
Thank you. I'll just finish off my questions in these 2 minutes. I'm going to do it. Minister, I just wanted to quickly talk to you about the shared equity scheme. I understand that it was widened to cover domestic and family violence victim survivors in December after that process was gone through. With DV New South Wales and others, which is great. Can you tell me, I guess, how does it work, and given what the sort of criteria for it are, but also given the criticisms of sort of low uptake under that scheme, what you think that scheme is looking like now with that broader cohort of people?
Yes, I'll try to be quick because I know you want to get through your questions. Yes, there has been quite a low uptake of the scheme as a whole. We did commit to expand it to domestic violence survivors, and I really want to thank Revenue New South Wales for the important work they did in relation to making sure that that process wasn't traumatic for the survivors themselves. There has also been a low uptake in the survivors, but my understanding is that that's also because some of the people who have applied under the domestic violence category may satisfy the other requirements.
Right, okay.
So rather than putting them through that particular part of the program, they have just gone through the original program. But the pilot does run out in June. We're going to take a really close look at it. Obviously, the federal government has introduced their own scheme, so there's more work to do in this space.
When it was first announced, I expressed concerns about how someone would be able to prove that they had been in the sort of the difficulties of that process when it came to domestic violence victim survivors. How has that been addressed in the scheme?
So that was a very sensitively handled, and I have to say the consultation work that Revenue did, quite a lot in detail. I mean, I'm happy to pass to Mr. Johnson to give you an answer now or this afternoon.
Yeah, I'll ask you one quick one in this last 3 seconds. Stamp duty exemptions for domestic and family violence victim survivors when they... I understand that at the moment you can get an exemption if you've got a divorce certificate, but it's not as easy for anybody who's just, who's had a breakdown of relationship for other reasons. Is that something that you've investigated or looked into to make it easier for women to stay in their own home?
Can I come back to you on that? That
Thank
sounds
you.
like a really interesting idea, but I just want to get some advice and come back to you on that.
Thank you.
The opposition.
Thanks, Chair.
Ms. Mitchell.
I just want to come back to the royalties for Rejuvenation. So can you just clarify, Minister, I think you said before you've got $5.2 million allocated over the next 4 years from that program. What's that for exactly?
Yeah, so that is at this point allocated as recurrent funding. Sorry, let me just get to the right spot here. So, that is funding towards establishing our future jobs and investment authorities.
Right, so how does that play in with the panels that have already been set up under the fund? Are you creating a whole new structure?
No, as I said to you earlier, we are considering what the role of the expert panels would be in the creation of our authorities and how the two will work together, or we haven't made any decisions in relation to the expert panels and the authorities.
So why have you set up local authorities if you've already got expert panels?
No, so we committed to, in the election, setting up local future jobs and investment authorities. Your government set up the expert panels and appointed them.
But why do you need two
November.
lots? I don't understand.
Well, that's exactly what we're working through at
So
the
you're
moment.
going to get rid of the panels and have your authorities, is that the plan?
No, that's not what I'm saying. We are working through what the structure of those local authorities looks like. We haven't made those decisions yet. I look forward to being able to answer your questions once we've worked with the community on those decisions.
Okay, so
what we have done is set up the delivery unit within Regional New South Wales that at the moment is coordinating our consultation, and then we'll work through once we establish the local authorities.
But the 5.2 million is basically on the admin and the costs to set up your new authorities, even though you've got existing panels.
So the existing panels are there because they were appointed by your government
So,
under the
but
legislation.
you just said before they're very, that they were great people providing that advice. You were
I said
quite
that they
positive
were
about it.
committed locals and we were working
So why not just
through-
keep them? What are you doing another lot of admin for?
So what we are doing is we are working through and working with communities as to whether the structure that you had in place, how that marries up with our election commitment. We are, as I've said, working through this carefully. Your government appointed these people to expert panels, and I respect the individuals that are on them, but it's prudent of us to just check whether they are fit for purpose and match up with what we want to do in relation to the local investment
With respect,
authorities.
Minister, you've got communities at the moment that are, facing imminent closures of their mine. Gloucester comes to mind as a very real example, who would like to probably have the admin sorted and just start to get on with seeing some benefits from this fund. I don't understand why you feel it necessary to recreate another layer of bureaucracy when you've got communities who aren't getting any support. What do you say to people of Gloucester? Have you been to Gloucester? Have you met with that community in terms of your consultation?
Great place.
It is a great place.
I have
My
been
brother-in-law
to Gloucester.
lives in Gloucester.
I've been to
as
Gloucester
minister?
many. I've been
Have
to
you been as
Gloucester
minister?
many
Have you been as
times.
minister?
No, I haven't
responsible
been.
for- Would you commit to going and meeting with Dave Lazell and some of the local community members to talk about these issues?
Well, you've asked me about 6 questions in a row there, Mrs. Mitchell, so let me work through them. I have been to Gloucester on many occasions. I would make this point about the Stratford mine at Gloucester. That was closed, I think it was operated by Yancoal, and they, again, have a really interesting proposal around a pumped hydro
That's great,
scheme.
Minister. I'm
But
asking you
Mrs.
whether
Mitchell,
you've been,
well, Mrs. Mitchell,
and would you go with the local member and meet with the community?
Let me give you an answer to your question, and let me say this, that mine was slated for closure for a long period of time, that you were in government.
Point of
You
order, Chair. I'm
appointed
asking
those
questions about the
expert
current
panels
budget.
in November.
Point of order. I'm moving a point of order, Minister. I'm asking questions about the current budget. I'm asking the current Minister whether she will go to that community with the local member and meet with them, talking about what happened under the former government is not within the remit of these estimates hearings.
I think there's some wide latitude given to witnesses to answer questions, and I do think that in the context of the questions that you were putting to the minister's answer was entirely relevant. So I don't know if
I do have limited time though, Minister, so as you would know. Will you commit to keeping the expert panels?
I have been really clear from the outset, which is there are really committed locals on those expert panels. We will work through as we establish a future jobs and investment authorities about whether the expert panels are fit for purpose and relevant for those local communities, but we haven't made any decisions
so that's a no.
in relation
Thanks,
to
Minister.
that. No,
Could
do not
you-
verbal me.
Well,
I
no,
have
I
not
said will you
ruled
commit,
that
and you
out.
said you're looking at it all. So that's not a commitment that you'll keep
no,
them. I want to turn now to the issues around the statutory, the independent review. You're doing into the small scale titles that you mentioned before.
Yeah.
On the website into the review, it says that the issues paper was released following consultation with key stakeholders. Which stakeholders were consulted with?
So this is a review that is being run through the department.
I'm asking you what stakeholders were consulted with.
So this is a review that was established and is being run through the department. There was an independent process in place there to commission that work. In relation to the consultation, that is being done by the independent reviewer and by, I'm going to get this name wrong, Norton Rose Fulbright.
Yep. So, Minister, can you tell me what public consultation has occurred so far?
Well, that's in the remit of the independent reviewer.
You're the
who
Minister,
is
don't you know?
That is the remit of the independent reviewer who is doing that work at the moment. I'm not doing the review. I have asked the department to commission an independent review. That reviewer is doing that work and in the process is consulting with the community. My understanding is that they have visited both Lightning Ridge and White Cliffs and that they were meeting with a range of stakeholders out there. But in terms of the actual consultation process, I'm not undertaking that. The reviewer is undertaking that work.
Okay, thanks, Minister. Are you aware of concerns that farmers have particularly in places like Lightning Ridge, that there's potential for mining to expand outside the current boundaries and onto land that is currently used solely for farming?
Yes.
What do you say to some of those farmers who are worried about potential biosecurity implications of having people coming onto their properties for the purposes of exploration?
So they were absolutely the concerns that the farmers raised with me when I went and travelled out there in, I think it was May last year.
So what have you done since then?
So they raised with me concerns around biosecurity. They also raised a number of other concerns. It was clear at that time that there needed to be a whole-scale review. That's why I came back and asked for an independent review to be commissioned by the department. And that is what they are doing. They are working through these issues. I'd like to thank the farmers who have already made submissions to that. I understand that the reviewer went out to Lightning Ridge and to White Cliffs and met directly with the community, including with farmers and landowners. There is a range of things that we have put in place to clean up the mess that your government created in relation to opal mining and invalidly issuing
the
mineral
particularly
licenses.
in relation to the farmers. Just
Well,
one last
let me be
question.
clear. Your government did nothing
Minister.
in
I have one
relation
last
to addressing
question.
these concerns that they raised with me when I'd been in the job
Minister,
only weeks.
I have one last question. You said you've been out there and you've heard directly from farmers and landholders about their concerns. Will you provide a guarantee that no new country will be opened up to exploration until the finalisation of the review?
I think that we've put something like that in place already. I think that I've said that publicly already.
Okay, good. Thank you. Good to have it confirmed at this hearing. Hand to my colleagues.
Minister, from October to December in 2023, in your diary disclosures, you met with the unions 8 times, but the Royal Australian College of General Practitioners only once. Is that correct?
It appears that you've analysed my diary disclosures closely. I'll accept your analysis.
Have you discussed any solutions with the GP sector to address retrospective payroll tax?
I have met on multiple occasions now with the RACGP, with the AMA, with individual practice owners in order to work our way through this issue.
And according to the RACGP, only 3% of practices across the state would have the money available to pay a backdated tax bill. Do you agree with that figure?
Well, I mean, I take them at their word. I'm engaging with them. My office is engaging with them. The Minister for Health is engaging with them as we try and work our way through this complex issue that has been running, long running, Mr. Rath.
So currently as it stands, can auditors from Revenue New South Wales demand that GP clinics across New South Wales pay retrospective payroll tax on the 4th of September 2024?
So I made an announcement, and I'm just going to get the exact date for you, in August, to provide certainty to the sector that audits would be paused. We passed the legislation through the Parliament. We legislated that 12-month pause to payroll tax audits on GPs. I would expect that was being enforced by Revenue New South Wales.
But that will come to an end on the 4th of September 2024, won't it?
Yes.
So, but only 3% of practices can afford to actually pay their payroll tax bill. So what do you expect them to do after that time comes to an end?
Well, no, Mr. Rath, that's a serious... Yes, it is true that the audit will come, the pause will come, will end on the 4th of September, but let me just provide you with some of the history of the issue. This is a long-running issue that dates back to 2018, and since the very first days of being sworn in as a minister, I have been working on this issue. I have met with the RACGP, I have discussed this with the Minister for Health, I have met with the AMA, I have met with individual practice owners, I have met with regional medical practice owners. We are going to find a solution to this problem that your government, indeed your colleague sitting next to you, failed to deal with for 5 long years. What we have done during our time in government is met with doctors directly and engaged with them and tried to come up with a solution. What your government did was chase them through the courts, and indeed when he was the finance minister, Mr. Tudor-Hope didn't meet with the RACGP or the AMA at all to discuss this issue.
So Minister, when this was before the Legislative Council, you stated that
Maybe
the
that's not
government
true.
would look at what steps other jurisdictions have taken to address this issue. Are you aware of the Queensland Government's model?
Yes, I am.
And in Queensland, they've basically brought in a 5-year amnesty. Would you commit to a scheme like that in New South Wales?
I won't commit to that today. I do understand that retrospectivity is a huge concern to GPs. They have raised that in their conversations with me. They have raised that in their conversations with the Minister for Health. We understand that is a crucial point that we are trying to address, but we are working through this issue to find a solution, Mr. Rath. Let's be clear about that. Your government, when you were in government, did nothing to resolve this except chase doctors through the courts.
But you also voted down our amendment in the Legislative Council to provide that amnesty, so it's all well and good to talk about the history, but in a more recent example, you voted against a solution that the opposition was putting on the table,
Well,
didn't you?
let's be clear about what the true cause of the pressure on GPs is, and I absolutely thank our hardworking
It's the federal Labor
GPs
government.
for the important work that they do in our communities each and every day, providing primary health care. I deeply respect the important work that they do. They they have for a long time, for over a decade, because of your federal Liberal national counterparts who failed to index the bulk billing rate, which has been estimated to have cost them billions of dollars, are under unprecedented pressure. So because of that situation, we legislated for a pause. Now, the federal Labor government has tripled the bulk billing incentive. That came into effect in November. It was announced in the budget, in their budget in May. It came into effect in November. But we are only starting to see the effects of that flowing through to GP practices. Indeed, that's what they told me when I met with them just weeks ago, that they were starting to see the effects of those changes to bulk billing. Now, the point of the 12-month pause was that we could work through this problem and find a solution in a considered way. Retrospectivity is a key challenge that we have to address. But we operate under a nationally harmonised payroll tax system, and different states are finding different solutions. We are considering those different solutions as we find one in working with our doctors, in working with the community, in working with patients. We want to get the best health outcomes for our community, and I'm working closely with my colleague, Minister Park, as we find that
And
solution.
in terms of the other states, I mean, don't you agree that the Queensland model is a better model than what we've got here in New South Wales? Why not just implement a similar type of policy?
Well, that kind of simplistic policy approach is not one that I'm interested in. Your government, when you were part of the government, failed to introduce any solution to this.
We put an amendment on the table for you to
So,
consider.
so what we are doing is working through and finding a bespoke solution that's going to work best for the healthcare system here in New South Wales. And we're not just going to blindly implement something that the Queenslanders are doing. That might be working well for them, and I'm certainly we're taking a close look at that. But we're going to find the solution that works best here in New South Wales, supports our doctors, supports our patients, supports our community.
Will you commit to a clarification on what constitutes a relevant contract?
Well, that's central to the work that we're doing.
So you'll commit to that. Will you also commit to no retrospective collection of payroll tax liability?
I just made that point, Mr. Rath, that is one of the central issues that GPs are raising with me.
But you
That
can't
is
commit to
one
it today.
that we are working through. I'm not going to make an announcement here today. I'm not going to work on this on your timetable. We are going to work through this carefully and methodically, as we have been for months. Since I was first sworn in as a minister, we started work on this problem. Now, your government threw their hands up in the air, walked away from it, refused to deal with it, chased doctors through the courts. We are working with doctors and committed to finding a solution for them.
Has your department or Treasury done any modelling on how many GP clinics in New South Wales would become instantly insolvent to meet their retrospective payroll tax bill?
We're working through this problem. I mean, the idea that there's a number of pejorative phrases in that particular.
What, insolvent?
in that particular assertion that you've made. We will of course work through this problem carefully. We will of course consider what the implications are. We're discussing this directly with GPs, directly with the community. I'm speaking to Minister Park about this. We're absolutely committed to finding a solution on this difficult problem that your government failed to address for 5 long years.
And what about modelling on how much the cost of a visit to a GP could rise if retrospective payroll tax was applied to GPs? Have you seen any modelling on that?
I saw the story that ran in the newspaper a couple of weeks ago. Of course, we'll consider the impact. That the impact on families at a time when cost of living pressures are enormous is one of the driving factors in us finding a solution to this problem. We don't want people to be making a decision about whether they feed their family or they go to the doctor. That's the situation that they find themselves in because of your government's inaction, because your government failed to address this problem in any way. So we are absolutely committed to working through it. We'll find a solution, but these kinds of rule this in, rule this out, that's just not going to happen today.
Well, you have been in government for almost a year, Minister, and given you've been in for a year, where is the promised New South Wales Jobs First Commission?
So we have commenced work on establishing that and scoping out the work. We've started work within Treasury on establishing that.
Bit lethargic, don't you think?
I mean, I wouldn't agree with that, but that's your
So
assertion.
when will it start work?
So I don't have an announcement on the time frame today, but I can tell you that we have begun to establish the commission, and we're working towards a timetable of introducing that legislation probably later this year.
Maybe.
And who has picked up the work of the Advanced Manufacturing Commissioner? Does that fit with you or Minister Chantherbond?
So, I mean, I'm the Minister for Domestic Manufacturing and Government Procurement. I'm working closely with my colleague, the Minister for Industry, in relation to ways that we can rebuild domestic manufacturing. I'd certainly acknowledge the important work done by the Modern Manufacturing Commissioner, but it was your government that didn't provide any ongoing funding for that position.
And again, 12 months in power, when can we expect to see the New South Wales Government announce a modern manufacturing strategy?
Well, that wasn't what we took to the election as being our plan. That might have been your plan, but we're not signing on to your plan. What your government's legacy on domestic manufacturing was to decimate our local manufacturing industry. I held a roundtable 2 weeks ago and was told that New South Wales is the least hospitable state in the country for local manufacturing. These are advanced manufacturers who have prospered and thrived in spite of your government's negligence.
Minister, when was the procurement policy framework last updated?
Let me have a look at that specific question. In relation to policy procurement, the policy procurement framework, I would think it was probably updated when I issued my ministerial direction in November, but I'd probably just take some advice perhaps from the Deputy Secretary in relation to that.
Yeah, I'll be able to come back with a date on the most recent updates. Yeah, thank you.
And is the department or minister undertaking work at the moment to update it?
Yes.
Because in the previous government that you so persistently mentioned the record of, it was updated at least twice a year since 2019, but the most recent version that we can see, or at least publicly, is that it hasn't been updated since the 6th of April 2022. Is that correct?
So I'm not sure. I think the Deputy Secretary just said that she would come back with a specific date on that. What I can tell you is that we're not interested in updating the policy framework. We're interested in updating and taking a fresh look at the entire devolved procurement model. That's exactly why, as we've spoken about extensively today, Dr. Kane is undertaking her inquiry. We've commenced work. We've established through work being led out of the Cabinet Office, a whole of government approach to better leverage our procurement. We don't think that the devolved procurement model, as it is operating currently, is the most effective way of the government leveraging its important and precious government procurement dollars, and we will absolutely be updating that.
So, Minister, I think one of the things we've gained out of today is that you've done actually nothing since you've been the Minister except order reviews. But I'd like to know this.
Order.
But I'd like to know this from you.
Take the wage, but
From you,
outsource the
Minister.
Order's been taken.
It's not a question, it's just a gratuitous swipe.
It is. It was a gratuitous swipe, and unfortunately, Mr. Tudor, hope
You got
you
to swipe
wasted
in
your
with
time
everybody else.
making a gratuitous swipe rather than
Well,
asking a
a
question.
statement of fact, quite frankly.
There you go. I have some questions to ask. Minister, you would be well aware that there is an inquiry on foot at hand regarding Ms Fairman has been participating in on the current and potential impacts of gold and silver and lead and zinc mining on human health and other factors. It's due for a response from the government on the 14th of this month, and a lot of people who've long been concerned, particularly with Cadia gold mine, are awaiting that response. Are you aware of the inquiry, and how are you leading the response from the government to that inquiry?
So that I am absolutely aware of the inquiry, and I'm aware that it's concluded and presented a report, and work is underway across government to respond to the recommendations. From memory, I think there are 3 that are directly relevant for the mining portfolio that we will require a direct response. But yes, we are absolutely aware of that inquiry.
Have you visited the Cadia gold mine?
Yes, I have.
Do you think it's a model of responsible mining that should inform potential future mining in New South Wales?
Look, I'm not sure that I would probably defer to the regulator in terms of what is a model for other mining. I certainly went to visit it as Australia's largest gold mine. I understand the long history of the Cadia mine in terms of providing jobs that support both directly in Orange but across the Central West, and I wanted to see that firsthand. I thought that was important. In relation to whether it's a model for other mines, I would probably defer to the regulator for advice on that.
You are well aware of the concerns of a lot of people, that raised concerns before the mine was a reality and during its growth about the impact on air quality in terms of dust and human health. You'd be aware of that now?
Yeah, look, I have to say I am aware also, and it was remiss of me not to mention earlier, Mr Buckingham, your long history in advocating on these issues. I am certainly aware of them. I have to say part of how I became aware of them was in my previous role as country organiser for the Labor Party, but also when I was first elected here. I know that you raised issues around the Cadia mine consistently in the Parliament.
Yes, and on Orange City Council for very, very many years. And would you recommend anyone? Would you recommend to friends or family or to live adjacent to the Cadia mine?
Look, I mean, in terms of the community safety around the mine, that really is governed by the EPA, and I think that was thoroughly tested through that inquiry. I would expect that it is safe for people to live close to mines. We have in our mining system...
Do you think it's safe to live close to that mine?
Look, I think it is. I think that, I know that there's been a lot of community concern around the impact of the mine, and I have to say the feedback that I often get from the mining industry is that the planning and the regulatory framework that they operate within New South Wales is tougher and more difficult and more onerous than in other states. Now, that's fundamentally because we have a different mining system in New South Wales, a different mining industry. Our mines are largely located close to communities, and that means we do have to make sure that there is a rigorous process in place to ensure the community's safety. They have important local jobs and they have an important role to play in sustaining local communities, particularly across regional New South Wales. But the other part of that is we have to make sure it's safe. But those, in terms of my responsibilities as the Minister for Mining, and the regulator's role, it is largely in relation to what occurs on the mine site. The community aspect is regulated by the EPA.
In terms of what's occurring on the mine site, there was a major dam wall collapse at Cadia before your time as the Minister.
Yeah.
Are you confident that that is being properly managed now and can be properly managed into the future, considering that it seems to be there's been essentially the mine wall has collapsed and the tailings dam continues to move into the landscape? Are you confident that the rigorous process you've talked about is going to afford us the environmental protection and community protection that we need in regards to that dam wall collapse?
So let me say, I would make a couple of points in response to this. I do believe we have a robust regulatory system in New South Wales where we have the resources regulator and the EPA working together in order to protect the community and workers. I think that's important. I do have confidence in that scheme. In relation to the specific questions, I think they're probably best posed either to the regulator or to the EPA to respond. But I am confident, and as we formulate our response to the government, our government response to the Upper House inquiry, I would take on board those recommendations in formulating any or making any changes that would be required.
Thank you, Minister. Ms. Fairman.
Thank you, Chair. Minister, we'll stick with the report into heavy metals mining and the impact of silver, gold, lead and zinc mining on the human health and the environment, which, as you know, has reported. So in terms of the findings of that report, that was most of that report was agreed to. Ultimately, the minutes reflect this as a result of agreement between government and opposition members on a range of different findings. What role did you have in advising the government members on that committee of what findings to put forward that would ultimately become the findings and the recommendations that would ultimately form this report?
Yeah, so I did broadly follow the committee's work. I think this is an important issue, and I know that it's one that you've done a lot of advocacy on, Ms. Fairman, in working with those local communities there. I was broadly aware of it, but I certainly provided no specific directions on specific findings or recommendations to the committee members.
Okay, so for example, one of the terms of reference for the inquiry was to look at the effectiveness of current decommissioning and rehabilitation practices in safeguarding human health and the environment. So my question is, which again is reflected in the minutes for everyone to see, why did the Labor members move to remove that entire section of that report that dealt with all of the evidence, had the recommendations and the findings in terms of mining rehabilitation? I mean,
Ms. Fairman, that is really a question for the Labor members on the committee. I think I would make this point. I mean, we've discussed at length the procurement inquiry that I've written to Dr. Kane to establish. I really take seriously the work of parliamentary inquiries. I think they're a great opportunity to unpick complex and difficult public policy issues. I think I deeply respect the process, but in terms of the specifics of how the government members voted on the committee, that's certainly not something that I directed them to do. I understand. I mean, I have read the recommendations of the committee. I've also read your dissenting statements. I understand that that there was a heated debate in formulating that committee report, but that's ultimately a matter for them.
So, look, the issue of silicosis, for example,
Yeah.
which you agree is an important one. Let's go back to that for Cadia, for example. Do you know how many workers have got silicosis that are working in Cadia?
So
Nine?
I'm aware that there are 2 health monitoring events involving historical silicosis, but I think in terms of the specifics in relation to the investigation, it's really best answered by the regulator.
Just in
rather
terms of
than by me.
numbers then, Mr. Day, I don't need to go any more than that. I can speak with you this afternoon.
We've had 3 overall over the years. One was in 2019, and the 2 current ones that are being diagnosed were back in June 2022 and August last year. The one in 2019 wasn't confirmed as silicosis, so it was investigated as a potential one, but hasn't been diagnosed as silicosis.
So again, with these, government members on this committee, we were hoping, and we were hoping to be able to ask questions of the country's leading silicosis expert and treating doctor, Professor Deborah Yates, but one of the government members moved that she not appear before the inquiry. That seems quite extraordinary, doesn't it, Minister? It seems like your government has something to hide when it comes to what is going on within Cadia Gold Mine when it comes to silicosis.
I'm not aware of that particular decision taken by the government members in relation to the witness list. I think, like I say, that's ultimately a question for the government members themselves.
So in other words, that didn't happen. You also weren't aware of the gutting of the report, essentially, in terms of a lot of evidence around the impact that we heard from the community in relation to the impact of heavy metal mining on communities. This report was absolutely gutted by government members. You're saying you had nothing to do with that and you didn't know about it as the minister responsible for regulating this sector?
I would say I have read the final report of I have read the final recommendations, and I took the time to read your dissenting statement. I know that you were very passionate about this issue, but ultimately the committee report is a question for the committee members themselves, and the deliberations are ultimately voted on by those committee members.
So what we've ended up with in terms of this report is a report now that doesn't recommend any improvements to the way in which mines are rehabilitated, the way in which heavy metal mines are decommissioned, which is, I think, absolutely extraordinary, an extraordinary missed opportunity that this is how things have gone in this place for many, many years, is that government members will bring forward solid recommendations that they know that their government can potentially implement. I mean, that's the way it goes. But for some reason, you as Resources Minister were completely shut out. This was an incredibly important report, and now there's no recommendations coming from that. Did it concern you when you read the report and the dissenting statements about why you were shut out of this?
I wouldn't agree with your characterisation that I was shut out. I do think it's an important parliamentary inquiry, and I let that parliamentary inquiry take its course. We're formulating our response to that. But I'd also make this point: legacy mines and the historical lack of regulation around rehabilitation is a concern for me, and it's certainly something that we are doing work on. But I respect the process, Ms. Fairman. I respect that we will respond to the committee report as it's presented to us as a government.
So the process is that the majority of evidence, I think, that would have helped you and your government, and potentially suggested by the community and by experts that this is what is needed in this area, was just, in the end, I think, became completely useless. So let's go back to mining rehabilitation then? So are you saying, in terms of reform, what processes and steps is your government taking? Let's forget the report. I mean, the report does not reflect in any way what the vast majority of members of the community told us. So how now is your government looking at what it needs to do in terms of mining rehabilitation? Because the report in that regard is next to useless. Unfortunately, sorry, upper house committees, you did a great job. We couldn't help what happened in that deliberative.
Yeah, so I'd say this. I mean, there are two separate parts to the rehabilitation requirements. There's obviously historical legacy mines, what we call is legacy mines, and we are left to deal with the consequences of those. What I am confident is that we have a robust rehabilitation scheme in place at the moment, and indeed some of the questions that I answered earlier in relation to the rehabilitation requirements around our coal mines are ones that we should revisit. We want to make sure that they're fit for purpose and that they're working for the community. But the challenge of mining that perhaps commenced over 100 years ago and the lack of regulation around that are ones that we are absolutely dealing with. I'd say this, the total security bonds that are held by the New South Wales government is $3.8 billion for rehabilitation. The mining regulator continues to monitor mines daily to make sure that this rehabilitation is up to date. So I think it's also important that as we discuss this issue, we don't confuse the two. There is a legacy mines issue that we're facing, but there's also then the mining that's occurring
So
today.
with that $3.6 billion, how much is that? How much of that is spent each year on the work of rehabilitating mines?
That's an excellent question that I might just hand over to the resources regulator to answer.
So yeah, it's important to recognise that 3.8 billion is held
3.8
is actually held in bonds as a bond, and it's only used as a last resort. So it's not actually used to rehabilitate ongoing mines. That's part of their current program, and so part of the current regulatory framework for rehabilitation requires them to submit an annual work program and a 3-year forward program so that we can better monitor compliance with that. So that money is not touched for current rehabilitation activities. It's there as a absolute last option in case, say, the company fell over or that we weren't satisfied with what had happened in terms of rehab at that point in time.
Okay, I'll come back to you, Mr. Day, I think, as well. Thank you. I know a question was asked as well. Let's stick with the rehabilitation costs. A question was asked about the Russell Vale colliery in terms of its rehabilitation costs. So I'm particularly concerned about what provisions have been made to manage and assess the ongoing loss of water from the water catchment of that mine, whether there's been any work undertaken by the department and whose responsibility that ultimately becomes, because there's the polluted water, as we know, coming from the mine as well. So is there responsibility here, or is this all going back to the EPA? What we found during the inquiry, in fact, one thing was that responsibility for this did seem to kind of slip through the cracks between agencies, to be honest.
So I'll take that on notice in terms of water management at Russell Vale. I'll come back later on with that one. But in terms of the actual work underway there, in terms of Russell Vale itself, you know, part of the process at the moment is there's a prohibition notice in effect on the site for production. The company still has the option of submitting a response program to address that, to potentially restart operations. Now, they haven't done that as yet.
So a mine closure for that mine has not been prepared then?
They will need to, if they intend to actually formally shut that mine, they will need to prepare a mine closure plan, and that will require some studies that will address the water issues you're talking about, and that will take some time, but that informs then ultimately what has to happen in terms of the rehabilitation at the site.
And I understand that it's unlikely that another operator will take that over. Like, at what point does the minister or the regulator step in relation to Russell Vale and say, you know, we need a closure plan and we need one?
So ultimately, those are commercial decisions, what doesn't change is the prohibition on operations until those safety issues are addressed. So that, I guess that's from my point of view, that's what I can answer. Any commercial decisions are going to be a matter for the company and any other potential companies, but what doesn't change is the fact that that prohibition notice is in effect until someone comes back to us with measures that we would accept as addressing the safety issues.
Minister, what happens then though? Because I can see that the Minerals Policy Institute did a report into mine rehabilitations that basically said in relation to this particular mine and the operators that the company's precarious financial position sheds doubt on whether it can be properly remediated. There's a lack of indicating that there is a lack of commitment to effective mine closure, how difficult it is for any company in terms of the full-on liabilities that this company has. And this is what happens, isn't it? Companies, they close the mines. In terms of any commercial operator taking these mines over with such a massive legacy in terms of how much rehabilitation is going to cost, isn't one of the issues that unless the government kind of does something in order closure, it looks incredibly unappealing to any of those commercial entities that are looking at potentially buying, for example, Russell Vale.
Yeah, sure.
Sorry, Minister. Look, in terms of the commercial viability of the mines, that's not my field, and I obviously can't get
Maybe
involved
the
in that.
Minister should answer it then, because it's a policy decision. Because if you can't answer it, if it's more policy decision.
But in terms of the rehab bond, that stays in place, regardless of who transfers the title over.
Sure, but it's still, this is one of the issues, I think, with mine rehabilitation, Minister, is that it is just very, very unattractive for a lot of the companies to buy as these companies are going under. They're saying, oh, we're waiting for a buyer for Russell Vale. I mean, doesn't something, and again, the inquiry that we did into heavy metal mining, so we had a big, long chapter on this. So has there been any consideration about what the government can do in this regard? Because it's only going to get worse. The situation is only going to get worse. It's not getting better anytime soon.
Yeah, so the question of rehabilitation is one that I'm really interested in and that we've done quite a lot of work on.
You should have spoken to your Labor members in that committee, Minister, before they went in, I think.
Oh, yeah. In relation to the post-mine land use opportunities I spoke about earlier, for example, at Mount Arthur, or at Gloucester, at Stratford, there's different proposals that mining companies are actually looking at doing things like pumped hydro, or perhaps given the buffer zones, there may be opportunities for farming on that land. I think there was something, one of the options that BHP was consulting with was some kind of bird, what are they called? The fly, it's a huge void at Mount Arthur. It's like 4 or 5 different Sydney Harbour bridges or something. And they told me, or maybe it's 3, maybe I'm just over exaggerating now, but they're looking at all kinds of different projects in terms of opportunities for post-mine land use. The challenge that we face is that opening up that consent process can be difficult. You're right to say that the requirements around rehabilitation can be onerous, but I think that's right. We don't want to get ourselves into a situation like we have with many of these legacy mines, where we have the community essentially stuck with the bill. Now, in relation to Russell Vale, we will absolutely enforce those requirements on the company. Just because they've made a commercial decision not to operate the mine doesn't mean their rehabilitation obligations cease. And I've been really clear that we will continue to enforce those. And I can see the CEO of Maggie's keen to add to my answer.
The response, the regulatory framework is very strong for rehabilitation. Russell Vale was due to close in 2025. It's brought that decision early by 12 months, which is a commercial decision for the operator. But the cost of rehabilitation sits with the title holder. And if another operator was to come in, they would take over that full responsibility for rehabilitation. But having said that, we are confident with the security bonds that we hold for that site that in the event that the government had to step in, we are covered for the rehabilitation costs to meet that final end land use of the approved condition.
Thank you. We have time for just one question from the opposition.
Minister, one question. Have you seen any bargaining parameters for the fire union?
He's
Fire
the
issue?
newest member.
Champion.
I
Have
understand
you
you
seen any
joined.
bargaining-
I
You've got to declare a conflict of
understand.
interest.
I understand you joined
I'd like to know too.
the march yesterday,
Solidarity.
Mr. Tudor.
Solidarity.
I mean, talk
have you,
about
have you
a
seen any
road to
bargaining parameters yet,
Damascus.
Minister?
So you've
Have
used
you,
that
have
line
you got
already.
an interest to declare there, Mr.
Have
Tudor?
you
I now
seen?
regret-
Have you seen any? Have you seen
have you got an
any
interest to
bargaining
declare?
parameters, Minister?
Bargaining.
This is a
Oh,
union which
serious
needs a
question.
resolution. Have you seen any bargaining parameters?
I'm not sure. Anyway, I would just say this. I commend the work of the Industrial Relations Minister in establishing
So you
a
haven't.
new
That's okay.
industrial framework that involves us sitting down with our workers
So that's a no.
and
It's
dismantling
going well
your
with fire,
wage suppression that occurred under your wages
So
cap.
that's
It's
a
going to be
no.
a robust system, and I look forward to it.
How do you,
All right,
how
thank
do
you very
how
much.
do you
Thank you
resolve
very
this?
much. I mildly regret allowing that question, but that is the end of this morning's session because we do not have questions from the government.
Oh, we do. Oh,
No.
We do not.
They did it earlier. No, good.
We do not. We had some before, but we have none now. So that concludes the morning session. Thank you, Minister, for attending the hearing. Thank you for your answers. We are finished, and we will reconvene at 2 p.m. for further questioning of our officials. Thank you.
No.
2 p.m. we will recommence the hearing and the inquiry into expenditure in the portfolio areas, Premier and Finance. We'll recommence with questions from the opposition. Mr. Tudor.
Thank you. I don't know necessarily who this question goes to, so it's a bad start probably, but who looks after domestic manufacturing portfolio within Treasury?
That would be me, Mr. Tudor-Hope.
Thank you, Ms Campbell.
Yeah, the microphone.
Thank you.
Mr. Tudor-Hope, just bring it a little closer.
So, in relation to that aspect of the Minister's portfolio, how many full-time employees are allocated to that section of the Minister's portfolio?
So, Mr. Tudor-Hope, we are working within the current New South Wales procurement team on supporting the Minister with her election commitments.
Yep.
But we have reprioritised work across the team to be able to provide advice to the Minister on those specific commitments.
But there's no staff which are
Correct.
separately allocated, just you are the domestic manufacturing team, so to speak.
Currently, yes, Mr. Tudor-Hope.
No, I understand that. So there is a process, and the Minister alluded to the setting up of the New South Wales Jobs First Commission.
Correct.
And have we allocated or at least done some modelling for a budget in relation to this establishment of the commission?
We have.
And in relation to that modelling, how much have you set aside for the purposes of the establishment of the commission?
So those are decisions yet to be made by this government as part of the upcoming budget process, depending on the operating model.
Okay, well, so in terms of the preparation of the operating model, are there various iterations of that model?
Yes, they are. We have benchmarked different models across other jurisdictions, Mr. Tudor-Hope, and provided that advice to the Minister for the purposes of decision making to inform the upcoming budget.
So, in relation to those other jurisdictions, which ones specifically are you looking at?
We've looked all across the country, Mr. Tudor-Hope, Victoria, Queensland, South Australia, Western Australia. And we are looking to identify what has been working well and perhaps what may not have been working so well in terms of forming that advice.
And for the purposes of setting up the commission, how many FTEs do you expect will support the commissioner?
That's still a decision for government, Mr. Tudor-Hope.
Okay. Just so for the purposes of where Treasury sits in all this, what does Treasury understand the term of domestic manufacturing to mean?
Yes, so obviously this will be part of policy development, which hasn't yet been approved by government. You'd be aware that there are existing policies that do deal with local, such as our SME and regional business policies.
Yep.
And obviously we will be having regard to free trade agreements in terms of a definition of local that encompasses Australia and New Zealand.
So is that the definition that you're currently working on for the purposes of identifying domestic manufacturing, Australia and New Zealand?
Yeah, we're working on policy proposals to take to the government for their decision.
Good. So if I can next, and it's probably again you, Ms Campbell, that's, if it's not, I'm sure you'll flick to the right person. In respect of the procurement policy framework, you would have heard some questions which were asked before lunch in relation to that, because I think on the website it says that new board directions and government policies are published on a regular basis. The procurement policy framework is reviewed a few times a year to incorporate new requirements. Now, it was last updated in April 2022.
That's correct.
Since that time, of course, we've had the threshold for SME and regional procurement policy raising from 150 to 250,000. That was 3 months ago.
Yes.
However, the framework still hasn't been updated on the website. I just, in terms of, I suppose, the policy position in respect of that, it would be confusing for people who are or agencies who are dealing with the government if it's not updated.
So those agencies will all be subject to the Procurement Board directions that have been issued. There's been 6 in recent times. The procurement policy framework itself is currently being updated, and my advice is that that will be published this month.
Good. So this month
March,
it'll be
correct.
updated.
Yeah.
Good. So just if I could, you will be aware of the reference to the Social Issues Committee of Inquiry and the Government Procurement Policy.
Yes.
And that's to report by the end of July 2024.
Correct.
Is there any concern by Treasury in relation to the potential of the inquiry to develop recommendations in relation to procurement policy which in fact currently stagnate the work of procurement? Because there may be recommendations that inquiry makes which would cut across current procurement policy.
I think, we have facilitated a whole of government submission to that inquiry, which you may have seen. We would be looking
Are you currently operating within that whole of government submission?
Yes.
Is that the current policy
framework?
whole
of government submission is factual, correct.
And that's
Mr.
the current
Tudor.
policy framework?
Correct.
Yeah. In relation to the updated board direction on skills, training and diversity in construction, which was issued in August 2023.
Yes.
What are the main updates from the previous version of this directive?
That is a good question, Mr. Tudor-Hope. I was looking at this myself yesterday.
I'm disappointed you were anticipating my questions.
I'm just well read, Mr. Tudor-Hope.
That's all right.
I believe it is really reflecting the position that's been in place, but I might have to take that question on notice as to the specific differences between the previous position and the updated one.
Well, it appears to do a couple of things. It does appear to report on the number of women in trade roles.
Yes, correct.
That appears to be one. And it reports on the number of women in non-traditional roles. For example, training and management guidelines would seem to suggest that there are reporting ability for non-traditional roles for women.
Yes.
So, is the updated policy issued in August still refer to the 2019-20 infrastructure commitment of 97 million by the previous government? That's in the current document, in the current version of your August 23 policy refers to the infrastructure commitment of $97 million. It's more than that now, isn't it?
Can I just clarify, Mr. Tudor-Hope, are you referring to the Procurement Board direction or the policy?
No, the updated policy document issued in August 2023.
So
it makes reference to a infrastructure commitment of $97 million. That figure is incorrect, is it?
So I say two things. The policy responsibility for this sits with Infrastructure New South Wales and Department of Education in terms of the skills for the construction sector.
Right. Yep.
And as you would be aware, the budget numbers will change with each budget and half-year review in terms of the infrastructure spend.
Yeah. Okay, I just wondered whether the Minister had seen that board direction before it was published.
It would have been provided to her, Mr. Tudor-Hope. Yep.
Mr. Campbell, under PHD, and this is again a Procurement Board Direction 2023, April, mandated registration of all New South Wales government suppliers on the Buy New South Wales Supplier Hub. It says this, that if an international business wishes to do business with the New South Wales government, it doesn't have to supply an Australian ABN. There's a simplified registration process which must be completed. The kicker is this, the business will not be included in the all of government supplier list. Is that your understanding?
That's what the direction says, Mr Tudor-Hope.
Well, so if an international business registers using the simplified process but is not included in the all of government supplier list, how would agencies be able to identify them?
I might have to take that on notice, Mr Tudor-Hope, but Supplier Hub, as you'd be aware, is a self-registration portal.
Yeah.
It doesn't necessarily lead to work with the government, and it doesn't mean that those suppliers are necessarily on a scheme or a panel.
Yeah, but it is a portal for the purposes of being able to match agencies with suppliers, is it not?
Agencies can absolutely use that portal to search for suppliers, and there would be other tags through the New South Wales Supplier Hub that would enable them to identify suitable suppliers for the services that they are looking for.
Yeah, but it appears though that if you're an international business, without an ABM you could register, but you just don't get listed on the Supplier Hub.
Yeah, I think that's a question of interpretation, and I'm happy to take that on notice.
Okay. Well, I just wonder whether this was a deliberate attempt to favour domestic suppliers by creating a different procedural.
I don't think that was the intention, but this was a recommendation brought forward by Department of Customer Service, who managed that supplier hub, and the intent behind it, as I understood it, was largely for transparency for all suppliers who do work with government to be registered via that portal.
Yeah, but if I can't see it, if I can't see them, my registration might be there, but if I don't get any exposure, it's unlikely that I will be potentially contacted by an agency to provide opportunities for dealing with those international companies, is it?
I understand the question, and I'm happy to take that away and consult with
Well,
the
I just
Department
wonder,
of Customer Service.
If in fact they are not there, if they have been excluded deliberately, that would be a problem for our obligations relating to international...
I don't believe it's a deliberate exclusion for that purpose, Mr Tudor-Hope.
Good. Now, revenue. No, but waiting anxiously.
As are we.
No, in fact, the foreign surcharge issue, which we had some discussion about before, and I take it that the Minister would have been briefed as part of the incoming Minister's brief? Would have been included in relation to that issue?
Yes, I'd imagine that would have been correct.
Correct. At that point, how many taxpayers had refunds?
Would have been zero.
What was that date, Mr Chair?
Well, the election was in March 2023, so in March 2023, how many refunds had been made by Revenue New South Wales in respect of purchases?
Yeah, we'll take... So, just give me a moment to look at my timeline of... Yeah, so I'll confirm, but it was likely zero.
Yes.
Yeah.
And in fact, and correct me if I'm wrong, I thought that potentially the policy decision at the time was that the issue had been identified and Revenue would be waiting for applications to be made
Correct. That's
for
right.
that refund, and would make a decision based on individual applications being made.
That's correct,
by
Mr.
taxpayers. Yeah. So, was the Minister briefed in relation to that as a policy position?
To my recollection, we discussed this as an issue, as the decision we were arriving at, and at the time we were developing the process to work through how we would provide a refund.
Well, did we have any discussions with your Victorian counterparts in relation to how they were dealing with it?
regularly speak to the jurisdictions across the country. We let them know what we were doing. We weren't. It was a decision for the for the Chief Commissioner, State Revenue in New South Wales to make, as opposed to what the Victorians or others were doing. But we absolutely speak to them like we do around any matters.
And you were aware that they were taking the view that they would not be refunding?
My recollection at that point, they were interested in our position and considering their options, but I can't speak to how or
So
when
were
they
you
made that
actively
decision.
involved with any discussions with the Commonwealth in relation to potentially amending Commonwealth legislation so that the state tax would be excluded from the International Tax Treaty?
I might get Mr. Smythe to answer,
I'm
but
sure
he's itching to speak, I think, Mr.
I thought he might be.
As you'd imagine. We did have conversations with officials in the Commonwealth about the issue, absolutely.
Well,
In respect to your specific query, no.
you didn't have any discussions?
Not about changing the International Treaties Act, no.
It was always potentially open to amend the Act to ensure that the international treaties did not include state taxes, was it not? Did it ever cross your mind that that might have been a prudent thing to do?
That's just on that. I think the first part of that question was seeking an opinion of the official.
The second.
It's always open for a legislature to go back and change the legislation in accordance.
Well, you're now aware that they in fact have done that.
Correct.
No,
Oh, they're in
I'm
the
aware
process.
that they've introduced a bill
Correct.
into the federal parliament, but
Well, it's passed the House of Representatives, has it not?
that's correct.
And it's currently on the notice paper to be debated, I think, next week by the Senate.
I believe so.
And the impact of that will be to, in fact, excise state taxes from international tax treaties.
Effectively, yes.
And in fact, we'll have retrospective application, will it not?
That's correct.
Have you briefed the Minister in relation to the impact of that Act?
As to how the legislation would operate should it be passed?
Correct.
Yes.
And in those circumstances, when did you proactively make a decision to seek out taxpayers to offer refunds?
This was March 2023. March
So,
last year.
did the Minister know that that was the policy position of the government at the time? So when you made the decision to proactively make refunds, did you brief the Minister that that was
Our
going to
position.
be the revenue position?
Yes, we did.
Did you brief the Minister that potentially you could seek an amendment to the Commonwealth legislation?
We had a discussion about how the interpretation of the law at that time, which was that we were collecting tax from these people and it was unlawful. We gave background to how this came about and the connection to the international tax treaties. Discussion from my perspective was more focused on the current state, the fact that this legislation was that's currently before the Commonwealth Parliament was that's come some months after our discussions.
Was it suggested to the Minister at any stage that, in fact, there may be other remedies other than proactively refunding the surcharge due?
My recollection was the discussion was that our interpretation of the law as it stood was we needed to make a decision, which we did, and act on it. Now, if Commonwealth laws were to change that would have impacted that in the future, that would be something we would deal with when it did.
You're aware, of course, that the provisions of the Act have retrospective effect and would, in fact, have covered any taxes which had already been levied, which would have obviated the need to refund the surcharge duty, would it not? If the legislation is retrospective, the obligation to refund is vitiated, isn't it?
But that's not currently the law.
But as of next week, it might be.
Point of order. That's a hypothetical question.
It's in the legislation.
Yeah, I hold the point of order. It is a hypothetical.
If the legislation is
have
passed,
another 20 minutes.
If the legislation is passed, the need to have repaid any of this money will have been obviated, would it not?
If I might, this is a. I don't want to descend into bureaucraties or anything similar. However, we have to deal with the legislation as it stands at a particular time. Now, for us to retain funds that are not the funds of the people of New South Wales would be somewhat similar to detenue of property, right? So an unlawful, just as if it was, say, your funds and we were holding it and we were individuals, of course you could sue me for the tort of detenue.
Well, probably you have. If I had asked for it back and I didn't give it back, it would be detenue.
That's correct. And so the issue then that we would have is once we've reached the conclusion that we are not authorised under law to collect the funds, what do we do with it? And it would not have been appropriate for us to retain those funds on the off chance that sometime in the future the Commonwealth Government might amend a piece of legislation that is almost 70 years old.
Well, the Victorian government took that view, did they not?
That would be a question for the Victorians.
Government, but on the face of it, it appears that they took that view. Is it not the case?
I think that's a fair assumption.
Yeah, but there are cases where you have collected revenue from taxpayers where, subsequent to judicial decision, you've held that revenue until such time as there's been a judicial decision.
That's correct.
And you don't think yourself open to a charge of detenue in relation to that, do you?
No. So in those circumstances, though, we're entitled to rely on the Tax Administration Act that allows us to. It provides any taxpayer who's dissatisfied with an assessment to object, and if they're unsuccessful, to take that matter through the courts.
And in fact, that's the normal process, is it not?
It is. However, if they don't avail themselves of that opportunity, then we are entitled to rely on the administration of the law at the time that we collected revenue. The issue with surcharge is it's to an extent taken out of our hands because it's a constitutional issue. And of course the problem there is not one necessarily of legislative interpretation. It's really a question of were we ever entitled to collect the funds? Not did we collect something we were entitled to, however we interpreted the legislation incorrectly.
Well, the moot point may have been, though, this, and which could have required some sort of judicial intervention, was a state tax of this nature covered by the international tax arrangement? That was a decision which you could have taken the view, I'd like some guidance from the court on this.
Theoretically, yes.
Yes. And it may be that was the position that Victoria took, may it not?
Possibly.
You'd have to ask the Victorians.
That is seeking an
opinion. Well, I've got the answer. I've got the answer on it.
So.
You sometimes get answers surprisingly without them. In any event, can I ask you this? Is there any scope for reassessing these taxpayers once, if this law is passed, is there any scope for reassessing these taxpayers based on the retrospective provisions which are, as you've seen, contained in the Act?
I think, Mr. Tudor, we would have to wait and see what the final form of the legislation, if any, that's passed by Parliament, and we'd be
Well,
able to answer that question at that
Well,
time.
in its current form, if it is passed in its current form, is there any scope for revenue to reassess those taxpayers based on the New South Wales legislation? Now that you have in fact refunded it, can you reassess them on the basis of the retrospectivity provisions which are contained in the amending Act?
I think that's a hypothetical question. It'd be very difficult for me to answer.
Really?
Point of order.
Mr. Narrabri, on a point of order.
Chair, I don't think Mr Tudor Hope is asking a question that goes to government policy, which is what the question should be geared towards with respect to questioning public officials.
Yes, I uphold the point of order for that reason, and also because it is again a hypothetical, as Mr. Smythe has said.
So will you obtain advice after the passing of this Act, should it pass, as to whether you can recollect that tax?
So we'll consider the position assuming that legislation passes, we'll advise of our position on how we will treat retrospectivity.
The Minister gave evidence, or maybe you gave evidence, Commissioner, that the opportunity to make a claim for a refund of surcharge duty finished at the end of November. Is that correct?
The date was set of 30 of November for people to lodge a claim for a refund. On some limited circumstances, we've accepted them after, particularly where someone was clearly unaware or...
Why would they be locked out after that date? If they were entitled to a refund on your view, it is money which you form the view that you shouldn't hold. Why would they be ever locked out of claiming back money which didn't belong to you?
So I would say we haven't locked anyone out,
Well,
Mr Tudor Hope. We set a date from a perspective of processing these refunds. About 88% of what we identified we have refunded, and it was a significant effort for us to do it. Anyone who's come to us after that date, we've considered their circumstances and we're reasonable. We're giving.
Why would you consider their circumstances if, in fact,
if they're eligible, and we've communicated on multiple times to
well, say they even knew about it. Say I knew about it in March last year, but I just didn't get around to making application.
Yeah. So you're right. The law still is as it is, and if someone was eligible for the refund, we will process it. We set a time frame to more from an operational perspective rather than to try to get this to the point where we could work it through quickly.
So there's a very interesting piece of legislation from 1963 that we've relied on, the Recovery of Imposts Act. Now, the Recovery of Imposts Act, I'm not aware of its provenance. I don't know what gave rise to it, but it basically sets a 12-month time frame from the time someone has paid to come back to us and ask to have the money refunded.
Yep.
There is some administrative discretion that vests with the Chief Commissioner under the Tax Administration Act on how he actually operationalises things like that, which is why the time frame that you just referred to is actually longer than 12 months in the interests of fairness and the ability to communicate the availability of refunds.
So you're telling me that my money becomes your money after 12 months?
So I just need to clarify, it's not my money.
Yeah.
I don't take it home.
Yeah.
I don't get to spend it on...
it becomes revenues money. I'm not suggesting you take it home.
So the way it works, and you know the vibe of the legislation in toto really is to try and set a reasonable time frame that allows people sufficient time to consider their position and to come to the government to ask for a refund of money. Now, of course, that it doesn't detract from any of the other legislative tools or processes that would, such as objections or refunds or court action or anything similar. But from the context of public finance, there does need to be the ability to draw a line under the finances of the state. And this is, as I mentioned, this is long-standing. This goes back to, 60-odd years ago.
Well, in view of the bill which is about to be debated by the Senate, it would be unlikely that you would make a refund, isn't it the case?
A refund to
a taxpayer who sought a refund today?
As I tried to explain, we would consider their circumstances, but we put, as Cullen...
You've got a bill before the Senate which says it will,
so when the law
act
changes,
retrospectively.
If and when the law changes, we will have to...
Sorry, Mr Johnston, a point of order has been taken by Mr Nanbar.
Again, it's hypothetical and it's just conjecture as to what
Well,
may or may not happen.
These are the decision makers.
To the point of order, I think there's a difference between something that is blatantly hypothetical and something that is virtually inevitable, and asking what contingency plans are in place for a department looking at federal legislation. I think they are very different concepts. It's not asking about maybe pocket money or something like that from an earlier example. This is an almost inevitable piece of federal legislation that we are asking the department about.
And these are the decisions.
Well, just I'll rule it. If the question was put in that way, that like what contingencies are in place for that circumstance,
well,
that's a better way to frame it, and then you're avoiding any.
Well,
so
hypotheticals.
So, firstly, if and when law changes, we will, and it requires a correction of our position, we will. So that would be...
Well...
and in terms of current refunds, very limited, and I haven't got, because there was a question earlier of when was the last refund. We can provide that information, but very few refunds are being currently paid outside of some discretion where they've come through later. We haven't got a large effort now. This is at the tail of this work, regardless of what happens with this legislation.
Ms Wilkie, when this legislation was introduced seeking the recovery of foreign surcharge duty, did you ever form the view that the legislation was defective in terms of our obligations under international tax law?
Are you asking for my opinion, Mr Chair?
Yes, I am.
Well, Mr.
Point of order.
Yeah, we don't need a point of order. That's out of order. Clearly out of order.
Did you provide a briefing to any minister that this may have been defective?
Not to my recollection.
Okay. Can I move on to the ITM case, Mr Smythe?
Please do, Mr Chair.
Well, can I just finish with this question? As of today, of course, any foreign surcharge duty, in your view, is not revenue's money, is it?
From those 8 countries?
It's not revenue's money. As we sit here today,
yes,
on the basis of the policy decisions you've taken, that is not revenue's money, and it won't be treated. It shouldn't be treated any differently. It shouldn't be treated any differently until the Senate passes that bill, if in fact they pass it.
I might just comment. It's not a result of policy decisions. It's a result of a careful analysis of the interplay of state legislation and Section 109 of the Commonwealth of Australia.
Thank you. So that hasn't changed, has it?
No.
That analysis?
No.
So the person who today applies for a refund, you'd have to treat the same way as a person who applied for a refund in March last year, would you not?
Subject to the comments I just gave on the Recovery of Imposts Act 1963.
Yeah. So you'd be treating them exactly the same as that particular taxpayer, other than treating them as now being impacted by the impost bill act.
Yes, I think that's fair to say.
So the ITM case, does
Sorry,
it have
Mr.
any
Tudor-Hope, for my edification, ITM?
International trolley. What is it? Trolley management.
Ah, yes, of course.
Yeah. This is a case about people who pick up trolleys for Woolworths and They're now deemed to be employees.
Thank you.
For the purpose of payroll tax. So, are there broader implications in relation to the decision in that case for other industries?
That's an incredibly difficult question to answer.
I'm sure you have thought about it.
Mr. Tudor-Hope. The reason for that is the Court of Appeal decision in the ITM case just vindicated the position that's been taken not only by Revenue New South Wales, but to the best of my understanding, revenue authorities around the country. It was principally in respect of provisions that are referred to as the employment agency provisions. Again, these provisions have been in payroll tax legislation since the very late 90s. So they're not new. We believe they've been applied consistently to similar circumstances around the country. We were confident that they applied in this case, and a panel of 3 justices of the Supreme Court of Appeal agreed with us.
So, job hire companies, are they potentially now exposed as a result of this decision? If they are in fact making or providing job services to one company for a protracted period of time?
The position hasn't changed. It largely has not changed since the late 1990s. So I wouldn't read too much into into further ramifications of the ITM decision.
The company, of course, has now been placed in administration, probably to protect the directors of the company. However, what's the impact on revenue if, in fact, or have you done an assessment about what the impact on revenue will be if, in fact, the payroll duty which has been assessed is not collected? How much are we talking about?
I couldn't comment on the specific finances of an entity in any given time, other than publicly available information.
Yep.
And the details around the details that were disclosed in the judgment at first instance indicated there was approximately $3.6 million being a combination of tax and interest and penalties.
But Australia-wide, was it $3.6 million? Because this has implications for payroll tax for this company, which is a publicly listed company, and they've in fact notified the stock exchange in respect of this decision. In those circumstances, the administration was notified to the stock exchange. What's the total assessment Australia-wide? Are you aware of that?
I'm not. We're concerned with New South Wales payroll tax.
Currently, the Minister was asked some questions in relation to GP tax or GP clinics. If there's no legislative change before the, I suppose, amnesty exists up till August.
September?
Yep.
September.
4th of September.
I think it's up till September. If there's no legislative change, it is your view, is it, that audits then can continue and the tax can be collected?
So I think, Mr. Tudor-Hope, so the law that period would have ended, we would, it's hypothetical, I think, in a sense, because we don't know what's going to happen between now and that period of time in terms of other changes, but I would not be looking for Revenue New South Wales audit program to step into a campaign of auditing en masse medical centres, which we have never done. We have had very limited audits of such businesses for many years, and we'd be very considerate to the circumstance of how do we navigate from a period of pause into something else, and we'd have to manage that, and it would be in consultation with the industry groups that are advocating for other positions if we needed to.
Well, the amnesty which has been given is only in respect of audit, is it not?
That's right. So the liabilities continue to...
So any penalties and interest is still occurring, is it not?
No.
No?
No. So interest has been stopped during the period of the audit.
Yep, but
And
prior?
Any
Of the amnesty, the period of the 12 months.
Yes. What did I say?
You said audit, but...
Sorry. Yep. Audits on the brain. That's terrible for a revenue authority. Any penalties that were still outstanding from memory up to the time the pause started were basically written off. Don't have the provision with me, but it's set out in the Tax Administration Act.
So
the primary liability, if a taxpayer had a liability outstanding, had a liability to pay payroll tax, that would continue to exist, but there would be no interest accruing during the period of
But if there is a liability to pay payroll, if there is a liability to pay payroll tax, are you still collecting it?
It's up to businesses to choose to, if they choose to pay, they can, and we will accept it. But there's no action from us compelling
to actively
auditing
audit it,
That's
are businesses being advised that their obligations in relation to payroll tax are continuing to mount?
Yes. Yes.
During the period of the amnesty, there is no waiver of their liability. It is just the only thing that has been waived is audits.
and interest.
And interest.
That's right.
For that period.
That's right.
Correct.
So any liability which is occurring today, in the absence of legislative change, will become a real liability after September of this year. If in fact you carry out an audit.
Right.
And in fact, a taxpayer who is currently had potentially been paying payroll tax in previous years, you would expect that they would continue to pay payroll tax, would they not, during the period of this audit?
That's a choice of those. In practice, that's a choice of those businesses because we're not pursuing them, or we are giving respect to this amnesty period so that whatever comes after that can be done in the best possible way. So some businesses will be paying by choice.
In terms of the policy considerations in relation to this, is the consideration also being given to dental clinics?
I think they're matters for the government, not for...
there is no amnesty in relation to audits of dental practices?
Sorry, no, there is not.
And Pacific Smiles, in fact, was the subject of an audit, was it not?
I couldn't speak to the matters of a particular business in this.
But dental clinics generally?
Yes.
Well,
potentially. If as you're well aware, Mr. Tudor, we have a framework, a risk framework to identify those businesses that may be appropriate to audit, where we've seen either a difference of opinion from their response compared to other data, or we've audited very few medical related businesses in the past 5 years. I think last financial year there was 80 in total, and approximately half of those we found a liability. But dentists, physiotherapists, others outside of GPs potentially could be audited, yes.
I'll just have a break for a moment. I'll pass over to Mr. Arthur and I'll come back to you.
Okay.
Thanks. I wanted to talk, to turn to our royalties for Rejuvenation. So just wanted to see what, with the funding, when's the earliest that funding could be spent?
So the Royalties for Rejuvenation Fund currently cannot be spent until 2028-29, or until the balance reaches $250 million.
Right. And what, I don't know if you've got it on you, but what part of the legislation is that carried under, or is it a directive from the Minister?
That was a decision by the former government.
Right. And the guidelines and the expert panels for the program that was established in late 2022, why is it that the only money that has been spent from this fund so far is on administration costs?
So the fund cannot be spent until 2028-29 or until it reaches that $250 million. There is a portion of money that's been allocated for operating expenses, and that money has been used for administration, managing the funds, some staffing costs, and also payment of fees for the expert panels.
And that's been communicated to the expert panels that the funding can't be spent until 28-29?
I believe so, yes.
And have the expert panels ever provided correspondence to the government seeking the release of funding for projects or business cases in their respective regions?
The expert panels under the legislation can provide advice to the minister, and that is required to be published on our website, and I believe has been. There are a number of areas, if you just bear with me, that they have provided some advice. I think your question was specifically in relation to early release of the funds.
That's right, yeah. Or if you want, we can come back to it later.
I have it here.
Yeah, okay.
Somewhere. Maybe I will just come back. Sorry, I just need to find it.
That's okay. I'll move on from royalties for rejuvenation at some point, and then we can come back to it later on, maybe, or we can take it on notice. But what are the reasons why the expert panels haven't met since August last year?
So the expert panels have met a number of times, but you're correct, they have not met since August last year. The panels are aware that the government is consulting about the establishment of the future jobs and investment authorities, and they understand that that is the focus of the government at this point in time. As you heard from the Minister this morning, there have been a couple of roundtables held, one in the Hunter, one in Lithgow, and there are 2 more roundtables to be held. So the expert panels haven't met since August. I believe they're allowing the government to do its consultation for the establishment of the authorities.
And are there any vacancies on the expert panels at the moment?
Yes, I believe there are.
Do you know how many?
No, I'd have to take that on notice. Some of the expert panels had up to a number of people. It could be between 5, there's 5 and 10 members, so some of the panels were larger than others. That was just as a result of the recruitment process for the panels at the time.
Okay, yeah, that would be great, just a list of what vacancies exist. Earlier, the Minister spoke about a commitment of $5.2 million over 4 years for the establishment of the future jobs and investment authorities. Is that $5.2 million, is that going to come out of the royalties for Rejuvenation's fund?
Not from the statutory fund, no.
Not from the statutory fund. So under the legislation, the money that's put aside for royalties for Rejuvenation, that can't be redirected to future jobs and investment authorities. Is that right?
Sorry, can you repeat that question?
So under the legislation for royalties for Rejuvenation, could funding be taken out of that for another purpose, for instance, for the future jobs and investment authority?
Or
is it like hypothecated?
So the fund and the use of the fund is clearly set out in the Mining Act, and that is to alleviate economic impacts in affected coal mining regions caused by a move away from coal mining by supporting other economic diversification in those regions, including infrastructure, services, programs and other activities. So as part of the consultation that the government is undertaking at the moment about the establishment of the future jobs and investment authorities, we will look at all aspects of the Royalties for Rejuvenation Fund, and as the Minister said this morning, the role of the expert panels moving forward once those authorities are established.
And I think, Mr Ruff, the evidence this morning was that there was 22.5 million per annum going into the fund and 2.5 that was not set aside under the statute to fund the administration of the panels and then potentially the future jobs and investment funds. Am I correct?
That's correct. Yeah. I have the information on the advice.
Yeah, that'd be great. Thank you.
Apologies for that.
Yeah, no, that's okay.
So advice has been provided by the expert panels to the Minister, and as I mentioned, that's available on the website. The expert panel chairs provided advice on strategic priority areas common across the respective regions. The chairs provided advice about considerations for regional authority models to inform government's thinking about the design and implementation of the authorities. The chairs provided advice on recommendations on the scope and timing of the Royalties for Rejuvenation Fund. And the Hunter chair provided advice on the key considerations for decision making about the design and implementation of a regional authority for the Hunter. And again, the Hunter expert panel provided advice about a proposed post-mining land use quick wins project. So that advice has been received and is being considered as part of the work that we're undertaking about setting up the jobs authorities.
So they could put in advice about early release of funds, but ultimately it's the Minister's decision whether the Minister would take that advice and have an early release of funds, or is it like a legislative inability to withdraw any funds before 28-29?
It's not in legislation. It was a decision of the former government not to release that funding.
Sure.
But as the Minister said this morning, all of that will be considered as part of the work that is being undertaken at the moment.
And has the Minister asked the department to draft any legislation that would allow the Royalties for Rejuvenation program to be redirected to other funds?
We're not drafting any legislation at the moment. The focus for us is consultation with the coal-reliant communities.
Okay. I might turn. Are you okay if I do this, or do you want to? Okay. I might turn to the former First Home Buyers Choice program. How many first home buyers opted for the First Home Buyers Choice scheme, which was available between 16 January 2023 and 30 June 2023? Yeah, I'll give you a minute to find it. Yeah. I know it's a very specific question.
So first home
buyer's choice.
How many?
How many people opted? How many first home buyers opted for the first home buyer's choice? So the property tax rather.
I've got this. 7,988 properties.
Yeah.
Which individuals, because often more than one person involved, 13,361 individuals, which I think was your question.
Yes, individuals, properties. That's very helpful. And over that same time period, how many I don't know if you have it on hand. How many first home buyers were there over that time period?
I'll take that on notice.
Okay.
It's available, but I don't have that to hand. Yes, well, actually, it's. So,
like, how many?
We'll see because someone has to identify themselves as a first home buyer and depending on the scheme that they're taking advantage of, whether it's a first home buyer assistance scheme or this, obviously there's limits where property value, it's irrelevant whether you're a first-home buyer or not. So we'll be able to provide some information that will be instructive to it, but probably not completely full.
Yeah, sort of essentially how many paid stamp duty versus how many opted for the property tax is sort of where I was, the land tax.
In terms of proportion.
Yeah.
Could I
Or,
just add,
or a percentage figure if you don't have the...
So as the Chief Commissioner was saying, the figure that we'd be able to provide will not be 100% accurate, because there will be, or there may be, first home buyers who would not be eligible for any scheme and therefore would not have identified themselves to us, for example, because the house was over the threshold.
But we're happy to provide a response that frames those that we're aware of.
Sure. Do you have, of that number, so 7,988 properties, do you know how many were between 1 million and 1.5 million? Or do you have it broken down by?
I don't have that on me for the moment, but I can
Yeah, that would
notice.
That would be good, sort of just broken down maybe a little bit, a few different options there. And what arrangements were put in place for those people that that did opt for the first home buyer's choice scheme? So it was only in existence for that sort of less than 6 month period.
Yes.
They then sort of operate in like a scheme separate to everyone else. Can you give an update on that,
yes,
how that all works? It's only a small number.
The scheme continues for those that entered it, and we issue assessments annually, and they, up until the point their circumstances change and they sell from or leave that property, we'll continue to collect, issue assessments and collect the revenue from that.
Okay, great, thank you. I'm happy to go on. Do you want to kick it? Yeah. I just wanted to move to the budget. So the nurses. In the budget, there's a funding set aside for 1,112 full-time, or converting 1,112 full-time equivalent nurses and midwives, positions which were funded temporarily to June 2024 to permanent positions. How much funding was put aside for that?
So that was $572.3 million.
And how many years does that cover?
It covers 3 years, so it covers the forward estimates beyond 23-24, which was already funded.
And what are the assumptions behind that in terms of the annual salary requirements of each of those 1,112 positions?
Mr. Rath, I believe we took this on notice at the Treasurer's hearing, so we will provide that information.
All right. Great. No, it just seems rather high. So I know there's probably other costs that are built into it as well. It's not just total, like the figure divided by the number of positions, but that would be good to know what the assumptions are behind that dollar figure.
That's right, and we're preparing that answer in response to the former question on notice.
Excellent.
Can I just, Mr. Smythe, just returning to the International Treaties Amendment Bill, your advice, or the position you took, was that the law was clear in relation to the surcharge duty not being duty which was capable of being retained by revenue.
I don't recall using the word.
Well, you'd formed the view that it was not revenue's money.
Correct.
So have you read the explanatory memorandum to the bill which is currently before the Commonwealth Parliament?
I have.
You accept from me that it says it's not changing the law, it's clarifying the law. That clarification, of course, would mean that the Commonwealth formed the view that state taxes were not within the International Taxation Agreements Act, and that they were clarifying that position with this amending bill. Would you agree with that?
I would agree with the language you used in describing what the Commonwealth said. I couldn't possibly comment on whether the drafters
the use
of
of
that-
the use of the word clarification rather than change would seem to indicate to me, I don't know if it indicates to you, but it indicates to me that they were in fact of the view that the estate tax was properly collected, but to the extent that it needed clarification, they were clarifying the International Treaties Act. International Taxation.
Yeah, so that's what they said.
If in
yes.
fact, that's what they say. So their view was, given what I've just put to you, their view was different to yours.
I don't know what their view is. We can agree on what they wrote. One might draw a conclusion from the fact that the bill is there was some necessity seen in drafting such a bill and putting it through Parliament.
Yeah, but it's, if they were going to change the law, that's one thing. If they're clarifying the law, they're suggesting that the estate tax is properly collected, but for the sake of certainty.
I'm not a mind reader. I'm not sure what conclusion they've reached. We can both read the words that they thought fit to put into the explanatory memorandum.
Under the Imposts Recovery of Imposts Act, you've identified that after a 12-month period, the taxpayer would have to give some explanation as to why did you go back then in March of 2023 and offer refunds as far back as January of 2021? Weren't those payments outside the 12 months?
Correct. The reason that decision was taken was because we were disadvantaging people who paid early, and those that paid late were in scope where we looked at the annual cycle for land tax. So that was the basis of that decision, to try and provide fairness to our decision.
Thank you, Mr. Johnson. Ms. Fairman, you have 20 minutes.
Thank you, Chair. Mr. Day, let's start with you, if I can. Back to Cadia and the silicosis. Now, you said that there were two, I think possibly a third. Now, we go back to, I think you said in your evidence earlier that the third wasn't a case of silicosis or something?
No, it didn't. Yeah, that's correct. It didn't meet the criteria for silicosis, so it was investigated and didn't meet that criteria. The other two that have been subsequently confirmed and diagnosed as early stage silicosis were investigated, and they were more recent, back in 17th of June 2022 and 17th of August 2023.
Okay, so when they're confirmed, so the other person who wasn't presented, and ultimately, what's the test that is required to determine silicosis?
Yeah, so the companies will do routine testing of workers as part of their principal hazard management plan. And if we look at Cadia particularly, they'll do pre-employment X-rays. They do they have a lung bust that comes out every 2 years. That does spirometry testing as well around lung function, and that's really to try to detect any sort of early stages with that. That then triggers the notification to us if there's any sort of issues from a health point of view that we would investigate from that point.
Okay, so that lung bus is compulsory for every single worker at Cadia, is that correct?
That's correct.
So every single worker goes through that, gets a test. What's a test? Did you say?
It's a spirometry test.
Okay.
On lung function.
So that's two confirmed cases. What about suspected cases of silicosis in Cadia? We'll actually go the whole of New South Wales at this point. What about silicosis cases confirmed in New South Wales in terms of your industry, the mining industry?
Yeah, so I'd have to take that on notice in terms of actual numbers, but we normally get about anywhere between 6 to 10 notifications a year that we would investigate.
Mm-hmm.
Now, they're preliminary detections, and that doesn't always then translate into a confirmed case of silicosis. That's through the entire sector. That's coal, metals, mines, quarries, and so on.
So about 6 to 10 cases per year is what you get per year. So right now in the state, how many cases of how many people have silicosis as a result of mining or silicosis that you're aware of?
I'd have to take that one on notice. I mean, from our point of view of our investigation, we're looking at predominantly where there may have been a failure or a causal factor from the mine operations on that worker. Now, the issue with silicosis is that it's got a long latency time, and so often then the requirements for airborne contamination are fairly recent in terms of workplaces, especially in the mining industry, but we're far ahead of other sectors. But in terms of airborne contamination, some of the requirements only come into effect around monitoring, measurement and control factors started coming in from about 2016 onwards. So that's pretty recent because a lot of the damage could have been done some time ago for workers, as you'd imagine.
Are the two cases that you referred to at Cadia, are they still working at Cadia?
One is, yeah. And I guess part of the complexity...
Has the other person retired because of age or illness or...?
I'm not sure about that in terms of their current status. People do move around, and that's part of the complexity with operations, is that when we get detection and we look at their work history, often these people have been at multiple mine sites and other industries as well where airborne contamination is known to be prevalent as well.
Yeah, so what about suspected cases then at Cadia? Say, how many suspected cases, say, in the last 2 years are you aware of?
Well, we've had that's what we've had there.
That is Cadia. Yeah.
Yes.
Who's specifically, so in terms of the regulatory environment, given the higher risk of dust exposure at Cadia, specifically who's responsible for regulating this area?
Yep, from a worker point of view, from a worker safety point of view, that is
yes,
really
and
us.
And you're responsible for ensuring the screening of the workers as well.
They put in place a screening mechanism, yes, so as part of their principal hazard management plan to screen workers around any sort of ongoing health issues. There's minimum requirements for that, but companies often go above requirements for that.
Yeah. Okay. So do you have the figures as well in Cadia? So kind of year by year, maybe breaking it down over the past 5 years in terms of every
we would only
metalliferous workers.
Sorry, we would only get detections, like exceptions or incident notifications. But we can look at that as part of a targeted assessment process in terms of our own compliance activity. So we might target that aspect of the principal hazard management plan around their pre-employment checks or their ongoing monitoring. Where we're really interested in, I guess, is actually around dust exceedances that happen during the workplace, and that then triggers an investigation from us around that. And I guess primarily we're looking at about 4 different categories of workplace exposure around dust. So we're looking at inhalable dust, respiratory dust, silica dust, and also things like diesel particulate matter as well. So we group them all under airborne contamination. It's important to know the difference between different dusts. I mean, it's not a very interesting subject, but it is actually relevant to what we do. And so the inhalable dust is the dust that we can all see out there in the environment. That's probably the least damaging dust in terms of that. It's probably from a safety point of view of workers, we're looking more at visibility than anything else. But the dangerous one is what we call respiratory dust, which you can't see. And within that also is the silica itself. And so, which is why then we have monitoring equipment on site that the companies utilise, measure, and let us know about exceedances out there that then triggers an investigation from us.
Okay, so the bus itself that every single worker, as I understand, yearly, is that correct? This lung bus, every single worker goes through. What the screening that takes place, which you described as, what did you call it?
Spirometry testing.
Spirometry testing. What does that look out for? What does that test?
I would take it on notice. I can give you a very basic answer. That's not my area of expertise, but it's basically looking at lung function and in terms of how well their breathing ability is working. Now that can be also impacted by a number of things, like even occupational hazards like smoking and so on. So what they're looking for is something that triggers a further investigation into why someone's lung function may have deteriorated, and then they can determine whether is that silicosis, is it from smoking, is it from other issues.
And plaque and scarring of the lungs.
That's correct.
Because what I have some people have talked to me about is that this spirometry testing, yes, it does that in terms of if breathing difficulties are starting to show, but it's the earlier detection actually that I understand can take place, and that the workers at Cadia actually aren't being screened for that earlier detection. Are you aware of what that is in terms of the earlier detection, and why that the lung bus isn't doing, prevention as much as possible? For example, I assume that if some workers were starting to show concerning signs before getting to that point, then maybe the precautions around dust exposure need to be tightened.
So my understanding is they'll do a pre-employment X-ray, which is really
For everybody gets an
everyone,
X-ray,
and then they'll repeat that X-ray every 5 years, and in between that, the lung bus will do the spirometry testing every 2 years. So it's a multiple layer approach.
So the X-ray looks for what?
It'll look for abnormalities in the lungs itself, and then once again trigger further investigation from medical professionals.
Okay. But my understanding is that 40% of X-rays miss silicosis, and if you want a comprehensive test, you get a CT scan.
And there's various, we just did a recent review into coal health surveillance program for that, and so there's a number of recommendations in that review to look at second readers and CT scans and a whole range of things.
Because that's what ICAC does, doesn't it?
It's linked in, so coal services will do work under contract for a lot of the mines as well, but yes, it does link into ICAC where there's the detection and it's confirmed diagnosis.
So when were the two current cases at Cadia discovered?
My understanding is they were just recently late last year diagnosed as positive silicosis, but we were notified through the preliminary detection back in June 2022 for the first one and August 2023 for the second one. Before that, say the last 5-10 years, what was the silicosis case numbers before that? So that's all we've got. The first one was 2019, and I guess that reflects that the requirements for testing and notification only really came into effect about late 2016-17.
Okay, I've got a bit more that I'll actually... Yeah. Sorry.
So I was going to say, from a point of view of safety as well, Ms. Fairman, that we also look at the dust exceedances as being critical in terms of investigating their systems, and so each mine has to have a safety management system, a principal hazard management plan specifically for airborne contaminants, and a health control plan around how then they test and monitor the individual's workers' health as well. So we assess the plans, we review the plans, that's part of our targeted approach. Every year we do targeted inspection or compliance programs in those mines, looking at ventilation management, looking at airborne contaminants. We're doing one this current 6 months we speak in metals mines, looking at airborne contaminants around how well their programs are mitigating against airborne contamination issues out there, recognising that the requirement is that they minimise exposure as far as reasonably practical, and they'll wear P2 masks and a whole range of other things. So there's multiple protections in place, but underpinning all that is the requirement to have a minimum workplace exposure standard around exceedances.
Do you do random, like unannounced compliance checks, spot checks on Cadia, and how often?
Every year, so we'll do multiple layer approach to compliance, and so we publish our compliance priorities, where we'll do a targeted compliance project on aspects of their plans. And so, like I said, this 6 months, we're doing airborne contaminants in metals mines. Last year, we did a project on lead management in mines and also ventilation management as well. Those projects can either be a mixture of announced, unannounced, and also then we can do targeted interventions if we get complaints or get data, which we've got a lot of data coming in around instant notifications that suggest a bigger problem. Then we would do what we call a targeted intervention that goes right through the mine itself, looking at every nook and cranny on whatever the issue may be.
So have you got the data around, say, for the last 5 years, how many kind of unannounced compliance checks happened at Cadia? By that, I mean, the regulators' people, going to the mine, doing the checks, taking the air, monitoring deep underground in other spots. When did that last happen without Katia knowing that you're doing it?
I'll take that on notice in terms of that time frame, yes.
And you're saying here in terms of what you do know, that does happen semi-regularly?
Yes, and we do thousands of inspections a year. We get about 2,300 instant notifications that may require a follow-up or investigation on safety issues at mine sites, and from that, a mixture will be unannounced and announced.
Okay, I wanted to just turn to the mining inquiry, the heavy metals mining inquiry report that I was referring to this morning, and I will ask each one of you if you or your department did see any of those, the draft of that report, or had any discussions about it or contributed knowledge to that report. For example, Mr. Day, we did have a lot in there about mining rehabilitation, as I mentioned earlier, that was removed on motion by a Labor member. So did you see the draft report or have any discussions about the content of that report with any member of the committee?
No. No, in terms of I had no discussions with members of the committee. I saw a draft recommendation, but had no discussions with
Where did that draft recommendation come from?
I'm not sure. I can't recall where it came from. It was around provided to me from at the office in Newcastle.
And it was a draft recommendation. Did it make its way to the final report? The draft recommendation you're referring to?
There were some minor changes to that.
So, did the recommendation come from within the regulator, or had it come from the Minister's office, or did it come from another office? So you had a look at it. It was edited.
I'm assuming so because it changed.
Yeah. Then changed on the recommendation of you and your officers?
No.
Who changed it?
I've got no idea.
So you saw it as edited?
Yeah, I saw it as a draft recommendation, and then I saw the final recommendations that came out.
Of the saw the final recommendation.
Yeah, but I've had no comment. I know no.
So all you saw was a recommendation. Just to be clear, you didn't see everything else in terms of you just got a little recommendation.
Yeah.
No committee comment or any just.
Yeah. Apart from the final report. Yeah.
Apart from the final report, Ms. Beattie, did you have anything to do with it?
No, the Minister's office did not discuss the report with me or the draft recommendations.
Yeah. So, and did you see any of the recommendations or the findings within the department in terms of what providing advice to the members of the committee around what could be accepted and not accepted? I mean, I actually assumed that happened all the time, to be honest. I really would assume that that is what good government members of committees do. They make sure the department understands and they receive feedback from the experts. But, Ms. Beattie?
Sorry, what was the question?
So did you see the draft report and did you see it circulating and able to contribute? Did you see the draft report?
I did not see the draft report.
And do you know whether that draft report made its way into the department at all for comment?
I don't believe it did at all for comment. I was aware that Mr. Day had seen some draft recommendations, but the draft report was not circulated within the department at all, to my knowledge.
Mm-hmm. Ms. Livingston, are you aware of this report? Did you see the draft report?
No, it's outside of my remit.
The names? Can I have the names? Sorry, I just have lost my sheet. It's not mine.
No. In my role, which is in the policy and budget team in Treasury, we cover all the portfolios across government in terms of budget process, but the report hasn't come across my desk.
The draft report. I'm assuming, I would hope that the final report does, but again, don't be too excited about what's in it. Ms. Campbell?
No, it's also not within my portfolio responsibility.
Okay, thank you. Mr. Johnston?
No, Revenue New South Wales. Myself or Revenue New South Wales haven't seen.
Yeah, because there's nothing in it that's going to cost the government anything because it doesn't tell the government to do anything. Mr. Smythe, is it Smith? Smith,
No.
Sorry. That's, again, Revenue New South Wales. Yes. Ms. Beattie, we've done you. Ms. I can't see what that is. Wilkie.
Ms. Wilkie.
No, I haven't seen it either.
Treasury, nothing. Hansard, nothing. Okay. Thank you. So, part of this, part of the recommendation, one of the recommendations in the draft recommendation, Mr. Day, was in fact to ensure that the regulator had more resources. I think that was one of the ones that stayed in. Did you have a? Did you have
that recommendation is in the final?
You're okay with that one? More. Look, that's what was in the draft report. I thought was, that was a good recommendation as well. So in terms of more resources, what to do your work? Where do you think, in terms of the greatest weakness right now? We had a lot of issues in that inquiry. What specifically? What are you with the budget coming up? Is it personnel in terms of going out and doing the inspections for the regulator?
So I think in terms of resources, I'll leave that to the government the day to determine what we get resource-wise. A lot of the issues that were raised in that upper house inquiry last year effectively related to I guess, historical regulatory framework for rehabilitation. Very much so our focus and our compliance approach is on the current regulatory framework for rehabilitation, which we're confident is robust and will deliver excellent outcomes for the state in terms of ensuring that mines fulfil their rehab obligations. How we're like every other compliance agency out there, we'll take a risk-based approach, target our resources to the areas of highest priority, that type of thing. Okay. So that's what we all do. But in terms of most, I guess, the issues that I saw come out of the upper house inquiry is very much from a historical point of view around how rehabilitation was conducted, and our attention currently, and has been for some time, is on the current rehab framework, which provides a lot more strength and rigour to the process around compliance.
Ms Fairman, if I may just add to that, the resources regulator receives its funding from levies that are paid to the government by industry. Yeah. And so the whenever additional resources are required for the regulator to undertake its functions, we've never had any trouble in getting extra resources for those functions.
Yes, okay, all right, thank you. Mr Day, when you talk about kind of seeing a recommendation and floating around somewhere in terms of where that came from and who you liaised with, was one of the people or bodies that you talked to about this report the Minerals Council?
No.
So they, as far as you're aware, from your side of things with the regulator, you had no, it was just a regulator providing input with the Minister's office?
There was no input. I provided no input. It was basically looking at it, and that was it.
The draft report again?
Yes, I provided no input to anything on that. Yes. Yeah,
but just to be clear, you saw the draft report, not just a single recommendation?
No, the single recommendations I saw, not the report itself.
Okay, thank you.
Thank you, Ms Fairman. Mr Tudor-Hope.
Thank you, Mr Johnson. In relation to EV road user charge, which will now no longer be collected, how much had revenue anticipate collecting in relation to EV road user charge?
Sorry, the collection of road
electric vehicles,
road user charge.
Yeah.
So we're not currently collecting that. So I think from a forecasting perspective, that would be a question for Treasury.
So Ms Wilkie,
I don't. I'll have to take on notice the exact forecast. It's not within. It'll be the costing of the original proposal because it's not within the forward estimates yet. It's not scheduled to be started to be collecting until the 1st of July 2027.
Correct, so, but you'd be aware of potentially this is something which we may be wanting to seek to recover from the Commonwealth in the event that we're not able to recover it. And have representations being made to the Commonwealth in relation to how they will treat EV road user charge?
Yeah, so there's a few issues in there. Let me unpack that a little bit. Yep. So as Mr. Cooch-Trotter said this morning, the Vanderstock case applies to the Victorian road user charge. In light of that, though, it does certainly behove us to look at what the implications of that are for the New South Wales road user charge. That is being undertaken at the moment. The second thing then that is being done, as you implied in your question, is conversations with the Commonwealth, both around what is the future of road user charges of this sort of nature in Australia, and what can all jurisdictions do on that front. And then the second one, which is in the event that there are additional High Court cases that overturn the state's rights to impose similar taxes or other taxes, what will we do with the Commonwealth in such an event, which is where the windfall tax issue is part of that discussion.
Just in relation to that, and I think point of consumption tax is one of those taxes which would fall within that category, and I think Mr. Cooch-Trotter identified the windfall tax discussions which are being held with the Commonwealth at the moment. Can you confirm whether there is currently before Treasury any proposal to increase the point of consumption tax from 15 to 20%?
There's no, in terms of the point of consumption tax, I'm not aware of any current cases in Australia that would, in terms of in the context of the Vanderstock ruling. In terms of other proposals that the government may be considering around point of consumption tax, the government is always looking at various issues around taxation, and I'm not going to...
Well, I'll put to you a specific proposal. Is there, in relation to gaming revenue, is there a proposal to increase the tax rate from 15% to 20%?
The government has a whole heap of things that it's looking at in the context of taxation revenue, Mr. Tudor-Hope, and I'm not going to make any comment on policy advice or advice in front of them.
Well, I take it that's not a no. Mr. Johnson, in the 3 months between the budget and the half-yearly review, the anticipated tax raised by transfer duty was revised upwards by nearly $1 billion, about $957 million. And land tax was revised up by $1.765 billion, which is a total increase of $2.722 billion over 4 yees.
Sorry, Mr. Tudor, what was the first figure? Sorry, the first. $957 million, or $0.957 billion. Are you aware of that?
Yes.
Yep. So, in relation to those projections, are you expecting any further revision of?
So again, I think forecast is a Treasury question.
Should I ask you, Ms. Livingston, whether
my colleague
back at me?
Back to you. Thank you, Ms. Wilkie. Are you currently forecasting? So that was between November. Between the budget in September and November, that forecast went up nearly $2.7 billion.
Sorry, I had it and then I've lost my notes again. Here we go. So which year were you particularly interested in, or the forward estimates?
Yeah.
So between budget and half yearly review, yes, the forecast increased $957 million. That was largely due to increases in house prices over and above what we between September and November than we had expected when we did the budget forecasts, so there's in a time of when interest rates were going up, we did not anticipate that house prices would continue to increase at the rate at which they did.
So in terms of forecasting going forward, are you expecting similar deviations?
So the forecast round for revenue for budget, we are in the
pre-forecasting stage at the moment, which is where we are reviewing models and reviewing data and that sort of thing. We haven't actually commenced the forecast round for budget yet.
You've been doing this for a long time. What would your
so again, I'm not going to venture an opinion.
well, given your experience.
So revenue monitoring for transfer duty is actually slightly below where we had expected it at this point in the cycle. So between what has been happening with house prices and what has actually been happening with the actual transfer duty that revenue has been receiving, the signals are very mixed.
Okay,
Thank you, Ms. Wilkie. We will now have a break for 15 minutes and reconvene at 3:45. 45, we will recommence with another round of questions from the opposition. Mr. Tudor-Hope.
Mr. Smythe, in respect of the view that you formed in relation to the surcharge, foreign investor surcharge duty, did you obtain any legal advice independently to confirm that view? Or Mr. Johnson?
Sorry. Yes, we did.
You prepared to make available that
I'll take that on
legal
notice.
advice? I suppose these are old issues, but the COVID hotel bills, where are we up to on that?
Can I clarify which? So Revenue New South Wales collects at the charge that was put to people who stayed in the hotels, and Treasury looks after the interstate piece. I'm not sure which question you were after.
The revenue, the internal COVID hotel bills.
Yes, so so 92% resolved, 326.1 million worth of invoices were issued. With 299.4 million resolved as of the 29th of January.
So is Revenue still pursuing those, or is there a proposal to write them off?
Currently, we're still working through those. Much of it would be on payment plans, etc.
So the 8%, which is uncollected, may well be on payment plans, is it?
It'd be a combination of either not
can't
paid
find
at all
the people or on payment plans.
Yes. Yes.
Yeah. In respect of the Treasury component, Ms. Livingston,
Again,
this is
I'll
always
refer
in the
to,
media.
My colleague, Ms. Wilkie.
I'm sorry.
That's all right. Mr. Tudor-Hope.
So there's always in the media. Have we collected any money from Queensland?
So we have not recently collected any money from Queensland. Their bills are unpaid, and hence the recent correspondence from the Treasurer.
Is there any other jurisdiction that hasn't paid its contribution to?
Western Australia has also not paid. It has outstanding amounts.
How much is that?
26.6 million.
And is there similar correspondence been addressed to the Western Australia?
Not that I'm aware of, because they've paid half. So that they've paid 50% of their overall bill. So whereas Queensland,
they on a payment plan too, are they?
Hardship provision.
Given the concessions we made to them on GST, I would have thought that they may have paid that. In respect of Commissioner, of the COVID small business grants, have they the audits in relation to those, have they concluded yet?
The audits have concluded, yes.
Yep. And how much is currently outstanding as a result of overpayments?
Where are we? Sorry, just one. Can you find it?
That's one. It's here somewhere.
Can I come back to that?
Sure.
There's there is an amount outstanding.
And you also have details in respect of matters which have been referred to prosecution?
Prosecution in relation to fraud?
Yes.
So Service New South Wales, in conjunction with police, is the agency that deals with the fraud. Any cases where we might have identified through compliance or other means, we refer that to Service New South Wales.
So how many cases fit into that category?
I'm not aware of how many, because again, Service New South Wales looks after that part. But I'll take it on notice to see how
many have actually been referred by your agency, Revenue, back to Service New South Wales?
It would be very few, but I'll take that on notice. The majority of issues around fraud was about identity at the outset, so that was identified through Service New South Wales as part of that function. So.
Yep. This morning the Minister was made some observations in relation to only 0.1% of fines fit within the fine reduction regime in relation to hardship provisions which were introduced. You recall that observation being made by the Minister?
Yes.
Now the Act provides the scheme provides this, and this is an extract from your own website, I think, that you may be eligible for a 50% reduction in your fine, and these are the conditions: have not yet paid your fine, were receiving a government assistance payment at the time of the offence, can't pay the fine in full or set up a payment plan to pay in instalments, have not had 4 or more similar fines within 12 months of the offence date, can't take part in a work and development order, and do not apply, are not applying about a serious offence or have had a serious offence in the last 12 months. Serious offences are those that have a big impact on other citizens, their safety, property and environment. And you can find out more from the Review Assist Guide. You'd be very, very well aware of those conditions which relate to hardship which you would consider, and that is within your remit. Are you surprised that it's only 1% of fines fit within that category?
I think the best way to...
I think.
Yeah.
0.1%.
So it's a much lower amount value or number than when we initiated the fairer fines provisions. I think our forecast was significantly higher than
Yes, the forecasts were high, but
originally.
given the eligibility criteria to qualify for relief, to an extent that it's not surprising that few people, unless of course you're going to change any of those eligibility criteria. Are you proposing to change any of those?
Well, I think the Minister spoke this morning of a wish to look at how this operates, and I think if so few people are receiving the discount, I think it's worth having a look at, is it achieving its purpose? Is there people who would be deserving of that discount, and it's where people can't pay.
But that's your discretion.
No, I agree. But there's a process, and
the Minister can't interfere with your discretion.
No, that's true. But the Minister, as ministers before, have a view about how this can be set in keeping with their priorities, and so I wouldn't be intending to do anything without.
Well, you wouldn't be considering changing the provisions in relation to what constitutes a serious offence, which wouldn't give rise to a hardship provision, are you?
I think not necessarily, no, but I think the serious offence is important part of the approach. I think reviewing what we consider a serious offence is something that we should continue to do, which I think's reasonable. I think the framing of the process that steps through a whole range of criteria to the point where you might be eligible for a discount makes it quite difficult for someone to qualify. So this is part process as well as policy, I think, that we need to think through.
Well, this is a process for getting a 50% reduction in your fine, and there are a set of is the minister suggesting to you that you reduce or increase that list of eligibility criteria?
No, the Minister hasn't suggested that to me.
Is there a different financial criteria that you would apply?
So I think there's a whole range of parameters in this approach, including the fact, an example of mine, not to suggest this is where we would change, but something we should think we and I are thinking of is we try to get someone on a payment plan before we consider whether they're eligible for a 50% discount. Now, there'll be lots of times where we know someone has no ability to do that and we could offer that earlier, as opposed to going through a whole range of steps and someone just accepts it. We could lift that as an option higher that might see more people who are eligible, would otherwise be eligible, but select out because...
Well, you could do that tomorrow.
Absolutely.
If in fact, well, is that your decision?
No, we're looking at the parameters of the scheme to work out what the impact would be. There's obviously... there's a whole range of... Any change to this will have an impact on a number of things, and so we're working through that. We're also getting feedback from advocates, the issuing authorities that we work with, to see their perspective on how it's working.
Well, you meet with the agents, the fines working group on a regular basis. Are they making suggestions to you in respect of variations to the implementation of this?
They're sharing views. They do, as you'd be well aware, they share views on a whole range of matters, and some of it, and that's important information for us to consider. If this program is changed, how we step it forward. Well,
you're not going to certainly move away from suggesting work and development orders, because there's a work and development order has an educative benefit, does it not?
Absolutely. Work and development orders are an incredible opportunity for people to resolve their debts and also give value to themselves and community.
Very good government that introduced those, wasn't it? Work and development orders.
Order.
No, it's my opinion.
But it isn't.
It's my opinion that he can agree, that the Commissioner can agree.
Well, it wasn't at the end.
I gave my view on work and development orders. It's a really valuable, and at the time was a absolutely nation-leading program, and gives a great opportunity for thousands of people who can't afford to pay a debt to resolve it in other ways.
So that would be a priority.
Absolutely, but not everyone due to age. It might be about disability. There's a range of reasons why people can't fulfil a work and development order, and I think how we think about the person's circumstances in each case and how that then applies to what choices we've got is something that we should think about. Can it be better? Can it be done in a better way and give...
Well, this has been in place for nearly 2 years now.
Yes.
And we've had not much variation. Why haven't you done anything in the last 2 years? This is purely a matter... These eligibility criteria are not the Minister's to set, they're for you to set. So if for the last 2 years,
Mr. Smythe just whispered into my ear an important fact. They are ministerial guidelines that do need to be signed off by the Minister. So it needs to be done with support by the Minister, who has a keen interest in it. Why has it not changed in 2 years? Well, I think sometimes these things you need to see how they work.
Bed them down for a period of time and see how.
You do. But I take that feedback. We could have. No. You could always act quicker on things, but
well,
I think
the working group is always, their fines working group is always full of suggestions in respect of certainly hardship cases.
Yes.
That they would be saying that your office should be taking a more lenient view, and you haven't seen fit to vary the guidelines or make recommendations in relation to varying the guidelines in the last 2 years.
Not as yet, no.
Yeah. It's up to you. Okay.
Are you done, Mr. Judah Hope? Mr. Ruff?
Thank you. Yep.
You're done. Ms. Fairman.
Thank you, Chair. I wanted to turn to a different issue, but again, I think with you, Mr. Day, in relation to the specific exploration licence, which was granted ultimately to Peabody, and it's exploration licence 9399. It's the big one that's over, well, a lot of them are big, 1,668 hectares of agricultural land, the one that's kind of around Walla Village. You're aware of the one I'm talking about?
No, I'm not actually, no.
So, okay, so this is a big licence that, as I said, almost 1,670 hectares agricultural land, basically in the Mudgee region. I've just got a couple of questions around the process in terms of the level of transparency for these exploration licences in terms of the role of the regulator. I understand that you're responsible, obviously, for the regulation of exploration activities, which includes things like conducting probity and compliance checks on applicants, but as well as conducting site inspections and investigations and things like that. Is that throughout the exploration, the period that the company owns the exploration licence?
So we'll do a range of activities. So I guess starting with activity approvals, the actual application itself, and apply conditions onto that, and then from that, we, like as part of that application process, we would consider their review of environmental factors, publish our own on the website if it meets that criteria under Section 5A of the Planning and Assessment Act. In terms of compliance activities post that, we do a range of activities, predominantly focusing on audit arrangements, and also we can do other investigations if we receive complaints as well.
So I understand that the proponent here, the leaseholder, has an extensive drilling program in terms of exploration drilling. They'd normally be required to do a review of environmental factors for that, do you think? Do you believe?
They would have had to have done a review of environmental factors as part of their application for an activity approval, yes.
And so that's the REFs are always public, aren't they?
It depends on if it's they are public in terms of a public interest test, or if they meet certain criteria, more than $5 million, or have other licences under that process as well.
So just explain the public interest test to me. So that you're saying that there can be review of environmental factors for some exploration licences that don't become public because they're minor and there's no interest in making them public.
There's criteria there under the Planning and Assessment Act.
Yes. So this one, 1,668 hectares of agricultural land surrounding Mollar Village in the Mudgee region, granted May 2022, undertaking extensive drilling. I mean, that does sound like it would be in public interest.
My understanding is that the requirement to publish it came into effect in 1 July 2022.
Okay. So what I am being told that is that in fact, if there is a review of environmental factors, that for the exploration program, it's not publicly available if indeed it's been done. So if you're able to check on that for me. I also understand with this exploration licence that there's very little transparency, if any, around the whole exploration licence, which of course the community who are living near and have this exploration licence over in very near them are wanting to find out more about it. There's a work plan. So Schedule 5 of the instrument of grant. Usually a work plan under that. That's usually a public document, is it?
They'll submit their review of environmental factors. We have to do our own review against that. And then we make the determination whether it meets those requirements. That basically informs any conditions going forward that they'll need to comply with. In terms of transparency around compliance activities, we publish any audit reports that we do on exploration.
So you might need to look into this one for me if you don't know about it now, because it certainly sounds like this is an exploration licence, an activity that would require a review of environmental factors and then trigger the process that you're talking about, the review and then a work plan under.
A review of environmental factors is a compulsory part of that process.
Yes.
So it comes in as part of the application. I thought what you were talking about was the actual publishing of that documentation.
Okay, yes. So
two things.
Yes, so there's definitely a review of environmental factors.
Yes.
You're saying that possibly they haven't published it.
That's right. It would have had to have had a review of environmental factors. Yes.
Okay, so even if the isn't public, what about the work plan under the Schedule 5 of the instrument of grant?
In terms of what they're applying for?
What the public sees in terms of transparency around the whole exploration licence. We could take a step back and say for something like that, say, because I've been told that the review of environmental factors isn't public, what is public then? When that's not public, is the work plan public? Is there any other way for the community to see what the conditions are, for their activity?
It's public only if it meets certain criteria under that Section 5A. And so we determined that at the point of that. As I said before, that came into effect in July 2022.
So are you aware, right.
And the work plan is reviewed by a GA survey in regards to the actual exploration program itself. So a different part of MEG actually review the work plan itself.
This is all kind of come about after the process of what was when Walla, this is under the John Barilara's coal strategy developed in April 2021, still warmly embraced by this Labor government, strangely enough, that Walla was opened up for in terms of a competitive process, right, in terms of exploration licences. The only company interested ultimately was Peabody. Right, so as part of that process, there was then the Walla initial suitability assessment. Yeah, you're aware of that, that identified
that was all
issues?
Before my time.
Right.
And different parts of MEG, yes.
Those questions would probably be better directed to me rather than Mr. Day.
Okay, so the issues in that suitability assessment, there was quite a few different environmental issues and water issues and other things that needed to be taken into consideration with that exploration licence. Just going back to, it kind of, you look at this and you think, well, there certainly should be a public review of environmental factors actually considering what was identified in this suitability assessment. For example, that it said that the Walla initial suitability assessment identified quite a few issues that would need to be addressed in any exploration or mining, including the need to avoid, minimise and offset any impacts on endangered ecological communities, threatened species, including regent honeyeater habitat, in accordance obviously with the biodiversity offset scheme. There was the heritage and biodiversity conservations of the Goulburn River National Park, managing potential impacts to surface water quality, things like having open and transparent communication with the Walla community. I understand quite a few people in the little township of Walla have of course been displaced, but there are still people living around Walla that are very concerned about this activity, avoiding impacts on significant environmental heritage, and we go on and on. But there's been zero transparency around Peabody's current exploration program regarding any of these issues. My question is to the department today, why is there zero transparency around Peabody's exploration activities when all of this was identified early on in the piece under the former government?
So every title holder has requirements under its title to comply with the various conditions, and as Mr. Day has outlined, the resources regulator has various activities to ensure that compliance. The specifics of this particular title, the Peabody title around the Walla area, and I recall a couple of years ago when that was issued, we'll need to take that on notice and we can come back to you with the details around that. I'm just not familiar with the specific details of the transparency.
Well, I can tell you there's zero transparency. The community can't see the review of environmental factors. They can't see anything underpinning it, the work plan, anything. So, you know, there was these kind of strict conditions, if you like, saying that this area is suitable, but as long as all of these values are protected, and then there is absolutely nothing that anybody can look at from the community to ensure that those values are being protected. And I hate to say it, but we know that when the community actually is able to look at a lot of these activities, that's when, you know, sometimes not so great activities by mining companies are exposed. It's not surprising, is it, that the community is concerned at the lack of transparency. Like, why wouldn't there be? This sounds like a big exploration licence. It's a big company. It's a big area, and it's sensitive area. Would there be a reason it wouldn't be?
I understand your concerns. I'm just not familiar with that particular work program. We'll need to take it on notice, and we can come back to you with some details around what activity is occurring there under the title, what transparency is required, and whether they're complying or not.
Okay. As part of that, I just wondered if you could also just have a look at, so with the Walla initial suitability assessment, one of the, where it says quite a few areas, issues would need to be addressed in any exploration and mining, including the need to have open and transparent communication with the Walla community. Do you have any further information on that in terms of what is open and transparent communication? Are there guidelines to ensure that the mining companies, when that needs to be addressed, they do what's required to make sure that they are communicating? It does seem quite extraordinary. I hear you've taken on notice. I've just given you a little bit more to take on notice, and that's it from me.
And I might just add, there are requirements to engage with the community. So there is a code of practice for exploration, and we certainly expect that title holders, when they're exploring, they are communicating with landholders and with the community around their activities. But again, I will need to take on notice the specifics of that particular title.
If you could take it on notice, and then be assured that if it does come back with what seems like an extraordinary lack of transparency, the Minister's not here in terms of policy, but I will be taking it up with the Minister in terms of why it's happened that Peabody has gotten away with this exploration licence with such appalling transparency. Hopefully the community's wrong and it's buried in the website somewhere, but I doubt it, given the experience of the people who are looking at this.
There is a requirement around a community consultation code as well, around where the company would have consulted with the community, and some of those conditions would be available online in DIGS as well, which is another online forum administered by MEG around exploration sites.
Okay, I'll get you to still take what you
Yes,
said you've taken on
definitely,
notice, despite what you've just said, Mr. Dave. That's okay, in terms of more detail.
And
Thank you.
community members are always welcome to contact the resources regulator as well, and where there's a complaint, we can investigate.
Thank you, Ms. Beattie.
They may well have done that.
Thank you. You're done.
Done. Thank you.
Okay, thank you. And Ms. Beattie, you had an answer to a part of a question, or a question that was taken on notice.
Yes, thank you, Chair. I just wanted to follow up, Mr. Rath, with a question you asked about vacancies on the expert panels.
Yep.
So the regulation requires panels to have between 5 and 10 members. I think I mentioned that earlier. But we're not required to have the full 10 members on each panel. So in terms of each of the areas, in the Central West, there are currently 5 members, which would mean that there are 5 potentially vacant positions. In the Hunter, there are 7 current members. The Illawarra, there are 8 members. And in the Northwest, there are 5 members.
Thank you.
And Chair, while we're on a roll with that, I might just also, there was a question I took from Ms Fairman before lunch around water management discharge from Russell Vale. So Russell Vale operates under an EPL from the EPA, so they have, let's say, a remit for discharges. But obviously the water management going forward will be an integral part of the rehabilitation management plan as part of that process as well. That connects in with each other, both agencies.
Thank you.
Thank you very much, Mr. Day. Well, that concludes this hearing for the inquiry into the expenditure in this particular portfolio. So thank you very much to all the officials for coming to this hearing and all the other ones. We very much appreciate your evidence. The Secretariat will be in contact in due course regarding any questions that were taken on notice. So thank you all very much. We'll see you next time, and thank you, committee.
Thank you very much.
Thank you.
Thank you.
Now do we